Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Boring buzz lights up the air, faces tense as stories tear, truth and lies like a tango dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes stand, shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello, good morning, everybody. Hi. Hello. I am in. Oh, why am I so small in the screen at the moment? That is not good. You guys need to see me. No, I'm joking. No one needs to see that. Hello. Good morning. It's Thursday. Good morning, Lois. Hello, hello. Hi, Zizzy. Hi, Lo. Welcome in. I hope you guys are okay and you've recovered from the spiciness of the Lori Vallow case yesterday. So, today's gonna be a long, interesting day. I am ready for it. So we're gonna start doing the Linda Stermer case. We are gonna do the afternoon session of that case of yesterday, and then catch up of the morning of today, which is gonna start soon. But we'll do exactly the same way we did yesterday, because we already know how things work. Just a bit of a not spoiler. I'm not spoiling the case or anything, but I am just gonna say, if I'm talking and if you hear garden bot in the background, or for example hear other voices, that's my cousins. They are over and having a good time with garden bot, but shouldn't have any interference. But it's just in the case, but you guys are okay with that anyway. But oh, and also I've had an energy drink today, so well, it's going to be an awesome, interesting day. So let's get court started, because we have a lot to catch up, and we are going to listen to, carry on listening to the fire expert that we had on the stand. I need to find his name on my notebook, because I have already forgotten his name. Where is it? Where have I? Okay. Robert James Trunkle, that's his name. I'll write on chat in a second. But yeah, without further ado, yeah, let's carry on and crack and watch.
And sir, you're reminded you're still under oath.
Yes, Your
Thank
Honor.
you. And Mr. Blair, continued cross.
Thank you. Mr. Trinkle, I want to talk to you about formulating a hypothesis, if I can.
Okay,
There is some common sense that's used in this, correct?
I would hope so.
Because, I mean, hypothetically speaking, and this is very hypothetical, an alien spacecraft could shoot a laser beam into a house. That could be a hypothesis, correct?
It would be wrong, but it would be a hypothesis.
Fair, and that's what I'm trying to get at. There are some hypotheses that are just automatically discounted because they're very illogical, correct?
Yes,
And not likely to have happened, correct?
correct.
So when we're talking about considering hypothesis, we're talking about what the investigator may consider to be a logical hypothesis, correct?
Correct.
Based on maybe the circumstances that they observed, correct?
Yes.
And is it fair to say that one investigator might look at the work of another investigator and maybe come up with different hypotheses? Is that correct?
That's correct. One of them would be wrong, if not both.
Well, and that's what I'm getting at is this is your work in this line of work, this fire investigator, it's subject to interpretation, correct?
To a point.
And so therefore, you may reach one conclusion on something and somebody else might reach a completely different conclusion, correct?
And as I said, if that's the case in something like this, either one is wrong or both are wrong.
And obviously, you're not reaching any conclusion here today, correct?
My conclusions are that I, with the information I have, cannot make a conclusion other than undetermined.
Fair. You were asked questions about the red gas can, correct?
Yes,
And you at one time were a government investigator working for the city of Detroit, correct?
I was.
And you were trained to collect evidence, right?
Yes,
And if you had gone to a fire scene and seen a gas can out in the front yard, you would have collected it too, wouldn't you?
I believe I would have, yes.
So you take no fault in the fact that Mr. Leroy collected that gas can, do you?
No,
Because that's data, correct? Or possible data?
possible, and that's why you do it. You know, then you do the analysis and all the other things, but yes, you collect it.
And you were asked questions about there being an ignition source in the living room. Do you recall those questions?
Yes,
And there, in fact, was an ignition source in the living room, was there not?
yes,
It was the fireplace, correct?
yes,
Because we know there was a fire going in the fireplace, correct?
yes,
And those are based on the statements of Ms. Stermer, correct?
yes.
Were you aware that we heard testimony about the boat that was used to move Mr. Stermer yesterday?
Heard testimony, I've heard different bits of testimony, I'm not sure what you're referring to, however.
Fair. Did you hear the testimony of Trevor Stermer?
Stermer, I didn't know, I was in the conference room, I wasn't allowed to be in here for that.
Would it surprise you to learn that it was a 6-foot plastic boat?
No,
Would it surprise you to learn that it never had a gasoline engine on it?
never had what, sir?
Foundation.
I think it's an appropriate question of impeachment, Your Honor. He's been talking about it, and we learned testimony yesterday that there was no gasoline engine on
The
it.
objection foundation is misrepresenting testimony driven with their notes.
I'm not sure he is, so I will overrule the objection.
Your question again was?
Sure, would it surprise you to learn that there was never a gasoline engine on that boat?
I would have no way of knowing either way whether there wasn't or if there was.
And you've been doing fire investigations for about 52 years, is that right?
Let's see, 71, 29, 49, yes.
Yeah? All right. All right. And when you reach a conclusion in a fire case, okay, or a cause and origin determination, you're not making a legal conclusion, correct?
I know you've talked about legal and a couple other things. It would be my conclusion based on all the facts and evidence, and I would turn it over to a prosecutor or something, yes.
Very good. That's your opinion, correct?
If I say it, it's more than opinion. It's based on more than just opinion. Opinions anybody can have, and they're worthless sometimes. But no, if I say the fire is an arson, that fire is an arson. There is no opinion about it. It's the facts that are in evidence that prove that.
But someone could disagree with you on your conclusion, correct?
And one of us would be wrong.
Could be
In
you.
this case, it wouldn't be me.
Well, it could be you, though, correct?
No, because I have the evidence to substantiate my position.
Well, I'm not asking about this case, and we were talking
No, I'm not
generality.
talking about this case either.
Okay, all right.
I thought we were talking about generality.
Sorry.
Yes,
Okay,
if you
thank
wouldn't
you.
mind not cutting the witness off.
So you're saying your conclusions are always right?
No, I make a lot of mistakes. The main mistake I make is that when I have 95% that I think it's an arson, and I don't have that other 5%, I'm wrong because I call it undetermined, but that's the only proper thing to do.
You've been involved in criminal prosecutions before?
Many.
You've been involved in other fire criminal cases, even not with the prosecution, correct?
Yes.
And there's been situations where you've determined a fire to be undetermined, but that did not stop a prosecution for arson, did it?
There was no case I've ever, oh, I'm sorry.
The objection is foundation.
Foundation, no. You go ahead and wait.
Yeah, I'll overrule that.
Okay. I've never been involved in a case where I said a fire was undetermined and it went to a court hearing, particularly in a criminal case. No.
You were retained as an expert in the People versus Clint Dunning, correct, sir?
I was.
And you determined that fire to be undetermined, correct?
I was trying to say more than that, but as the judge knows, I was ruled I couldn't say that, and there was no Daubert hearing or anything. But anyhow, it was an undetermined fire, yes, and I don't believe it was.
And yet, Mr. Dunning was still prosecuted and convicted of an arson-related fire. Isn't that correct, sir?
Objection, Your Honor. He wasn't on the side of the prosecution. He's mixing apples and oranges here.
No, I'm not.
Yes, absolutely.
I'm going to allow the prosecution question, but not the conviction question. I don't see the relevance to what some other jury on another case did to argue.
Well, I guess what I'm trying to get at is that was a response directly to his question of he's never been involved in a case where he was made it undetermined and then the person got prosecuted. Well, I think,
So you can ask about prosecution, but not about what a jury did.
And if he limits it to where he was on the prosecution side, that's different than you're the defendant.
I'll allow you to ask about the prosecution question, but not
fair,
what the
fair.
jury did. That's-
So the bottom line is, Mr. Dunning was still prosecuted, correct?
He was prosecuted without an adequate defense, and he will be tried again, or he will be exonerated sometime in the future.
And that's your opinion, correct?
That would be my opinion.
You're not
I
a lawyer,
can't-
correct, sir?
No, that would be my opinion. I can't say that that's going to happen. I believe it will, that's all. But you're right.
That is your subjective belief, correct?
That would be true.
No further questions.
These last couple questions, sir, that you were asked, you were testifying for the defendant.
Yes,
You've never been involved in a case, you were in law enforcement for a long time, right?
yes,
And you've never been involved in a single case where you were the fire investigator, where you testified or had an opinion that it was undetermined, where there was ever a prosecution. Is that what you're telling us?
that's correct.
Because if there's no intentionally set fire, incendiary fire, there's no crime.
Objection, Your Honor. You can't, that's a legal opinion.
Yeah, that's argument. I'll sustain the objection.
Then you were asked questions about the gas can. You remember that? This
That's a
red
lot of
gas can,
questions,
a lot of questions. And what you would have done, you don't fault Mr. Leroy for taking it, right?
Correct.
The next day, the day after the fire, right?
Yeah, it was a day later, but he said, I think on the stand, he didn't see it the first time, so
Would
you
you
wouldn't
have
take it
done-
if you didn't see it.
Would you have done something more than he did? Would you have done something like check for fingerprints?
Probably not, because on those cans, it's almost impossible ever to get a fingerprint off those cans. They're
Remember
not
the-
smooth.
Remember the questions you were asked about the scientific method, and could different experts look at things, same data, same evidence, and come up with different conclusions? You remember that?
Yes,
The point of the scientific method is that you have reliability and reproducibility, isn't it?
yes,
Okay, so if somebody does a thorough, proper investigation, another expert looks at it, like a peer review, what should be the outcome
that peer review should confirm whatever the first person did.
if it's done properly?
And if you have all the, the information that the first person had, yes.
Like collected the data, the evidence.
Right, if the data isn't collected that you don't determine to be of any value, somebody else can't look at it and see if it was or wasn't of any value.
So under the scientific method, if it's done properly, you should come to the same conclusions. You would only come to a different conclusion if what?
If you didn't have the same data that was preserved, even if two investigators came to the scene at the same time.
I'm just talking about just a situation like this,
Oh,
where
yeah.
you don't get a chance. All you have is what the person did before you.
Yes, I or no one else would have had a chance to have the same information and data that Special Sergeant Leroy would have had.
So if it's done improperly, you might not come to the same conclusion. You come to a different conclusion.
Improperly or inadequately.
Okay.
Back to that word.
That ties in. Let's talk about adequacy. First things you were asked had to do with the definition of an adequate excavation. Remember that?
Yes, yes.
Does adequate mean middle of the road?
No, I think adequate to me, and I didn't look it up in the dictionary, I would have if I had time without a dictionary. I mean, it means enough. Adequate means enough. Whatever that enough may mean, it means it's what you need.
It certainly doesn't mean average.
No,
In your opinion, was there any excavation that Mr. Leroy did that could be deemed adequate by any standard in your field?
well, if Mr. Leroy said he removed all the evidence, I saw the,
Your Honor, I guess I'm going to object. I think he can give his opinion about what he believes, but not the entire field. I don't think he can speak for every cause and origin expert on the face of the earth.
You
He's-
can limit the question.
I'll limit the question. You're certified by AIAA,
yes,
the NAIA.
yes,
You've taught for years.
Yes.
You trained for years.
yes.
Is there any, in your experience, any type of organization that would suggest that what Mr. Leroy did with his excavation was adequate?
Objection, Your Honor. He can't speak for every organization. He can speak for himself.
I'll sustain the
Okay?
objection.
In your opinion, sir, did Mr. Leroy do anything close to an adequate investigation?
Anything close is very vague. I would say that NFPA 921, there's a photograph and some things you need to do, particularly in a fatal fire, about sifting debris. There was a grid search in the I don't know, I got it marked, but ultimately, I think we talk about, it depends, you know.
But let me ask you this, sir. He testified he cleared the floor, 18 by 18. You remember that?
Yes,
Did you see any evidence that he did that?
I saw a space of maybe, I can't really tell you dimensions, 4 by 6 toward the fireplace that was cleared, and I saw other debris outside. But going back to my Laird's talk, because we have collapse of roof and flooring and everything, you'd have to get down to the floor, but he said he did it to the floor.
Did you see evidence that he cleared an 18-foot by 18-foot by 2-foot area of rubble, sir?
I did not.
Did you see any evidence of a 7-foot pile of rubble, 4 feet by 8 feet by 7 feet, that he said he did?
The cubic foot thing, how much we had for 18 by 18 by 2 or 3, if it comes to that, 7-foot pile, no, I didn't see anything like that.
Now, you were asked a lot of questions about area of origin and the size of origin. NFPA 921 guides us on that, doesn't it?
Yes,
Ideally, you'd like to find a point of origin, am I right?
that's the goal.
And what happens as you get larger and larger and larger areas of origin? What happens to the reliability of your opinions?
The larger it is, and you can't confine it to something smaller, how can you actually say what occurred if you have that big of an area of origin? to say this is what the origin was and this was the cause.
I want to go back to Mr. Shinsky's photograph when you talked about, let's see if we can get this now. Mr. Shinsky's, oh, that's what it is. Photograph regarding the back of the house. Thank you, Ms. Heidi. I think that's it. Okay. Getting back to Mr. Shinsky's photograph of the house, you were given a lot of questions about the chimney chase, remember?
Yes.
Based on your review of the records, the drawings, everything, how high was that chimney chase?
It would have to be higher than the peak of what was covering that, those 2, 4, 6, 8 bay windows.
Okay. And these bay windows in the back of the house, what can you tell us about what would have happened to them if there was a fire in the living room?
If the fire was in the living room and originated in the living room, the fire takes the path of least resistance. It doesn't seek or look for or anything like that. It's an inanimate object, but it will take the path of least resistance. And with that in mind, those windows are going to be compromised and the flames are going to come out where that oxygen is coming in. And if it started there, all of that should be burned away. That shouldn't be standing there anymore.
Because fire goes up?
Yes.
And also, if we're talking about, you said there was OSB board, the testimony has been a lot of wood, open wood in the house, and around the chimney chase, OSB board.
Yes.
If that is up there and we're talking about 2 stories, how is it going to fall into the living room?
Well, again, where it actually started, which none of us know, where that fault, if that's what the cause was. We don't know the level of that height where it was, but if it was still in the confines of the cathedral ceiling, it would fall inside the living room. If it was above that, it's going to fail and fall on the roof, basically, and cause a fire up there.
And you're not here to tell this jury definitively, based on everything you could find, that the chimney chase is the area of origin, are you?
Correct. No, I'm not saying that's what happened. I'm saying that was a very strong possibility, but I could not say it was.
And it's a strong possibility that has to be ruled out by the fire investigator?
Yes.
And did he?
No. Well, he ruled it out, but he didn't have evidence to rule it out.
Okay.
Okay.
All right. So, under the scientific method, what you folks always use, you have to rule out these alternate probabilities, possibilities, right?
Right. You have to be able to disprove everything else except your final hypotheses.
Right. Now, let me ask you about possibilities. Since Mr. Blair asked you about, is it possible somebody could pour gas on somebody in the living room and then run down the stairs? You remember that?
I do.
Experts, do you deal in possibilities?
No, that's so much of guesswork that it doesn't apply to anything as far as science goes.
You deal in evidence and probabilities?
Probabilities, yes.
Then you were also asked, well, why didn't you use a human being for those sweatpant tests, or an animal? Remember that?
I do.
And why didn't you use a human being for a sweatpants test, or an animal like a pig or whatever else he said?
There's this anthropologist doctor in California, and I wanted to set up, because she burns bodies and for a variety of reasons, but she's an anthropologist, so she burns them too much. And I wanted her to do an experiment for this. And she would, but she was already tied up to doing all these burns for an anthropologist, like bones. They were down to nothing. So I tried to get a cadaver somewhere else. All those things failed, so I couldn't do that. But the mere fact that I know what's going to happen to a body when you pour gasoline on anything.
Objection, Your Honor, he's testifying because this court's already ruled he
Your
cannot.
Honor, please, there's a legal objection in here somewhere.
It's irrelevant.
There.
It's outside the scope of
I'll
this.
sustain the objection on
Thank you.
relevance.
Why didn't you use a live body like Mr. Blair suggested?
The live body would have gotten hurt or killed.
And it's unethical?
That would be a good reason, yeah.
Oh, you were also asked about some questions about polyester and difference in polyester. First of all, you understand, you do understand polyester is a man-made synthetic
It is,
plastic,
yes.
so it doesn't matter what kind of blend of polyester it is.
Correct.
Polyester melts,
Yes,
and that's what you're trying to illustrate in that video.
yes.
Okay. Give me 1 second, Your Honor. I think I might be finished. You're aware that Mr. Shinsky has a lot of expertise in fire investigation, origin, and cause,
Yes,
as do you.
yes.
Are you aware of any expert in this case, other than Mr. Leroy, who said that what Mr. Leroy did was adequate?
I'm going to object, Your Honor, that's one what you're saying.
I should, if he's aware, I didn't ask for a statement.
I don't understand the question, honestly. What
Are
is
you
it?
aware of any evidence that any expert in this case besides Mr. Leroy defended what Mr. Leroy did?
I'm not aware of any evidence.
What was your answer?
I'm not aware of any evidence to that.
All right, thank you.
Thank you. Mr. Blair?
You would agree with me, sir, that this cause and origin investigation is not a, like, quote-unquote, hard science. Would you agree with me there?
What do you mean by hard?
Well, that's a bad question. Let me rephrase that. Like, for instance, a chemist in a lab or a DNA expert working in a forensics lab that rely on very controlled environments, scientific instruments, et cetera.
Yes.
So you would agree with me that that cause and origin is not a hard science?
There are variables that are uncontrollable, yes.
Because a lot of this relies on your training and experience, correct?
Correct.
And it's your interpretation of fire patterns, is that correct?
Fire patterns are being more and more discounted unless you have them covered with gasoline or some accelerant well, it depends what patterns you're talking about. I misspoke.
That's okay, that's all right. I'm asking in very general sense. It's you looking at something and then evaluating it based on your training and experience, correct?
Correct.
It's not something that you bring out a special instrument and it measures it and it gives you a answer within a reasonable degree of scientific certainty, correct?
No, we don't have that yet.
All right. Would you agree with me that a person that would have the opportunity to go to the scene and view the scene in its original condition would have kind of a better idea of what went on?
I guess I have to use,
Objection foundation and call from the speculator, we're talking about who have a better opportunity, that'd be one thing.
Overrule the objection.
it depends is what I was going to say, and then I will explain it depends. It depends on the level of experience of the one person as opposed to another, and it more depends on the first person preserving the evidence for someone else to see.
You would agree that being able to view something with your eyes in person is better than looking at photographs, correct?
Absolutely, but that can't be done in fire investigations because you're moving debris and changing the aspects of the scene as a way to get to the cause of the fire, and that's why you have to document it.
And just one final question, and just so we have a foundation here, you again reviewed Linda Stermer's statements, correct?
During the course of my 12 years involved in this, yes.
And you reviewed her statement that she stated that the only place she saw fire was between Todd's recliner and the master bedroom, correct?
I guess the word between again means it wasn't on either one of those things, it was between them, but if you want to say the expanse of the fire, yes.
In other words, she observed a trail of fire between the master bedroom and the living room and the recliner, correct?
I believe I answered that a long time ago, saying a trail is a whole different subject and a whole different observance or perception of a fire that is burning in all of those locations. There's nothing to do with the trail.
Nothing further, Your Honor. Thank you. Oh, I'm sorry, Your Honor.
Mueller, briefly.
A few more questions. Person of your experience, person of Mr. Shinsky's experience, even Mr. Leroy's experience, very hard to fool somebody like you into thinking that an intentional fire is an accidental fire, right?
Objection, Your Honor, from the question.
I'll sustain it.
There are obvious signs when I apologize.
It's sustained.
Thank you. There are obvious signs when somebody is trying to intentionally start a fire, right?
Objection, Your Honor. Well, it's very broad answer, calls for speculation.
He's got 50 years.
The way it's phrased, I'll sustain on speculation.
Okay. Can you tell us you mentioned trailers. Explain for the judge what a trailer is.
A trailer-
For the jury.
Yes, observing a trailer. There was more of that years ago than there are now, but people would pour gasoline. I think that Mr. Blair actually said, you know, if you walked in this room and somebody poured a trail and set it on fire, you would very clearly see it visually if the fire flashed and went out. I think I remember Mr. Leroy was asked about a flash fire before too. And it's very obvious to see, and you'll smell the gasoline and you'll see this pattern. But it doesn't conform to the question I was asked and what Ms. Stermer saw.
Okay. A trailer would be obvious as opposed to that there was gas within a boundary.
Well, trailer can also...
I mean, strike that, not gas. A fire within a boundary versus a trailer.
Right, exactly. And a trailer is a whole different meaning by me and all the years and way before 921. it clearly shows whether it was more masks by a flashover or whatever the case may be. The whole room may be involved, but hypothetically and sometimes often, when you go through the debris, you'll find this pattern, which is called a trailer. But the question I've been asking is not anything to do with a trail or a trailer.
There were no evidence of a trailer in this case, was there?
No.
No evidence of multiple points of origin in this case,
No.
which is another sign
Yes.
that might suggest arson?
Yes, if a fire was over here in this corner and a fire over in that corner with no reason for either one of them to happen, and they weren't communicated one to another, it'd be clear to all of us that that was something wrong.
Okay. And then finally, your ability to determine whether somebody did a job properly is based, one, on, you said, their competence and experience,
Yes.
and also, would it be based on their candor and truthfulness in what they did?
Yes, I always liken fire investigation to a chef. You're only as good as your last meal. Wolfgang Puck may have made a million good meals, as Mr. Leroy, but this case wasn't sufficient, wasn't done sufficiently.
I don't have anything else. Thank you.
Obviously, in this case, we can't verify any trailer or anything in the living room because it was completely destroyed, correct?
The floor was, yeah, it was OSB, it went down below. Whatever was below, you might find the remnants of a ignitable liquid, but you wouldn't find the trailer, correct?
Well, there is certain factors that can determine whether or not you're going to find an ignitable liquid, correct?
Yeah, it depends on the degree of damage.
Right, so if the floor was completely destroyed and burned away, that could be a factor, correct?
Well, when you say it was completely burned away, there's residual debris on the floor. Yes, a lot of it was consumed and fell. The condition of how much was left is something I'll never know.
And another factor that could affect gasoline would actually be the amount of water used by a fire department, correct?
Gasoline is not water soluble. I've had cases where, well, I've actually did demonstrations where I could put 1,000 gallons of water on 3 ounces of gasoline on the ground, and the gasoline would stay on top, just like when you have oil slicks or slicks like that with petroleum distillate. They're going to remain there, and the water's going to go past it. It could push it around, but it's not going to change its components.
Well, that's my point. What you just described sounds like a controlled experiment where it was on a standing body of water, correct?
No, I'm saying that I poured the gasoline, and I found gasoline when 500,000 gallons of water had been applied to a fire scene, and still found residue of gasoline that was analyzed in the laboratory. What I'm saying my demonstration is that I poured a minuscule amount of gasoline on the ground, and then didn't direct stream that thing so it would be spread around. It was not lightly put on, it was in a fog spray. It wasn't fog, but it's just wide little pellets like when you're in your shower. And then we let it sit for a while, and we went and still get the gasoline. But I'm saying in the real world, I've done that also. You know, we know sometimes that there had to be something to accelerate a fire based on witness information, based on what we could see physically, and we have come up with a gasoline sample after going through all the debris.
Sometimes you don't, correct?
Sometimes you don't, correct.
And you would agree with me, obviously, that a fire hose is different pressure and different volume of water than that of your hose you use in your experiment, correct?
No, I used fire hose.
Oh, you used a fire hose.
I
I
mean,
think that was
first
okay.
off, I had a fire truck of my own, but that was done, I believe, in Detroit. We did it with a bigger truck. I had a mini pumper.
That was not in a burned out house, correct?
No, but I have had the same experiences in a burned out house. And by the way, I can tell you the pressure if you want to let me. It's usually 200 pounds per square inch is what we fight fires with. It can vary a little bit here and there, but it's a lot of pressure.
Thank you.
Yeah, just finally, whether you can find any remnants of gasoline depends on how good you do your excavation and how thorough it is.
Certainly would be part of it.
Okay. And any evidence you have of evidence samples for gasoline that Mr. Leroy took, there was no evidence of gasoline, right?
We didn't take any sample.
Okay, thank you.
Jury, do you have questions of this witness?
Okay, I see some coming in. Absolutely. Sir, are NFPA guidelines interpreted subjectively or absolutely?
Well, as I said, NFP guidelines total? I'm sorry.
It just says, are NFPA guidelines interpreted subjectively or absolutely?
Depends. Some are absolute and some, are, they can't be used as a standard or a, doctrine of how you do things, but I think they're probably referring to 921, though, don't you think, or not? Does it say?
Yeah, it just says NFPA guidelines. My guess is the 921.
Yeah, so no, 921 is a guide, but it is a guide that is supposed to be a subjective, not a subjective, an objective document that you take, because it talks about don't be subjective in a lot of the areas. I think some we put on the screen. So, but it's not an absolute, it's not something you must do, but if you don't follow it, I can tell you that it won't be good for you in the end.
If you could answer this one with a yes or no, please.
Okay.
Do you have any personal connection with Linda Stermer or her family?
I do not.
Do you conduct all investigations remotely? If not, why?
Almost never remotely. I'm almost always at the scene conducting an investigation like Mr. Leroy does. Not too many other ways of doing it other than if you're going to be trying to assess somebody else's work.
Where was the electrical panel installed in the house?
Basement level along the south wall.
According to NFPA 921 regarding excavation and debris examination, the terms adequate, in quotes, and some, in quotes, were shown. Does the investigator determine what these terms include?
I'm not sure about the word some. I'd have to, see that paper again. But there's a lot of, an investigator is given some latitude about what he feels is necessary. But if you're going to make a definitive cause determination, you have to go above and beyond that adequate level to make sure that your determination is correct.
Okay. Thank you. In Leroy's photo of the rear of the house that you reviewed, more of the exterior is burned away on the north side of the bay window than the south side. If the fire started in the chimney chase, why would you get an asymmetrical burn pattern on the window area?
There's only one picture I think that was shown. I don't know in Mr. Leroy's, I don't think he showed any other ones, but the dash cam from the sheriff's department, first arriving sheriff, you can see that the wind was coming out of the southwest, going across the house to the northeast. That's the explanation. Well, ventilation and fire suppression also.
How common is it for you to be called to review a case done by someone who was an expert in their field?
Common's kind of a common word. I guess if I took percentages of how many fires I do and do somebody else's, do a technical review as opposed to my own, it would be slight.
Having not been to the house yourself right after the fire, did you at any point talk with Mr. Leroy to review any part of his investigation, to ask why or how he came to any conclusions? If not, why not?
Okay, I relied on his report and other information he gathered. Normally speaking, we don't communicate, although we had the federal evidentiary hearing, we may have spoken a little bit, but it really wouldn't have been getting into the meat of the matter of the fire. It would be what he reported and what he testified to and what I testified to.
You stated there are two editions of NFPA 921, one published in 1992 and one in 2024. Are there procedures and codes in the 2024 edition that are not in the 1992 edition?
I wish I'd have brought both of them in. They're in my car. The 921 today is this thick. The 921 in 1992 was 1/5 of the dimension of this book. But I didn't mean to confuse you. These are not the only two. They're published and printed almost every 3 years. The first one in 92, then there was one in 95, 98, 2001, 2005, then 2008, then 2011, 2014, 17, 21, and then this book. Each one of them, became more refined, had more information for us to have a better knowledge base. A lot of the book really doesn't have a direct relationship to what Mr. Leroy and I do, but it's something we should know about and how to proceed from there. More about electrical and mechanical, and they've added more about wildland fires, seaboard vessels, not just a boat, but watercraft, I guess, put it that way.
Okay, so there are some differences?
Yes.
Okay.
Yes.
And which edition are you quoting from today in regards to fire investigation, procedure, and regulations?
Everything is from the 2024 version because it's not a standard. If it was a standard or a code, you would rely on the code or standard of that moment. But this is never, by the volume, it's ever changing or ever more additions and today I need to be testifying to what was in 2024.
Is the 2024 edition of the NFP 921 relevant to analyze information, data collection, and excavation from 2007?
Yes, it expands upon it, and what was done in 2007 might not have all of the different things that need to be done now, but we are now in time frame, and if I may have testified to less than in this book naturally because there wasn't this big book in 2007, but I would be responsible for what happened in the interim, how much more knowledge we have, our knowledge base is greater, so I would have to testify to what we have now, even critiquing my own investigation from 2007.
If you believe the fire may have started in the fireplace chase, then how do you explain how the fire made it to the victim recliner in the manner depicted by defendant?
If the chase is compromised and there was no barrier between the chase and the living room, there could have been a great deal of falling debris coming down on top of him. His hands were burned like this, as though he was stopping himself from whatever was happening.
He can't testify to the position of it.
I'll sustain as to the position of him. We'll move on to the next question. How do you explain the victim burns on body but sweatpants seem unharmed?
Okay, that's a pretty easy one for me. But your body can only take temperatures from 110 degrees Fahrenheit and up. Pants, clothing items, I don't know if any of you have heard of them. There's two movies, one remake, Fahrenheit 451. That is the basic lowest temperature that combustible clothing materials and other materials will actually ignite. So well, I can't get into that. That's the reason. He's not burned. I mean, depends on burned. He's burned because he can only take the 110, and he could only take it for a short time. I would say that because of convected and radiated heat transfer, I'll give you another example. The sun is radiated heat. If we stay too long in the sun, our clothes won't burn, but we will. You know, we're going to feel that heat, especially when it's exposed, but even if it's protected by the clothing. But that was one of the big reasons why there was no way, well, can't get into that.
Okay.
That we can leave it at that. Skin and body burn much quicker or get degraded because of a lower temperature exposure.
Thank you. Counsel, any questions in light of the jury questions and answers, Mr. Blair or Mr. Mueller?
Yes, thank you. I'm going to go backwards because it's freshest in my mind. This idea of skin burning, but the clothes didn't burn. Does NFPA 921 speak to that?
They do, or it does.
Do you have a section on that you can tell us about?
Not sure if I have that section marked anymore. I might have taken it out, but I'll find it.
How about section 24.2.5? And 24.2.5.1. How about we go there?
Okay. Okay, I'm duty glasses. I think.
You want my pair?
I got it. I'm just looking, and a 7 looked like a 5 or something to me. Yeah, it's on the top of the page. Yes.
24.2.5.
24.2.5, yes.
All right, what does that tell us skin burns at? Thermal burns begin.
Wasn't the section I thought it was going to, but let me see. Maybe I need better light.
That section, do we have a section that tells us thermal burns begin at 110 degrees?
We do, but I don't see it here. This is more about kilowatts and...
I might have the wrong section, but you do know that NFPA 921 talks about skin burns?
It's in the book. It should be in this section, I think.
Do you remember what Dr. Markey said the burn, how he described the burns as thermal burns?
Yes.
Okay. And then does NFPA 921 also tell us that heat can be transferred through clothing, causing burns to the underlying skin, without any readily identifiable damage to the clothing?
Yes, well, I've seen that firsthand many times.
And why is that?
Because of the ignition temperature, the temperature of burning for the clothing materials at 450 degree level, as opposed to your skin at 110 and a small amount above.
There's a picture that's up on the screen. I think it was addressing a question about some damage more to the north side of these bay windows, which would be the left,
Yes,
right? And then you mentioned a photograph from the in-car video.
yes,
Does that show the wind blowing toward the north?
yes,
Okay. Would that help account for the fact that you may have more damage to the north side?
absolutely.
And with regard to one, you said NFPA 921 changes about every 3 years.
Yes, it's supposed to be consistent every 3 years. I can tell you that I was on technical committees, and I'm not on now, I get no more time, but hopefully I have a lot more time, didn't mean it that way. Once this goes into print and comes out, the technical committees are already working on anything else that's new and advanced, and then there's the technical committee, like the judge, takes these things and looks at them, and then if they're valid, or I'm going to say any questions are invalid, the questions that really make an impact for a newer section in the book or even a sentence, that will be put in, and then it's voted on by all NFPA members at the end.
Mr. Trinkle, some questions addressed 2007's version and what might have been in effect then versus 2024. We are here in a 2025 trial. You as an expert, and any expert has to be open to change, right?
Absolutely.
So what standard or what guidelines NFPA 921 apply to this trial and this criminal case in 2025?
It would be the 2024 edition.
And just with respect to the various guides, if you're not open to change, what is that evidence of?
Can't be stagnant. You always got to be moving forward and learning every day. I learn something every day. Sometimes it's irrelevant, but like stepping on a Lego coming out of my bed.
Oh, I have a question.
Yes.
There was a question regarding are some of the guidelines absolute or subjective? You remember that?
Yes.
The scientific method has been in effect since 1992 and before.
Yes.
Right? That has to be complied with.
Well, the caveat is it has to be utilized and complied with unless you can absolutely say you did something equivalent and it comes out to the same thing, just trying to get to what caused the fire. But normally speaking, if you said you didn't do this, they wouldn't even allow you to testify in most courts.
Certainly, Mr. Leroy was subject to scientific method in 2007, just as he is today, just as you are.
Yes.
And you have an opinion, you said, as to whether he complied or not with the scientific method, and that was?
No.
Okay. And the excavation principles in NFPA 921 are the same now as they were back way before 2007, right?
Yes.
So the fact that he didn't do what he told the jury he did, that would be in effect, you're held to those same standards.
Yes, you are.
Okay. So many questions. Okay, I don't have any other questions. Thank you, Mr. Trinkle. Let me get him in.
Yes.
I think you've even testified that to this here in court today. You don't agree with all portions of NFPA 921, correct?
Some I get revised, and people like Mr. Leroy and myself would look at them and ask, or put a suggestion in, like the jury, the jury box, to make a change. I've had sometimes where the computer section was new, and the second edition that came out, I think it's 2005 and 2008, one of them said this is, and it was wrong. It was, typo, but a big typo. And so then they put it now is not. But they left them both in.
Well, but I think you've even testified this here in court. You don't agree with some of the information or the way they define things in NFPA 921, correct?
I guess define, you have to explain what definitions you're talking
I
about.
think we talked about you used ignitable liquid.
Oh, yes, I don't like that, yes.
You don't like that,
I
correct?
do not, because I have to explain to a jury that liquid doesn't ignite. It takes me more time to get to the point of fact.
And NFPA 921 is not an absolute, correct?
Correct.
There's no requirement that you follow it, correct?
Requirements.
Legal requirement.
I guess there is no legal requirement.
And I think you testified to this in 2007, there were less requirements or less guidance, I think, in the 2007 edition than there was in the current editions. Of
Yes, the 2007 would be somewhere halfway between these two. Each volume from the 92 version, which was very thin, the 2007 version increased in size and what was covered. And as I say, every year, every edition, I've never seen it get smaller.
So I guess at the time in 2007, a fire investigator would have only had the guidance that the 2007 edition would have been providing, correct?
That guidance from the book, yes.
And would have only had then that guidance when conducting their investigation, writing their reports, so on and so forth, correct?
Right, we don't carry the book with us.
Because you would agree with me that looking back at something from today's standards to 2007, that's kind of reviewing something in hindsight, correct?
Yes, like I said, I would review my own now and probably criticize it in a critique of what I didn't do the times before, but it wouldn't be critical.
But at the time, it may have been completely appropriate.
Completely appropriate. I'd have to know what you're talking about. It
Well,
was
sure.
a particular thing.
Well, you were just talking about looking back and even second guessing yourself or reviewing
Sure.
yourself, right?
Sure.
So, but what I guess what I'm getting at then is if you're looking back and finding things you may have done wrong in, 15 years ago, they didn't make them wrong at the time, correct?
It all depends what you did wrong. If you called a fire something that you couldn't prove and now you find out that you can prove it or disprove it, as you mentioned before, yeah, those are variables I can't really address.
Now, when a fire goes up, it actually hits a roof and spreads out, does it not?
It hits, let's take this room for example. Yes, fire starts on the floor level, continues to burn upward and outward, depending on the configuration of the room, configuration of the fire load, but eventually it hits a barrier like a horizontal surface, then it spreads out.
So, for instance, in the pictures we've looked at then, I think this is based on one of the juror questions, if the fire had gone up, it should have hit the roof and then spread to all areas of the roof in the Stermer residence, correct?
Way beyond what is the questions from the jury.
I think that's right in line with the juror question.
I'll let you ask, but I'll alert both of you. This witness has been on the stand since yesterday, so if you have any great questions, I'd suggest that you ask them now.
I think that's right in line, I'm sorry.
Thank you.
Could you please rephrase? I don't want to
Sure.
say something wrong.
If the fire had gone straight up and hit the roof and then spread out, like you've talked about what they do, it should have spread to all areas of the roof in the Stermer house, correct?
I don't think it's going to hit the roof. It's going to hit the ceiling of the cathedral ceiling, which isn't the roof. It's not right there. You've got probably scissor trusses or something to separate the ceiling of the cathedral ceiling from the roof, and it's going to spread from there first, and it's going to, as I said, heat and smoke, fire, rise, but they rise in a conical shape. It's not like this is three-dimensional stuff. Wherever the fire starts, say where Mr. Leroy is sitting, it's going to go in all directions around him and up until it meets that resistance, but that resistance is part of the house, not the roof.
Just a moment, Your Honor. Questions, Your Honor, thank you.
I think it's a great question.
Yeah, brief, great questions.
You were just asking questions about complying, excavation, documentation. Those were absolutely required in 2007, just as they are now, right?
That's correct.
And that is ingrained in fire experts from the time they start training, right?
Yes.
You remember, you were asked questions about, I'm going to call it, I forgot what Mr. Blair called it, playing devil's advocate with yourself. How could I be wrong?
Yes.
Right? And that's something that every fire investigator should do throughout their investigation.
Yes.
Do you have any evidence that Mr. Leroy played devil's advocate with himself on any part of his
Your Honor, that
report?
calls for speculation.
Sustained,
Do you have
sustained
evidence?
speculation.
Okay. Is there a requirement in 921, back in 2007 and now, to be truthful and candid in your documents and reporting?
I'm going to object, Your Honor. I think I think the scope of these jury
Oh,
questions.
sustained cumulative.
Okay. I don't have any other questions. Thank you.
Thank you.
Jury, any others in light of the questions or dialogue? No? May this witness be excused from subpoena if he's under one, counsel?
Yes, I don't think it's under.
Okay, thank you, sir, you're all done. You want me to take this trash to discard? Yes. Oh, is this the gray the sweatpants that have been admitted?
That's an exhibit.
Oh, okay. What, was that admitted?
And that notebook was admitted.
Okay.
That's my binder.
Was that admitted? No.
No, that's my,
Okay.
I just referred into it.
So, Mr. Mueller, Mr. Kelly, any other witnesses? Any other witnesses? Okay, you may call your next witness. Officer, you can come forward. If you pause briefly. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. And once you're settled in, we'll have you tell us your full name and spell the last, please.
My name is Mariusz Ziejewski, Ziejewski.
Thank you. Mr. Mueller?
Thank you. Sir, can you tell us what you do for a profession?
I'm a university professor at North Dakota State University.
And what is your specialty, or what do you specialize in?
My specialty is impact biomechanics.
What is that?
Well, that's application of physics, engineering principles in the study of forces on human body and effect of those forces on human body.
Okay. Can you give us an idea of the education you have that brings you to court today?
Well, my highest scientific academic degree is PhD, doctorate degree in engineering from North Dakota State University. I graduated in 1985. I have 2 Bachelor of Science degrees and 1 master's degree. All those degrees are from my native country, Poland. One of my Bachelor of Science degrees are in mechanical engineering, and I'm diplomat engineer from Europe. It has equivalent standing to PE, professional engineer's license in this country. My Master of Science is in bioengineering, or equivalent to bioengineering. My other BS degree is in life sciences. Then I became university professor in Poland and worked on my doctorate degree in Poland. And I was invited on a research exchange program between professors from Poland and the United States. And back in 1980, I came to North Dakota State University. I quit my doctorate degree in Poland and started at North Dakota State as a part of my research exchange program, and graduated in 1985. Became for 1 year lecturer, assistant professor, associate professor, tenure associate, full professor, and now I am professor emeritus.
Does that mean you're semi-retired?
Not really. I mean, I could, but no. But really means that it's a title. We can essentially do what we want to do. My choice is to continue work on the research. I have 2 PhD students. I don't teach.
What kind of research do you do, and how would it relate to injury causation that you're here for?
My research is in human brain modeling, mathematical modeling of human brain. In other words, how external forces affect human brain. I've been working on this project for the last 30 years. The primary sponsor for this project, research sponsor, was Department of Defense.
And specifically, who are you working with, types of folks you work with?
Well, it started in early 90s, National Highway Traffic Safety Administration. It is part of our government, civilian government, U.S. Department of Transportation. I worked from 1992 to 1996, 97 on mathematical modeling of human brain. NHTSA, for short, used this program that I developed in the study of real-life car crashes to understand the effect of head strike into the A-pillar. A-pillar is the connection between windshield and side window. 1996, I was invited to join Armstrong Aerospace Medical Research Laboratory. This laboratory is part of the United States Air Force at the Wright-Patterson Air Force Base in Dayton, Ohio. Back then, in 1996, women received all the rights that men had, and the question was how the safety system of ejection seat perform for female. Body dynamics for female is different than for male. In the scope of this work that lasted about 15 years, I was involved in analysis of over 900 full-scale tests with male and female pilots. In 2007, now remember Afghanistan war, a lot of traumatic brain injury cases, and unfortunately many of our soldiers were released to civilian life with a clean bill of health, and actually they had the brain injury. So Congress appropriated over $100 million to the Department of Defense to study that issue. And I was fortunate enough to be invited as a scientific consultant into that endeavor. And part of that work, I had $1 million research grant. I chair a number of different committees that relate to biomechanics of traumatic brain injury.
Okay. You have taught not only in engineering school, but you've taught in medical school. Tell us about that.
That's correct. I am adjunct associate professor at the medical neuroscience department, different university, 70 miles north from Fargo, University of North Dakota. I'm not a physician, so I don't teach medicine, but I teach how injury occur. So I was involved in teaching team-taught courses, and obviously teaching the mechanism of trauma. In addition to it, I was involved in a research project, the School of Medicine, and local emergency room, and the objective was to apply knowledge that we have in automotive field, in military field, to medicine, into emergency room. Completely different fields, and medical students do not know much about what we know in biomechanics. Obviously, we don't diagnose injury. We identify risk factors. We identify likelihood of type of injury. Physicians do what they're supposed to do, diagnose and treat injuries.
Can we kind of, put a bow around your background as injury mechanics, what causes injuries, the forces that are involved in injuries?
Yes, that's what it is.
You've lectured, I'm sure, before,
Yes.
around the world?
Well, yes. No, first of all, at North Dakota State University for 35 years, altogether as a professor for 40 years. But outside lectures, yes, at many different conferences throughout the world.
This is not the first time you've been in court in litigation, right?
That's correct.
Okay. You have been qualified as an expert in injury biomechanics. Give us an idea how many times.
I testified probably at least in 80 trial cases since year 2000.
Around the country?
Yes,
Federal and state courts?
yes.
Okay. Your Honor, at this point, I'd like to move for the admission of Dr. Chesky, I'm going to butcher it, CV, and for his admission as an expert witness in injury mechanics, biomechanics.
No objection, Your Honor. I will receive his testimony as an expert in injury.
You said injury biomechanics?
Thank you. Doctor, can you tell us, in this case, you and I got together a few years back, what was your assignment, if you understood it?
Well, I was asked really two questions. First question I was asked whether or not, from biomechanical perspective, I can assess severity of trauma that this particular individual sustained. And the second question was whether or not we can determine how fast the vehicle, the Ford, was traveling at the time of the contact with the individual.
Now, you weren't talking about burn injuries here. You were talking about I'm going to call them orthopedic injuries.
Right. I talk about blunt injuries. I don't talk about the terminal injuries.
Okay. What did you review to be able to arrive at your opinion, sir?
Well, the most important for me was the medical records, the autopsy records. The medical description of the injuries were the most important. I also had the information about the type of vehicle it was involved. I received photographs of the wounds and photographs of the vehicle with the blood on the carriage.
Okay. You reviewed the autopsy and medical records. I'd like to show you, prepared a PowerPoint. I don't know if you have it, but I'm just going to show you a slide from your PowerPoint. You can tell me if this helps illustrate your testimony.
Okay.
Is that a slide you prepared?
Yes, I did.
And what does it describe?
Well, essentially, it is verbatim statements from the autopsy record. As a biomechanical engineer, I'm historian as far as the injuries are concerned. I accept the injuries as diagnosed by physicians and present in medical records.
Okay. Does that help illustrate some of your testimony regarding Mr. Stermer's trauma injuries, forced trauma injuries?
Yes, my opinions are based on medical records because those are the objective evidence, forensic evidence in this case. So in the majority of my cases, I start with medical records as objective records and formulate opinion.
Okay. Your Honor, at this time I'd move for the admission of Defendant's Exhibit V. Victor.
Is it just a slide?
Just a slide.
Just the slide. I have no objection to just the slide.
Thank you.
What'd you say? V?
Victor.
Victor? V.
I'm going to show fully marked. Is that the slide you were talking about?
Yes,
Okay. Shows Todd Stermer, who at the time was age 42, 5'7", 180.
that's correct.
And load this up a little bit and see if we can describe some of the injuries, and you can explain what these injuries mean to us.
Well, and maybe I can give you numbers, because really that's so small that I know what is on it. I have a hard time to read
All
it,
right,
you know?
just tell us what the injuries are.
If you go to well, those are the injuries, and the first 3 injuries relate to burn. I really don't deal with that, but I include it in the analysis. If you go to number 4, if you go to item number 4.
Give me a second.
Very good. We have 4 lacerations on the skull. So we have evidence of 4 separate contacts to the head.
Then
And the next one, if I can lead that, go to number 5.
okay.
Okay. Minimally depressed marks, defects of the outer table of the skull underlying 2 of the lacerations.
Let's break that down. What is a depressed mark or defect? And then I'll ask you, what is the outer table of the skull? What are we talking about?
Skull is like a sandwich. We have a dense layer at the top and dense layer at the bottom, and we have this porous layer in the middle. This description indicates that only top portion of the dense layer of the skull was, as was described, depressed. Normally, if you have a linear fracture, you have a linear fracture all the way through the skull. It didn't happen. It just simply top portion was compressed. Now, it is important that that type of description relates to 2 lacerations. So already we are connecting the 2 lacerations to one event that is quite similar in nature. I mean, the chances are that you might have a very similar outcome from completely 2 independent blows. It can happen, but clearly this will be more consistent with head contacting something that is on one side and another side. There's a rigid object in one motion, head motion, with respect to the rigid structure, created those laceration and depressed, minimally depressed skull.
In 2 spots.
2 spots.
Okay. What else?
Now, what I would like you to do, maybe skip to go to number 7.
All right.
Okay, so now we have a depression of outer area of the left parietal bone of the skull.
What's the parietal bone?
Side bone. If you look at the midline to the temporal area, this is parietal bone. So we have depressed area in that location. It's on the left. Now, if you go to number 10, now you have a depressed mark on the outer table of right parietal bone underlying laceration. So what is important that we have in both areas, left and right, we have a outer area of the bone. So now we know that the 2 areas that the records refer to are on the side of the head. The size is somewhat different. The one on the right is about 1/2 inch, the one on the left 1/4. That's not that critically important. Important thing is that the nature of the damage is the same left and right. So both of those happen from one particular event.
Okay. What else do we have?
Now I would like you to go to item number 8. Okay, V-shaped laceration in a midline posterior frontal/anterior parietal skull over the vortex of the skull. A lot of words, but midline is midline of the head. Posterior is the back. Well, the word frontal tells you is front, /anterior, because anterior really means front. Parietal skull over the vortex of skull. So there's some laceration close to the vortex area. Remember, we have 4 lacerations. We explained 2, now we are dealing with the 3rd one on the vortex.
Where are these words coming from?
Directly from, by the way, notice that after each sentence, I have a parenthesis, document 1:17. That's document 1 in my list of material studies, that's the autopsy record. And :17, that's page 17. In addition to it, I attach the date for this diagnosis, 187.
Date of the autopsy.
That's correct.
Okay. Where are we going next?
And the last one really would be number 11. And again, talks about this 2.5-inch gaping linear laceration on posterior back, midline region of paradial occipital skull. Now, occipital skull is the backbone of the head. So now we have evidence of contact that extends from the vortex to the back. And those are 2 separate lacerations as identified, and we have 2 on the side, we have 4 lacerations.
Okay. Anything else we need to see there?
No, those are the most important aspect to us because lacerations are AIS level 1. AIS stands for Abbreviated Injury Scale. It's a trauma scale that we use in civilian and military organization to link diagnoses to engineering parameters. Now we want to medical field and engineering field to communicate. And AIS scale allows us to do that. Based on AIS scale, we can use the evidence of the injury, and we have an engineering component attached to different level of AIS scale. Essentially, AIS scale is fatality scale. AIS level 1, 0 fatality. So all the lacerations that you see, the likelihood of fatality from it is 0. The next level, AIS level 1, is linear skull fracture. We don't even have linear fracture.
What is a linear fracture?
Well, linear fracture versus depressed fracture. Linear fracture, the skull gets hit and fracture. You have a line, fracture line for the skull. Depressed fracture, when you have additional energy that causes comminuted or complex fracture of the skull. Here we don't even have linear fracture because it doesn't go all the way through the skull. But still, I would assign AIS level 2 score according to the scale because there is portion of the skull that is fractured. And probability of fatality is very low. The survival rate is 99.2%. So 99.2% likelihood of survival from this kind of injury.
And tell us, were there any brain injuries involved here?
There's no indication of the brain injury. In other words, the bone heals, and they very often, there's no residual effects. The problem is that we have a soft tissue that might not heal. So in terms of the brain head injury, we are very much interested in what happened to the brain. There's no bleeding in the brain. There's no contusions or bruising. Contusions is bruising that happens if you get hit in the head and brain strikes the internal surface of the skull, it might bruise. Bleeding can occur. No laceration. So there's nothing in the brain tissue that was identified as evidence of trauma.
And the AIS-2 level would be considered what? How would you describe that level?
It's called moderate. You don't have evidence of internal brain trauma, and level of survival is 99.2%.
And in this particular case, you had pictures of the undercarriage of the van, and it tested positive for Todd Stermer's blood. Do you have an opinion, doctor, whether all the injuries that he suffered, all these traumatic injuries, other than the rib fractures, dealt with contact from the van?
Yes, everything is consistent.
I think you can say those injuries are consistent or not, but we're outside of the scope here, what he could testify to.
Oh, I'd ask if it's consistent with. I think that's appropriate.
Are they consistent with a single event?
They're consistent with single event, the interaction between his head and the pickup going in opposite direction.
Okay. Do you have a slide or a photograph that depicts the injuries to the skull and then also the components of the undercarriage?
Yes, I do.
Your Honor, just to advise, there's just me one picture of the skull from the autopsy, showing some lacerations. And counsel has that.
Yeah, as long as it's just the one slide of the report, yeah. That was right above the one we've already admitted.
I believe that's Exhibit
Figure 1.
Q. Okay, move for the admission of Exhibit Q.
And you? Yep, we have a
Go.
queue. That was this morning.
Figure 1. Oh, you, I'm sorry, you. Sorry, thank you, Ms. Heidi.
And jury, it sounds like there might be a little graphic here, but bear with us, we'll get it on and off the screen.
Thank you.
Mr. Mueller?
Doctor, can you show us,
Yes, I'm admitting you.
good. Can you show us what you're talking about in terms of injuries and tying it into the injuries of the skull?
Can we focus on the top left corner of this composite? And then prepare this composite, right? So we are looking at the top of the head, the nose is up to the ceiling. And at first, let's look at the two lacerations from the side. Those are the two lacerations that we discussed initially.
This
Then
one
we
here?
have the big laceration, and there are some small fractures, outer layer of the skull. And then we have a laceration on the midline, in the vortex. That's the laceration. And if you look at the laceration to the vortex, the force applied was obviously into the head and backwards. So the vehicle was going backwards, so his head was moving forward to end up with this kind of
Relatively.
injury. Relatively.
You understood that all the blood was on the front surface of the undercarriage components.
That's what I understand.
So what does that tell us in terms of any of these other pictures that you're talking about on this?
Well, what it really is telling us that from biomechanical perspective, I see one event, his individual with the head orientation into the front bumper of the pickup, and the pickup going over his head, and those injuries took place.
Okay. Getting back to that first opinion about a single event, is your opinion, having read Dr. Markey's testimony and his autopsy, is your opinion consistent with his that none of these injuries were fatal?
That's correct. I am.
Then let's talk about what type of impact. When we talk about forces, we're talking about loads, right?
Yes.
Loads in your business.
Yes.
All right. Tell us, do you have an opinion, given all the material you've reviewed, whether or not these injuries are consistent with the low-speed impact of the vehicle?
It is. Actually, cadaver studies show that head striking a rigid surface at 5 miles an hour, it's like 7 feet per second, it's like slow jogging speed, is sufficient to cause linear fracture. And the forces that were measured was 1,500 pounds, 5 miles an hour impact against a rigid surface.
So what does that mean in terms of, are we talking about low speed, high load?
Yes, I mean, low speed, 5 miles an hour is not the high speed. And if the impact happened, I guess not the right way, the wrong way, skull fracture can occur at that velocity.
But here it didn't.
It did happen. We have some minor fractures, which I would not, again, classify as linear fracture, somewhat less than linear fracture. So less than 5 miles an hour.
Do you have an opinion based on your review of the photographs, the medical records, the injuries, in terms of the relative height of Todd Stermer's body as to the vehicle on impact?
Well, the only thing I can talk to you about is where the head was. So the head to be somewhere at the height of the bumper or somewhere below, because they had to go under the carriage.
Finally, there's been some talk about the possibility of a frying pan being involved in this impact, in an impact. First of all, as a medical expert, do you deal in possibilities?
No, I don't. That's speculation.
In terms of your review of this case, do you have an opinion as to whether there's any evidence that suggests that a frying pan could have been involved in this trauma?
I don't see any evidence, because all the evidence that we have aligns very nicely in the sequence that I described to you. So more likely than not basis, there was only one event the interaction of his head with the undercarriage of the vehicle.
And can you describe any significance to, I think you said some symmetry between the lacerations?
It is. From very beginning, I mentioned to you the side fracture, position very symmetrical, pretty much the same extent of the fracture, meaning the same loads. So something there under the pickup, how it's designed, that there were two edges of sword that came in contact with his head in those two locations. And then there was less severe, there was the contact with the midline from the vertex to the back of the head.
Okay. Your Honor, just give me 1 second. Doctor, thank you for coming here from Fargo. No more questions at this time, Your Honor.
Ms. Seiderbean, any cross?
Yes, thank you, Your Honor. Good afternoon, Doctor.
Good afternoon.
So I just want to be clear, you study the force that an injury, what force it takes to cause an injury on a skull,
That's correct.
in lay people's terms.
That's very well described.
Okay. You're not a doctor of medicine.
Right, I'm a doctor of medicine.
You're not a forensic pathologist.
That's correct.
And you're not here to opine about injury patterns or that sort of thing on a body at autopsy.
No, actually, injury pattern is part of biomechanical evaluation because we are talking about the forces. And we are very much interested in the pattern because lack of pattern creates additional body kinematics, additional body motion. We are interested in that. So symmetrical pattern obviously tells us not much rotation either way, just uniform body position. So pattern is actually part of the geometry, part of physics. Not the physicians do not understand what pattern is. We all understand.
So I'm going to
But-
stop you there. You're talking about patterns of maybe where lacerations are?
Correct.
So you're not looking at like a pattern, like if somebody were to be hit with something with dots on it, that it would cause a pattern on their skin.
No,
You're not talking about that, right?
No, I do, or we do, because the type of imprint, you have a silly part, you put the finger, and somebody will ask us what caused this imprint. It's important that we will be able to figure out it was a human finger that left the imprint. So, no, we are very much interested in the geometry of trauma.
Okay.
We are.
But looking at this, we're just looking at lacerations and where they're located on the skull.
Lacerations, nature of lacerations, location of lacerations. More than that, the type of evidence of the skull fracture. Both sides we have just the top layer of the skull. What the chances are that random two forces come, striking the head, and only top layer of the skull is fractured. Not all the way through, or not at all. Well, the situation is very simple. It's some kind of symmetrical orientation, and will give you the same amount of force and approximately the same amount of depressed fracture. There are some small differences. One is a quarter inch, another is half an inch. Minor difference.
So when you're talking about the depressions, you're talking about depressions into the bone.
Yes.
And it could certainly be possible for there to be depressions in the skull created by different impacts.
Theoretically, yes, anything can cause, if it is forceful enough, to cause depression in the skull, sure.
So each one of those could have possibly been caused by a different blow or a different trauma.
I don't deal with the possibility on more likely than not basis, no. Everything is so symmetrical. I cannot envision two separate blows and give you pretty much the same type of laceration and top of the skull fracture. That's so unusual. Typically you have no skull fracture or fracture all the way through. So somewhere in the process, the force ended.
So doctor, I just want to stop you there. You have the two that you're saying are symmetrical, but you also have one on the top and one on the back, correct?
There's no fracture, there are just lacerations.
And indentations?
Indentation, yes.
Okay. And so all of those are then what we would classify as blunt force trauma?
Yes.
Okay. And I was taking a look at your report, and I think you testified as to what you reviewed. And it included the autopsy report, the car specifications, the trial testimony of Dr. Markey, and the photographs. Are those the photographs of the autopsy?
Yes, and you saw also some photographs of the undercarriage of the vehicle.
Okay. So you didn't review any of the testimony that any of the witnesses have provided?
No.
Okay. And a blunt force trauma to the head, if somebody were to hit a skull, a human skull, with an object, would you expect to see the same sort of indentation or laceration?
Sure, you can hit the skull any place, and you can get a laceration, an indentation, a skull fracture. Sure, it can happen.
And so basically what you're looking at is the amount of force that it would take to cause these lacerations, and you're concluding that they're not fatal.
Correct.
You're not here to talk about any of his other injuries.
No, just based on the skull and lack of brain injury. If there will be any bleeding, contusion, and laceration, you will hear me talking about that. And that injury will have a higher AIS score than skull.
So you are aware, after reviewing the photos, or are you aware that there were actually several different spots where there was blood underneath the van?
Yes,
More than 4?
yes,
And are you aware there were multiple injuries that were seen not just on the head, but also on the body?
yes. If you look at the medical records, I list at least some of them: arms, thoracic, rib fractures, and so on. Extremities, yes, but those are of minor significance in terms of the fatality.
In terms of the fatality. But we can agree that there's definitely more injury than just on the skull.
Yes,
And we can agree that there are multiple points underneath the van.
yes.
And you can't say what part of Todd's body touched what part of the van,
No,
because that would be speculation, right?
no, I would probably, if I will have exemplar van and three-dimensional model of the skull, I bet we could go there and match what portion of the undercarriage create those two imprints. Lacerations, they'll be more difficult, but if you already have a one point identifying the indentation to the side, you're in a good shape to identify where the head was and probably find the location for lacerations. But no, I didn't do that.
Well, and there, we can agree there's more than one laceration. So you'd have to match where the laceration on the back came from, the laceration on the side, the laceration on the arms. You can't do that. That's not what you're here to do today.
I didn't do any other lacerations except the head, but the fracture on the side and laceration goes together. And then you have a impact to the top, and then flexion of the neck, and you have a continuation to the back. Although there was no injury to the neck.
So I'm going to ask you that question again because I don't think you answered it.
Okay.
You're not here to match.
Yes, that's fine.
You're not here to match the injuries that he sustained on his back, his side, his arms to any particular portion. You've only analyzed the head.
That's correct.
And you can't say, sitting here today, if it would have come from a blow prior to being hit with a van, right?
That's correct.
And you can't say what particular blows on his head came from the van.
No, as far as the blows to the head,
Your Honor, it's not responsive. I just needed an answer. Thank you.
Are you moving on, or?
Yeah, I'd like to move on.
Okay.
Thank you. And I just want to be clear, you've reviewed no testimony from any other witnesses, and you've seen no testimony that was provided that somebody claimed that Todd Stermer was hit prior to being hit by the van with a blunt object.
correct. Then have not seen this testimony.
I have no further questions for this witness, Your Honor.
Miller?
Just a few more before I wrap up, Your Honor.
You did account for in your findings other lacerations on his body, right?
Oh, I knew what they were. I identified this in the medical records, and some of them I listed in my summary.
Okay, if I go to number 14, you noted the laceration on the right rear shoulder and upper back,
Correct?
and the upper left arm,
Correct?
and the lateral back and chest. So you noted all those.
Yes, I did.
But they didn't have to do with anything having to do with your analysis of whether or not these injuries were serious enough to have any type of chance of being fatal.
Correct. It's AS, any lacerations, abrasions, AS level 1, 0, likelihood of fatality.
Your ultimate opinion, or one of the opinions you have, though, is given the nature of these lacerations, the symmetry, it's more likely than not that everything happened from a single event, all those head lacerations
Yes, the
And
head
fractures.
lacerations, yes.
and fractures.
And what?
And fractures.
Yes,
And they would have been from the van impact.
definitely.
Thank you. Anything else?
I just want to be clear, you said that the two on the side of the head were symmetrical. Those would have maybe come from one incident. But then I believe your testimony was that the other ones were not then associated to the two on the side.
It might be. I'm just saying that those two very much symmetrical, and then we have a top and extending to the back. I do not match with the exemplar vehicle, so I don't know if the structure, undercarriage structure, that will leave the side depression, also have close a surface consistent with the contact with the top. If it does, everything happened right there. If not, it happens somewhat later.
And that would address 3 out of the 4 lacerations.
No, because this laceration on the top, there's an extension. Everything is in midline of the head, so it's extension to the back. Now we have 4.
I just wanted the slide that was showed a laceration, and I'm just going to show you your slide, showed a laceration on the top of the head. That's the laceration we're talking about here, right? The one on
Yes,
the top.
yes.
And so this photo doesn't show the laceration in the back.
This photo doesn't because the head is laying on something, so it doesn't show the acceptable laceration.
So the laceration on the head goes, for lack of better description, from ear to ear side.
No, go from it's extend, have certain width, and goes from the top to the back.
So what we're looking at in this photo that you put up on the screen, is this the face?
That's a face.
And this shows the injury going across the top of the head this way.
No, there's an impact and tissue burst that way.
Okay.
So if you have a sphere and you hit material, you get a laceration perpendicular to the direction of the force. And some of the tissue you push in the direction of the force. That's exactly what happened.
Okay, and then this does not show the laceration in the back of the head?
No.
Because the body is laying on its back?
Yes, but it's in medical
Okay.
records.
And you can't say where the blood came from on the van, like in the different areas in the photos you looked at?
No, I mean, other areas, the bleeding, it could come from different areas. And remember, blood is splatter. It just goes in different directions. So sometimes it's difficult to pinpoint where exactly, what's the original source of the blood.
Especially if you have lacerations on your head, your arm, your back, and your side. Would you agree?
That's correct.
I have no further questions, Your Honor. Thank you.
To make sure we're clear, in your expert professional opinion, you saw no evidence that's consistent with impact from something like a frying pan, right?
That's correct.
Thank you.
Now,
Yes, Your Honor. I just want to clarify, you testified that you can't say that a blunt force object could not have caused one of the lacerations.
no, I said, in general sense, laceration can be caused by blunt object, period. Now, totality of the evidence, or more likely than not basis, how everything is lining up. The two contacts on the side, and one extended contact from the top back.
But the totality of the circumstances would also take into account testimony that the defendant said she hit him with an object. Would you agree with that?
And it goes way back
One
to,
minute. I'm going to sustain the objection as to foundation.
Did you take into account any of the testimony from the trial?
I was aware of this fact from reading trial testimony of physician, and on more likely than not basis, I don't see any evidence of that. I just see the evidence on the head from contact from undercarriage of the forehead.
But you can't say, from what your prior statement was, you can't say that another blunt force object did not cause one of those lacerations.
On more likely than not basis, everything fits the contact with the undercarriage. That's
Unresponsive,
all.
Your Honor. It's unresponsive.
he's responsive, he's answering the question.
Sir, if you could try to just, I think if you can answer it with a yes or no, if you could do that.
Is it possible
Oh.
that one of the lacerations was caused by a different source of a blunt object?
Possibility is speculation. Is it possible? Yes, you might have an impact and no trauma. Then we won't know that really happened. So
Your Honor, it's unresponsive.
You said it is possible.
it's possible.
Thank you. I have no further questions.
Your Honor, you also said possibilities are speculation, right?
Yes, it is.
And do professional experts engage in speculation?
No.
Why not?
Well, because there's infinite number of possibility pretty much for everything that happens. So we are evaluating things from more likely than not basis. That's why we are evaluating the pattern. Everything fits in one particular motion. More likely than not, this is how it happened.
And one single event being van impact?
Yes.
Thank you.
You can't line up those injuries to the parts of the van.
Objection, asked and answered.
I'll allow it. She's asking the exact parts of the van.
No, not specific parts. As I said, I did not match the specific geometry of the undercarriage.
Therefore, you're speculating about how these injuries occurred.
Absolutely not, because I know the outcome. I see the blood in the undercarriage, so I know the body was there, and I see the type of trauma, laceration, and under laceration, I have some evidence of fracture. I can guarantee you that's a rigid object in some kind of rounded edge that came in contact. And we have a symmetry to it, consistent with similar structure of the undercarriage.
I have no further questions.
Thank you, Your Honor.
You good?
I'm all set. Well
Okay.
done.
Thank you, sir. Oh, I'm sorry, jury. They often have questions. How could I forget?
All right, well, this Dr. Bong, it was absolutely crazy. But now we're going to go to the best part of jury questions. We can skip because we are catching up. So skippity do. Let's skip. Sorry that if at times you can see me like moving my mouth and like talking and everything. I'm not talking to myself.
I have some questions from the jury.
Hang on, Judge. I can pause you. I'm not talking to myself. I haven't lost the plot yet completely. I'm just talking to my cousins and garden bots. They are here. Just trying to enjoy a little bit of their company as well, and as well doing the stream for you guys. But you don't want to hear me. You want to hear court. Let's get cracking.
In your biomechanical analysis of the injuries, are you assuming that the object being struck, namely the skull, was in a stationary state at the time of impact?
No, it doesn't have to be. The relative velocity has to be about 5 miles an hour. So it could be 2 miles an hour and 3 miles an hour. 2 miles an hour of the skull and 3 miles an hour of the pickup.
If so, could the severity and analysis of the injuries be altered if the object, the skull, was in motion either toward or away from the vehicle?
No, the severity is what it is. So the 5 miles an hour is sufficient to do that. And it could be skull going 3 miles an hour away, and then the pickup will have to be going 8 miles an hour into it. So the differential, 5 miles an hour.
Would you clarify the direction of travel of the van during the impact event?
The only thing I can tell you is the direction of the van with respect to the head. The head is pretty much directly into the bumper, a little bit under the bumper, and the van is coming over.
Did you computer model the impact event?
No, there's no reason to do a computer model because the evidence are so straightforward and based on the questions that I was asked. There was no need for that.
Based on your examination of the data, do you think Todd was laying face up or face down when hit by the van?
It was face down. We know that at the very end, there's some medical observation about dirt in the nose and dirt and grass in the mouth. So definitely it was face down, but somewhat off the ground initially when the impact occurred, but facing down.
Okay, thank you, sir. Counsel, any questions in light of those questions and answers?
Thank you. That face down is based on your review of the medical records, the autopsy records, and photographs of his face?
Yes.
One second. Would you agree, based on your biomechanical engineering background, that if all the blood spots are on the front side of the undercarriage components, it would mean that the van was going forward?
Yes.
Yeah. And simply, when you're asked about the skull being stationary, absolutely still versus there could be a relative movement of the skull, with respect to the bumper?
Oh, the relative motion of the skull before the impact, I don't know. There's no evidence. So from physics perspective, I cannot tell you. I know that what was the orientation at the time of impact? Quite symmetrical. It could be some waving of the head before, but at the impact it was quite symmetrical. And vertical because of both lateral laceration and skull fractures are so symmetrical. So could not be tilted to any extent left or right.
But it was face down.
It was facing down because we have the side impact and then we have a top and the continuation to the back.
Thank you, doctor. Appreciate it.
Hang on. So, I'm sorry, I just want to make sure I clarify. So you're saying if somebody were moving away from the vehicle and the vehicle then was coming from behind, then it would be higher than 5 miles per hour?
The actual velocity of the vehicle would be higher if the body would be moving, let's say 2 miles an hour back, then it would be 7 miles an hour.
If the body were moving 5 miles an hour forward, then the vehicle would have then traveled faster.
If the body is moving 5 miles an hour forward, the vehicle could be stationary. And you have 5 mile an hour impact.
Well, the vehicle would not be stationary when they make impact,
I know, but I'm...
unless the body ran into the vehicle, correct?
Right. That's the test. The 5 miles an hour test in skull fracture was done that way. The surface is stationary and the head hits the stationary rigid surface. So the relative velocity between the head and the impact surface has to be 5 miles an hour. It doesn't matter.
So if the object is going faster, then the vehicle would have to go faster in order to then create that 5 mile an hour.
You have to give me the direction because it depends what direction. But yes, the difference in the velocity. The vehicle has to be going 5 miles an hour faster in the same direction, right, in the direction of the skull to get the fracture.
I have no further questions, Your Honor. Thank you.
Well, I do. If the body was going 5 miles an hour, that you said is jogging speed, correct? You understand the facts of this incident is that Todd Stermer was likely on fire?
Correct.
And you would also expect lower body injuries if he was upright, wouldn't you?
Your Honor, I'm going to object. I don't think he's specialty will let him opine on that.
That's exactly in his wheelhouse based on the questions I received.
I will overrule that objection.
Thank you. Did you see any lower body injuries?
But the abrasion that we talked about, back and shoulders.
No fractures, no nothing?
No.
Okay. You would expect if a body was running and got impacted with a van, you'd have to be, and let's do the quick math. For a change in velocity of 5 miles an hour, if the person's running away at 5 miles an hour, the vehicle would have to be at 10, wouldn't it?
Yes.
Right. You didn't see any evidence of that, did you?
No, there will be fractures in this now.
Thank you. Have a safe trip back to Fargo.
Thank you.
I have no further questions.
Jury, any other questions? May he be excused from his subpoena, counsel?
No subpoena, but he may
Okay.
be excused.
Okay, thank you, sir.
Thank you.
Counsel, can you approach, please?
Sorry.
Right, I don't know how to think about that testimony, to be fair. It's like, it's just a bit dubious. I know, I think they are gonna go for the break. Yeah.
As late as close to 5 today.
Okay, so they are just going to break. So we're gonna skip that because we can. And we are gonna go to, yeah, I think it's the last witness for the day.
Before you have a seat, if you raise your right hand, do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. And once you're settled in, we'll have you give us your full name and spell the last, please.
Gregory James Stormzant, Stormzand.
Sir, I'll have you move that microphone closer to your mouth so the jury can hear you. Thank you. Mr. Mueller?
Thank you, Your Honor. Good afternoon, Mr. Stormzan.
Afternoon.
Sir, can you tell us, what is it you do now for a living?
Retired.
Back in 2007 in January, what did you do for a living?
Back then, I was the Assistant District Fire Investigator, which was out of Grand Rapids, Michigan.
Do you
Michigan
folks at the
State
Michigan
Police.
State Police have different areas and districts that you cover?
Yes, sir.
You were actually a certified fire origin and cause expert?
Yes.
How long have you been doing that? At that time, 07?
At that time, I got in the State Police Fire Investigation in 1999. I completed their training in 2000, so it's from 2000.
Okay. Back in January 7, 2007, there was a fire at the Stermer residence in Lawrence, Michigan. Your name came up as being part of an investigation on January 8th, 2007, the next day, with a man named Scott Leroy. Do you remember at all going to the Stermer house in Lawrence?
Just vaguely since then, yes.
At that time, if you were 2000 and Mr. Leroy was certified or became a fire inspector in 2001, wouldn't you have had seniority over him?
It's not much of seniority. I've been in the unit a little longer than he had. I was
Okay.
in, 99. His is 2001.
Would he have had jurisdiction over this fire because you folks work in districts or something?
Correct. Yes, it'd be his area of responsibility.
You were there then to assist Mr. Leroy?
That's correct.
Okay. Do you recall participating in any type of investigation at the scene?
Not specific investigation. He asked me to do a scene sketch of the residence, basically do the footprint, basically the outline of the house.
Hey, let me, if I can. May I approach, John? Thank you. Just going to show you something. Does that, in the upper right corner, can you just tell us what you're looking at, just to kind of jog your memory?
Upper right-hand corner would be the case number 04-18-07, the date, sketch not to scale.
But it's just GJS are your initials?
Yes.
All right, that's what you're talking about.
Okay, yeah, that would be my initials. That's how I know I did this one.
Do you recall the damage to the level of the house?
It was, recalling from the, thinking back, it was pretty severe, basically over the living room area of the house, which is on the main floor.
Okay, let me show you a photograph, and we can either look at it on the overhead. Or if it's easier for you, just on this blow up. Does that bring back, yeah, that looks like the house we did.
I'm going to object, I guess it's a lack of foundation, Your Honor. I don't know that he's ever had this view of the house before.
He was there on January 8th with Mr. Leroy.
This has been admitted, yes, but my concern is a foundational issue with him testifying from this. I don't know that he was ever up in the air in this case.
Unless you lay a foundation.
Sure, you were at the scene, correct?
Yes.
And did you even look in the house or walk in the house?
Yes, did a walk around, and to the best of my knowledge, I thought, that to the best of my recollection, that Scott led me through the house and a quick, walk around and say what happened and all the general description of what he
Does
saw.
that jog your memory as to that's the house we're talking about or no?
That appears to what the house that I remember looked like.
Okay. Did you take any photographs that day?
I don't recall taking any photographs.
Did you make any reports for your investigation?
I did not.
Other than these
Other
two
than I was
sketches?
asked to do the scene sketch, yes.
When you're doing a scene inspection, obviously this is considered a big loss, a total, lot of damage? Yes?
Yes, sorry.
Not every fire is the same. Some are kitchen fires, right?
Some are very small, yes.
All right. When you have, and especially, not that you treat anything else differently, but when you have a death case, it's a serious, serious case.
I'm going to object, Your Honor. I think the issue is we're not qualifying him as an expert of cause and origin. He sounds like he's testifying as a lay witness. Now we're asking him about how an investigation is conducted. I don't think that he's...
There are, again, I know there's a legal objection.
What it is, are you objecting as to?
Oh, relevance, and he's not an expert.
Okay.
He's not named as an expert, he's talking about his experience. He's even more experienced than Mr. Leroy, so he's talking about excavation, which is the heart of this case.
Oh, I mean, I think it sounds like it's an expert question, so I'll sustain the objection.
In this case, do you recall participating in any type of excavation of this damage to this house?
No, I do not recall doing an excavation.
If you had been part of an excavation of the house, would you typically do a report, given your experience and training?
I would, depending on if there's anything significant that we found in the incident, I would maybe do a supplemental report if requested by the senior,
it certainly
by the officer.
Certainly would be important to do an excavation in order to find something significant, right?
It can be, yes.
Okay. And despite you were in an assistant position back then, correct?
Yes, yes, sir.
You don't recall doing anything of the sort? Reports, photographs, anything?
No, sir.
Thank you. I don't have anything else.
Mr. Blair?
Good afternoon, Mr. Stormson.
Afternoon, sir.
What was your rank with the Michigan State Police at the time?
Specialist sergeant,
Specialist Sergeant?
same as, Mr. Leroy at the time.
Okay. Mr. Leroy, do you want your right hand? Give me your phone, sorry. Yeah, so you guys don't think I'll touch it or not?
Ready to go.
Let me back on the mic. And so you were both Specialist Sergeants, correct?
Yes.
Sometimes referred to as Detective Sergeants?
Well, detective specialist sergeant, call us, technically my badge said specialist sergeant, so, yeah.
So you were both of equal rank?
Yes, sir.
And in the hierarchy of the Michigan State Police, there are sergeants, and then there's actually like a lieutenant above you guys that's the manager of everybody, correct?
Correct.
And so on the 8th of January, you were actually just called down as an assist to Mr. Leroy, correct?
That is correct.
And you were there to just kind of help him with whatever he might have needed help with, correct?
That is correct.
And would it be fair to say your memory of what you did that day is fuzzy?
Yes, sir.
Don't necessarily remember everything?
Correct.
And so when you say, when you're asked questions about an excavation, you don't specifically remember doing an excavation?
I don't specifically remember it. I thought we might have, but I don't specifically remember.
Okay, you thought you might have.
Yeah, but like, how can I answer that? Through the years, had so many fire investigations, we've worked with each other that they all get pretty foggy after the years.
And would you agree with me that it's pretty much state police protocol that whoever's like the lead on a case writes the report?
That is correct.
And that sometimes people that assist don't necessarily write supplemental reports?
Correct.
And would you agree with me that what you had on January 8, 2007 was basically a fairly limited role at that scene?
Yes,
Do you
I would
recall?
say that.
Okay, all right, thank you. I have no further questions.
Yes, are you telling us that if you had done something significant as an excavation of a total loss, that you wouldn't have written any report?
If I would have done an
If you
excavation,
had even assisted and helped in doing a major excavation, you wouldn't have written a report? To account for your
I might
day?
have, depending on what we found, or if nothing. Normally, lots of times, the senior investigator, the person writing the report, would put in, was assisted by so-and-so doing this, taking photographs, or whatever the specific request was done.
Okay. You would certainly expect a thorough report to be done though, right?
Or,
Yeah, I didn't ask them that.
What's the objection?
Ask and answer.
I'll overrule that.
Go ahead. You would certainly expect a thorough report to be done.
or in the report, a section would be during the excavation, so-and-so, you found this or that. Yes.
Not simply omitted.
Yeah.
Okay. Thank you, sir. Thank you for your time.
Jury, do you have any questions of this witness? No questions? Excused from subpoena, if he's under one?
Yep,
Yeah.
I don't
Sir-
have, I do have one subpoena.
Okay, sir, you're excused from subpoena, thank you.
Thanks, sir. Now, as we approach.
You may.
I want to take the vote.
All right, we sidebar and we can zoom through that, but it's gonna be the end of the
No
day
discuss
anyway.
today, so, and come back.
So, the day is done. Yeah, the day is over. Well, yesterday was over. So now we're gonna swap quickly for today. They have already started, so let me set that up. Lois, yes, I know. I know there's no more hours of the day that I can stream a third trial. That is absolutely true. It's crazy. Oh, I've been exhausted, for sure, but it's been a lot of fun. It's not for Lori, for justice for Charles Vallow. Absolutely, I'll do that. So absolutely, yeah, indeed. Hello, therapist. Good to see you. Hello, friend. So let's just change to what they are live now, but we are going to catch up this morning. Okay, so let me have a look. Where do they start? Because I don't think we are that far behind, because court started late today. So I think we are going to be only like half an hour to 40 minutes behind, so it is not going to be that bad, so which is awesome. So let me just unpin that, put that a little bit up, add back to the stage this, and yeah, let's start the new day 9, so of the Linda Stermer unaliving trial. So let's get cracking.
Were they here enough?
Hang on, let me zoom a little bit more, cause. Oh, there, Linda. There comes Linda.
Address before we bring in, back on the record in the case of People versus Linda Stermer, any matters to address before we bring in the jury?
We have none, Your Honor.
Mr. Mueller or Mr. Kelly, any?
No, we have none, Your Honor.
None? Okay, we'll bring in the jury.
And we can zoom this part again, too. I love zooming. But we need to be careful. We're not gonna...
Good morning. Start with an apology. I'm sorry for the late startup this morning. It's my fault. Okay. Counsel? Mr. Mueller? You may call your next witness, or Mr.
Yes, Your Honor. We'd like to call Mr. Steve Benny to the stand.
Good morning. Good morning. If you raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? I do. Thank you. Please have a seat, and once you're settled in, we'll have you give us your full name and spell the last, please. And make sure that microphone's right up to your mouth.
Christina Lynn Benny, B-E-N-N-Y.
Okay, thank you. Mr. Kelly?
Good morning, Ms. Benny. Do you know Linda Stermer?
Yes, I did.
Okay. And did you know Mr. Todd Stermer?
No, I did not.
Okay. And could you briefly tell me, how did you know Miss Linda Stermer?
Through Kate Fox.
Through Kate Fox? Mm-hmm. Okay. And other than just being introduced to her, she being introduced to you by Kate Fox?
Yes.
You ever had any other dealings with Miss Stermer?
As far as what? I mean, before that, we didn't know each other until my sister-in-law introduced. I didn't know Linda until my sister-in-law introduced us.
Okay. Have you been to Miss Stermer's house?
After the fire.
After the fire? Mm-hmm. Is that the only time that you've been there?
We were there one time for my husband to look at a vehicle that wasn't working.
For your husband to look at a vehicle that wasn't
Yes.
working? Yeah. And so that was the only time that you'd been to their home, was one time when your husband was over there to look at a car?
Yes.
Okay. Did you happen to go to their home after January the 7th of 2007?
Yes, we did.
And for what purpose were you there at that time?
To get some materials to build a lean-to for the horses that we were going to take for her, and put, we got the materials from the lean-to that was on the property. So we had to tear some of that down to take to Kathy Eel's property to build a lean-to for a horse.
Okay, and what was your responsibility for Miss Stermer's horses?
To take care of them. We had some horses on the property she had nowhere to take them, because there was no power, no water, no nothing out at the property. So she asked if we could take some of her horses to our property.
And so this material that you're talking about taking material from the Stermer's property?
Yes.
And
It was in a lean-to, it was in the pasture. It was next to a semi-trailer and a tractor. So we took some of the material down to put another lean-to up on Kathy Eel's property.
okay. And then you moved the horses.
Yes.
How many days did it take you to do that?
Not very long. I think we moved it all in 2 days, I'm pretty sure.
And did you have any other activities on the property?
Yes, we did.
And what was that?
We went to the property to get some other materials and go through some of the ashes that were in the bottom of the basement of the house to see if we can find Linda's rings.
And that was a request of Ms. Stermer?
She wanted some help to go out there. We took it upon ourselves to help her out, yes.
And what did you do in reference to helping her out with going through the property?
We went out there was a pile of ashes in the basement. We went through that, made a makeshift screen where we could take shovels and dump it on top of it and shake all the loose stuff out of it to see if there was any materials like rings or anything else like that that would stay on the top of the screen.
And did you find anything?
Oh, yes. We found rings, we found baseball cards, there's some other odds and ends pieces of jewelry that we found.
How many days did it take you to do that?
About 3.
About 3 days?
Non-stop, yep. We went out there one day, was out there until it was almost dark, and then we left, went back the next day, and the next day.
When you say we, who are you referring to, we?
The first day it was me and Linda, Brittany, the 3 boys, I had my husband, Steve.
Okay.
Oh, and Kathy. Kathy was out there before we went sifting through everything.
And this is Kathy who?
Kathy Eel.
Okay. And you stated that the three boys was there also?
Yes.
Okay. And where did you find the baseball cards at?
In the fire, in the stuff that was laying in the basement.
Was it in a container? Were they in a
No,
container?
these were loose baseball cards. And some of them were in, I guess you want to call them, photo albums.
But they survived the fire?
They had some burning and they were pretty wet. I mean, the stuff was wet. They were stuck together. You had to actually pull them apart.
Okay. And did you do anything else in the, you referred to this shed, or is it a lean-to?
It's actually a semi-trailer that used for storage. And then they had another shed on the property that had hunting materials and deep freezer in it and all kinds of other stuff.
And did you go into the semi-trailer?
Yes.
That was used for storage?
Yes.
What was your purpose for going in there?
Our purpose is to go in there to see if we could get anything that related to the horses or anything else that we might have forgotten, to make sure that we get everything we need before we moved all the horses. And there's some other odds and ends, and that was it.
Did you remove any personal household items out of the shed?
No.
Okay. Did you hear any conversation about any household items in the shed?
As far as what household items are you
Or
referring
valuables of the family?
to? I'm sorry.
Valuables of the family?
There was boxes of pictures in there.
What kind of pictures?
Photo albums, picture frames with the pictures of the family, the boys.
And you saw those?
Yes.
And did you see anybody remove them from the trailer?
Well, we picked them up and moved them out of the way because we want, we couldn't figure out why they were in the semi-trailer in the first place.
Had you ever been to the house?
No, I have never.
Did you make any comment to anyone as to why they were in the trailer?
Well, I made a comment that was weird, that boxes of pictures were in the semi, and so I said something, well, we were all standing right there, and it's like, why are there boxes of pictures in the semi? And that's when Linda says, I don't know. And so that's when we asked the boys.
You asked the boys what?
If they knew that the pictures were in the semi-trailer.
Do you know which one of the boys you asked that?
I get the two boys mixed up, Trenton or Trevor. So I don't know if, I'm pretty sure it was the youngest son said.
Excuse me, Your Honor, that's objection hearsay.
I'll sustain.
Did you hear any statement at all about the box of pictures?
Objection hearsay, Your Honor.
She can say what she
She can
heard.
answer whether she heard a statement, or the content of it, though, is going to be objectionable.
What I heard was,
Okay, ma'am. So there's a hearsay objection as to
Okay.
what she heard. One moment, ma'am.
So did you hear a statement, not saying who's
Yes.
made a statement, but did you hear any statement about,
Your Honor, I'm going to object. It's hearsay.
Your Honor, she can testify to what she heard.
There's a hearsay objection, and what is your response to the hearsay objection?
It's not hearsay if she literally is standing outside and hear a statement being made. I'm not asking her about the truth of the statement. I'm just asking her, did she hear a statement?
Well, you can ask, did you hear a statement, yes or no, but once we get into the content of the statement, it does appear to be hearsay.
Did you hear a statement about the pictures?
yes,
Okay. And did anyone remove the pictures or the box from the trailer?
I don't recall.
You
I
don't
don't
recall?
remember them being brought out of the trailer.
Okay. At the time that you heard this statement, who all was present, if you recall?
It was me, Linda. I'm pretty sure that Kathy was there, but I'm not right there in the semi. I think she was down in the shed. And my husband was nearby, and the boys.
And where was Linda Stermer?
She was standing right next to me.
Okay. Can I have just a second, young? Did you make any other visits to the house after you stated that you all had been out there for 3 or 5 days?
I don't recall that, but the 3 days that we spent out there is the only 3 days that I remember.
I have no further questions, young.
Good morning, Ms. Benny.
Good morning.
So when you met Linda, it was after the fire.
I met her one previous time before that.
Okay, and how much time did you spend with her then?
I didn't.
You didn't spend any time?
No, we were introduced, and I went into my house and did my own thing.
So really, those 3 days after the fire was your first interaction with Linda Stermer?
Yes.
Never met Todd?
No, I never met Todd.
And you were introduced, or excuse me, I think you said your husband was introduced you to Linda through Kate, correct?
Correct.
Okay, and that was to connect you with the horses?
Yes.
How many horses did you take for Ms. Stermer?
Oh, that's hard to, well, it's not hard to answer. At the beginning, when we took the horses away from her property, after the fire, there were a total of 5.
Did you get more?
Oh, yes.
How many more did you get?
We had a total of 18 horses.
And these were all then Linda's horses?
Yes.
Did you get any more?
After we got the 18?
Yes.
No.
Did you ever have an opportunity to meet Mr. Chris Williams?
No.
Linda ever talk about him?
No.
And Kathy, you said, was with you when you went out the day after the fire, correct?
The day we went through the semi, yes.
And she was there with you as you were in that semi?
She was not in the semi.
Was she by you?
No, she was down the hill in the shed, looking through for tack and what have you that we needed for the horses.
But she was out there with you in going through the items?
Yes.
And you never heard Linda say that she asked the boys or Todd to move those pictures out into the storage area?
As far as, I heard one of the boys,
I'm not going to ask you what the boys said. Did you hear Linda say she asked the boys or Todd to move
No.
the pictures out there?
Linda did not say that.
Okay. So if Linda said she said that, Linda would be wrong.
I'll allow it for cross.
As far as what?
If Linda said she said that, Linda would be wrong, right?
Objected the characterization of calling my client a liar.
I think she's saying she was wrong,
Yeah.
so I'll allow it.
Linda never said that. I mean,
I have no further questions, Your Honor. Thank you.
Ms. Benny, where did you,
I just did.
where did you move the horses to?
2 of them went to Kathy Eel's house, and the rest came to my house.
And then did you ultimately do anything else with the horses?
Yeah, we cared for them. We maintained where they lived. We made sure they got fed, stuff like that. Linda and Kathy had the same thing. She had 2 horses at her house. She had to make sure they were taken care of, watered, and fed.
Still have the horses?
No, we do not right now.
What happened to them?
Your Honor, I guess that's irrelevant at this point.
Was she-
Talking about things that happened in the next issue.
She asked about.
I'll allow you to ask what happened to the horses.
Did you sell the horses or do you still have the horses?
No, we do not have the horses.
Okay, did you sell the horses?
We did not. I and my husband did not sell the horses.
What happened to them?
Some were rehomed, some were taken back to the previous owners, and some were sold.
Okay, I have no further questions.
Anything else inside?
No further questions, Your Honor.
Jury, do you have any questions of this witness? Any hand going up?
I forget that I can speed up through this sidebar. Like, let's zoom.
You sifted through the question from the jury, ma'am, no objection from counsel. What were the dates that you sifted through the ashes and went through the semi-storage?
Oh, I don't know exact dates, but I could tell you what season it was. It was like, not much later than after the house fire because the horses didn't have any water or any electricity, so we had to get them out of there as soon as possible. It was still snowing, so I'd say mid-February when we got the horses to my house and Kathy's house.
Okay, thank you. Council, any questions in light of the question and answer?
No, Your Honor.
They're not.
Jury, any other questions of her? None, thank you. If she's under subpoena, may she be excused?
Yes, Your Honor.
No objection.
Thank you, you're all done.
Thank you.
Mr. Mueller? and
Yes, we have witness Mr. Rich McGrew.
Sorry, what was that name? Rich McGrew? Is that like Mr. McGrooch? What? Definitely not in Bergen.
If you raise your right hand, do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. Chair's kind of hard to move. And then if you could put the microphone near your mouth so the jury can hear you and tell us your full name and spell the last, please.
Richard Anthony McGrew, McGrew.
Thank you. Mr. Mueller?
Morning. Mr. McGrew, can you tell us what you do for a living today?
I'm the village manager of Matawan.
How long have you been in that position?
2 weeks.
Congratulations.
Thanks.
Hope I'm not pulling you away from your job right off.
Right.
Back in the summer of 2024, last year, do you recall getting a file from Kathy?
Kelly Largent.
Yes, Kathy Largent.
Yes.
What was your position at that time in the summer of 2024?
At the time, I was the acting building official for Lawrence Township, and I did get a FOIA request, and I had Kelly Largent go through and pull all the files and the records for that particular job.
Okay. As building director?
Official. Building official.
Building official, what are your duties?
Run the building department. I do all of the building department, the zoning, planning, rental division, do all the plan reviews and the inspections for multiple jurisdictions at that time.
When you say you do the planning and inspections for jurisdictions, would that include Lawrence Township?
Yes.
Right. Did you get a FOIA request, Freedom of Information request from my office?
Yes.
And Ms. Largent got you the file pursuant to your request?
Correct.
All right. Did you review the file?
Yes.
All right. I want to direct your attention, and I think I've opened it up, to Exhibit CC.
Yes.
Can you tell us what that file is, that exhibit?
It was a building permit for the certificate of occupancy for that home.
That home would be located where?
Good question.
If I look at a yellow page and you see the Bates numbers on the bottom right, page 226.
That would be the 66598 County Road 215?
That's correct.
Yes.
What did you understand, or who did you understand that particular file or that address to belong to?
To Mrs. Stermer.
Okay. Are you in a position, or were you in a position back in August 24, to review the building file and look to see if there were final permits, interim permits, final certificate of final occupancy?
Yes.
Okay. Does this file that we're looking at, Exhibit CC, represent the entire file that you were provided?
Yes, it looks like the file that I have.
I'd move for the admission, Your Honor, of Exhibit CC, point 1 and point 2.
No objection. Court will proceed.
Those exhibits.
Thank you. There are two separate files in here. Would that be right?
Correct.
And if you look at the first page, kind of refresh your recollection, what are those file numbers?
It should be the zoning file and then the building permit.
What is the difference?
The zoning has to have the approval prior to a building permit being done to make sure it meets all the required setbacks. And then once that's approved, then it moves into the building process.
Okay. In looking at this particular file for the Stermer residence, did you look to see if there were any final building permits pursuant to that, or for that address?
Yes.
And what was your findings in terms of any final permits?
I did find that it had the rough ends all done for the mechanical, electrical, plumbing, the MEPs is what we call them. Those normally have to be done prior to any building rough ends done, mainly for safety issues. And then it looks like there were no other inspections done after the rough end were completed. So it was completed for all the mechanical, electrical, plumbing, and building were all completed at rough end stage. Nothing past that.
So there were no final inspection certificates for electrical?
Correct.
Or mechanical?
Correct.
Or what else is there?
Plumbing.
Plumbing? Nothing for
And then
that either?
building. And then the final one is the building.
Would that be considered or called a certificate of final occupancy?
You do a final inspection, and then once that final inspection passes, then you actually award a certificate of occupancy.
Okay. Was there any evidence that there was a final inspection?
No.
And was there any evidence in your file that that residence for the Stermers ever got a final certificate of occupancy?
No, it did not.
Is that important that people get a final certificate of occupancy and go through a final inspection?
Yes.
Why?
That means that the house was safe, everything passed the building code at that time, and then it's allowed for occupancy. And no occupancy is allowed until you actually have the occupancy awarded to that residence.
What would be the risks in terms of safety if you didn't have those inspections?
The electrical wasn't inspected and it had a malfunction, somebody got electrocuted, somebody got injured. A lot of times in the case of a house fire or water damage or anything at all, then the insurance company will kick it out and deny the claim because it was not final and safe at that point in time for occupancy.
One of the risks you said is house fires?
Yeah, house fires, we've seen water damage, we've seen wind damage, there's been multiple issues that we've seen throughout the jurisdictions. I've done over 36 jurisdictions, and we've had multiple ones.
How is it that a person, a family, could move into a house without having these final inspections, without having a final certificate of occupancy?
A lot of times when a homeowner moves in or actually is doing the permit themselves, if they don't have a contractor, they don't know that you have to call in for a final most of the time. Most of the time it's just, they don't know how the process works. Like the contractor knows you get a certificate of occupancy, that finals your permit, and a lot of times if you're doing it self-funded where you're paying for the permit or the house as you're going, a lot of the homeowners don't understand that if the building official does not explain that to them.
Not having those final certificates, not having the certificate of final occupancy, is that considered, from a government standpoint, illegal?
Yes, it is illegal.
Okay. I don't have any other questions for you. Thank you, sir.
Thank you, Your Honor. Good morning.
Good morning.
Do you live in Lawrence?
No,
Do you live in Van Buren County?
no,
Are you familiar with the size of Lawrence as you work there?
yes.
Would you call it a small town or a big town?
It is a small municipality.
And so, being a small municipality, would you say that a lot of the inspectors know the community members?
Probably not. Most of our inspectors at that time were from Richmond, some were from Athens area, some were from New Buffalo area. So they were from all over.
Do they spend time in the community and work in the community?
Yeah, they're there probably at least once to 5 times a week, depending on how many inspections they have in that area.
And you know when somebody's getting a building permit that obviously a house has started, correct?
Yes,
And you stated here that the plumbing, electrical, and the initial inspections were all done when the house was started.
well, there's multiple inspections. There's from foundation, footing, all the way up to rough in. Then after the rough in is completed, you go to an insulation for an energy inspection. Then you continue on to all the
The
finals
finals.
at that time. Yes.
So all the initial ones were started
Yes,
and approved?
yes,
Plumbing, electrical,
yes,
structural,
yes,
those were all done. So the township would have known that there was a structure going on, correct?
yes,
And they would have known that the structure was going on when that building permit was applied for.
correct.
So if the house took 6, 7 years to complete, the township would have had all the documentation that that house was under construction.
Correct.
And as your job as a building inspector, do you keep track of what's under construction in your area?
With doing 36 municipalities at that time, you can't keep track of every single building. And normally the computer after 6 months will generate expired permits and email the permit holders, whether it's a homeowner, whether it's a contractor, and let them know their permit is about to expire. And it's normally within 6 months after the last inspection that they had. So a lot of times that falls back onto the permit holder to renew the permit and to continue on with it.
And you
So-
don't know what happened in this case?
No, I didn't have any inspections. I didn't do anything with this home other than I took over after that inspector had moved on. He had resigned, I think, in July, and then we got this.
Can you agree, it's no secret that that house was under construction for a number of years?
Right, yes.
And in a small town, you were aware, or somebody was aware they were living there?
I was,
Speculation as to somebody.
I'll withdraw.
Thank you.
If the building inspector had notice of this home being built and any inkling that it would have been unsafe, would they have taken any action?
I just object to some facts not in evidence, asking him to speculate on that.
The way it's phrased, it does call for speculation.
In your current position as a building inspector, if somebody was living in a home and they hadn't received their final occupancy permit, would you take action to remove them if you felt it was unsafe?
I would red tag the house and explain to them that there is no certificate of occupancy, and until you have all the final inspections completed, then you could move back in.
And nobody did that in this case?
I don't know.
Do you have anything in the file to suggest that that occurred?
Nothing in the file shows that any finals were done.
And nothing shows that it was red tagged?
Nothing shows that either.
Nothing shows that anybody went out to this house and had a conversation with them?
Nothing. Other than obviously the emails from the expired permits. That would have been the only thing that they would have contacted them for. And at that time, it's the permit holder's responsibility to renew the permit or move on.
And those emails are in that file?
I'm not sure if the emails are, because it generates off the system. So it automatically sends them that 6 month time, 180 days.
In 2007, was that the case?
That's a good question. I don't know. I wasn't at that company in 2007.
Okay. And you don't know what their procedure was at that time?
No, I don't know if they had that same computer system at that time or not, because they did develop the system, but I'm not sure when they actually implemented their computer system.
And you have no evidence that those were set in that file that's been provided today?
No, I didn't see anything.
Okay. I have no further questions, Your Honor. Thank you.
Just a couple follow-ups, sir.
You said if it's expired, it's then the homeowner's obligation, whether
Permit
it's
holder.
permit holder,
Yes.
right? Whether, it could be the homeowner, or sometimes if you use a contractor, it's the
Correct.
contractor.
Okay.
If the permit expires and the homeowner says, I want to re-up the permits, do you have to go through the whole inspection process again?
No, you can actually up to 365 days. I normally give them a year. At that point in time, if they had no inspections in a year, then they could go ahead and renew it for a $75 flat fee.
Okay. And not have to start over?
Right, correct.
Bottom line, though, it's the homeowner's obligation to keep up with that, or I should say the permit holder,
Correct.
right? Okay. And there's nothing in your file that shows that the permit holder, Mr. Todd Stermer, did any of that?
No.
Okay, thank you.
No further questions, Your Honor.
Jerry, do you have any questions of him? At least one hand going up.
Oh, sorry about that. So, sidebar. We can skip through that. Sorry. I'm out of breath because I had to run.
Sir, I have a question from the jury, a couple questions, no objection from counsel. Did or does Lawrence Township have language on permits stating a final inspection was needed before occupancy permit was issued?
Yes, normally on the building permit, it states what inspections are required throughout everyone that's on that particular job. It'll have a list of inspections that are required under stipulations.
And is there standard language in all townships, villages for final permits per state laws?
Yes.
Counsel, any questions in light of the questions and answers?
Just want to make sure I clarify that last answer. Pursuant to, would be Lawrence Township?
Yes.
All right. Pursuant to Lawrence Township laws and the government, without a final certificate of occupancy, that house is considered unsafe to live in?
Correct.
Okay. Thank you.
I just want to clarify, it's not unsafe, you just haven't inspected it.
No, it's unsafe. It's unsafe until the inspections are completed.
But you didn't document anything that was unsafe, it's just nobody's been out to the house, correct?
Right, and at that point in time, by legal law of the code, it is unsafe until the inspections are completed.
Okay, but you can't say what would be unsafe until you actually inspect it?
Correct.
Okay, I have no further
Right.
questions.
Mr. Mueller?
Nothing more, Your Honor. Thanks.
Thank you. Any other questions, jury? No, may he be excused from subpoena if he's under one?
Please.
No objections.
Thank you, sir, you're all done.
Thank you.
Go back to your new job.
Enjoy. Thank you.
Mr. Mueller or Mr. Kelly, you may call your,
May we approach?
you may.
All right, so another sidebar. My sidebars are going up in this thing. So let's skip that sidebar. Let's skip it. Linda looks a bit worried today. I think she knows that the end is coming of her trial. Not, yeah, never. Oh, the sun is there. Look, that's the sun, isn't it? The one in the checkered shirt thing. Ooh, I'm sorry, but the wife, I'm assuming is the wife or girlfriend or partner or whatever. She's beautiful. Sorry, hang on. Here you go. Sorry.
Okay. Mr. Mueller, did you have any further?
1 second, Your Honor, so I can just. Your Honor, by stipulation of counsel, we have agreed to admit plaintiff's exhibits AA and BB, Alpha Alpha Bravo Bravo, medical records of Dr. Yu.
Agreed, Ms. Seiderbean?
Yeah, I just wanted to take a look at both. No, Your Honor, I just wanted to take a look at, we agree, it's just what he was prescribed in his medical records for the ear infection, so we agree, that's fine.
Okay. So I'll admit, what is it, UU and
Okay. Oh, UU
you,
and AABB.
okay, we'll admit those by stipulation. And any other witnesses, Mr.
We don't
Mueller?
have any live witnesses, Your Honor. We don't have
Okay,
any.
no witness, your rest?
No, Your Honor, we need to put something on the record.
Okay, outside the presence,
Right.
got it. And Ms. Seiderbean, did you anticipate any rebuttal?
No, Your Honor, we have no rebuttal witnesses.
Okay, thank you. So jury, what I'm going to do is, we're getting near the end here now, so we're working on final instructions and things like that. That's why we had a late start this morning. But I'm going to have you go and come back to the jury room at noon and go do whatever you want to do, but you're still under all the instructions of the court to not discuss the case or do any research or media searching. And then we'll get you some lunch back here. You can anticipate having some pizza or some lunch back here. And I think George is aware of dietary restrictions, but if you have any, you might want to let him know ahead of time, okay? So back here to the jury room at noon, and I anticipate at that point we'll be going right into closing arguments. Okay, thank you.
Oh my. So they are gonna come back at 12 noon. Wait, hang on. What time is it? What time is it? What time is in Michigan? What? Well, I need to know the time. Hang on. I'm all flabbergasted. So defense rests. No rebuttal. Closing argument. It's 11 o'clock. Okay. Right. Okay. So I'm allergic to bad pizza. I am allergic to bad pizza. So wow. Can Paula, can you put on Discord about the resting? Defense rested. The defense rested. No rebuttal case. Closing arguments at 12 p.m. Yes. Well, 1 hour. Let's see what happens, but we can skip some
Okay,
of
counsel, the jury has left. And Mr. Mueller, you wish to place something on the record? You may. You may.
Okay, they are gonna conferencing a little bit. Let's skip that part. Whose birthday? Whose birthday do not harm? Mine is on Monday. Let's skip this part. Well, we can skip it all, but I want to listen to everything. Hang on. There you go. They're back.
Okay. Okay, you wish to place something on the record?
Yes,
Or, I'm
Your
sorry, Mr. Kelly?
Yes, Your Honor. On behalf of Ms. Linda Stermer, we have explained to her her constitutional rights in reference to her right to testify in this case. And she fully understands that she has a right to testify and that she's waiving her right to testify as it relates to participating as a witness on behalf of herself. And so to that extent, Your Honor, we would, if you have any questions you would like to ask of Ms. Stermer or to me, we're prepared to respond.
So, Ms. Stermer, you've been advised that it's your call on whether or not to testify in a criminal case, and so you've discussed this issue with your lawyers, and, okay. Do you have any questions about it?
I feel that I'm fully advised of my constitutional rights and have decided to waive my right to testify.
Okay. And you're certain about that?
Yes, ma'am.
Okay, thank you. I don't have any further questions of counsel or her. I don't know if...
I don't either, Your Honor. Thank you.
Okay.
Thank you, Your Honor.
Okay. Thank you, counsel. Anything else, counsel, to address before we reconvene to go through finals again?
People have nothing, Your Honor.
We rest, Your Honor.
Okay. Defense rests, thank you, and the prosecution has rested.
Yes, Your Honor.
So counsel will meet, maybe can you come back in 10 minutes or so? We'll go through the finals again?
Yes, Your Honor.
Okay. Does that work?
10 minutes?
Yeah, 10 minutes back in my office. We can go through another round of finals. 10, yep.
Judge, I sent the court a case as well as opposing counsel about the second-degree murder issue.
Okay.
Just if you want to take a gander at it, I emailed it to everybody to look at, just so we have a, I think it resolves one of the discussions we had back.
Oh, good, okay. I'll have a look at that. Okay, I'll see you all in 10 then.
Thank you, Your Honor.
Thank you.
All right. All right. So they both rested. Well, Zizzy, if there is a verdict today, yes, I am gonna be dark tomorrow because I'm gonna be honest, guys. I love you all a lot. I have the most fun that I can have when I'm doing this. So no, case one, she's not gonna testify. It's okay. Sorry, no, yeah. I was saying, I love you lots. I would love to maybe do something or anything, but I am gonna take a day off. I want to enjoy a little bit of the sun that is over in the UK at the moment. I go outside and just enjoy it a little bit and have a bit of a rest and play video games and do some YouTube work that I still have to do it. Obviously, you know, I'm thinking of making like a video or something. Thank you guys, but I do feel guilty of having a day off if we get a verdict today from Linda Stermer. But thank you. But I if you guys are okay with it, yes, I am gonna be dark tomorrow. I hope you have a very safe drive though, Susie. I really hope so. Please have a safe drive. But yeah, I really want the day off. I know I have the weekend off, but I have so much work that I want to get done for the channel because we are growing, which is an amazing thing. I want to get some work done and some stuff done that I've been promising you guys that I've been wanting to do, and I haven't. So yeah, I hope you guys can understand that, and I hope you guys can hear me because I don't see no reaction. Probably you all crying that I'm gonna have a day off or celebrating. I think more is celebrating than actually crying, but never mind. I'm gonna stop talking. Oh, yes, we need... Oh, yeah, Paula, thank you. We need the verdict thing. I'm so dumbfounded we are doing 2 trials at the same time that I don't even think. You can play the verdict game. The form is on there. I need to put the verdict game now on the thing. But guess what? We can skip to live because literally there's nothing happening. Nothing. They do not come back. At all, so literally let's skip to live. We are live. Oh, we are live right now and there's nothing. I know I'm gonna miss you so much. It is gonna be weird, but yeah, if that's okay, if we have a verdict, definitely I'm gonna be taking the day off. I don't know. I do feel guilty. Like, no, I'm not gonna lie. I might do an improper live stream from the park because I think I might. I'm thinking of going to the park across the road if the weather's nice for a little bit of a walk. I might do. Yeah, I might do that. So, Paula, I need to write your thingy. Oh yeah, we'll come together on Monday for Lori's trial for sure. Hang on, I need a piece of paper. No, not that piece of paper. I'm gonna do it here. Paula guilty what? 3 to 5. 3 to 5 hours. Right. I appreciate that. I still do feel guilty. Thank you very much, Case One. I do feel guilty, definitely. Maybe tomorrow, Paula. If there's no verdict, yes, I think I'm gonna take the day off, even though I'm gonna feel like super guilty and super 2 to 5. Okay, I'll change that 2 to 5. So if you want to play the verdict game, the form is up there on the thing. But if you want to tell me, just let me know. We just play a game and then see who's right, who's wrong, and everything. Ooh, there's not guilty. I'm gonna finish. Yeah. Okay. I will try not to. You know me, I'm a perfectionist. I feel like I have to be live 24/7 and be here all the time and everything. So, thank you for that, William. Appreciate you guys. You guys are amazing. I'm gonna feel bad on Monday. I'm gonna be, I'm gonna be old. Oh, no, I don't want that. I don't want that. So yeah, so I think so they say they're gonna come back at 12 o'clock, so that's 45 minutes. Oh, Denise, the verdict expert, not guilty, 5 to 7. Wow, they're gonna take a while in your opinion. Oh, no way! Oh, I hope they get fixed by tomorrow, Paula, as well. That is crazy. Wow. Oh, sorry. Got you. Got Case One. Not guilty. We have a lot of not guilties in this one. 3 to 5. So if you're putting your you guess in chat, just tag me so it can pop up for me. So yeah, so it doesn't yeah. Oh, see, a lot of people. Lois, guilty 1 to 3, do not harm, guilty 3 to 6. I need to set up the other computer for the for the timer for the clock. So yeah, the expert said not guilty. Well, you can change, yeah. You can change up until the end of closing arguments. You can change your guess, so it's absolutely fine. To say that. Oh, is Maria okay? Because I've seen her on Discord, but I haven't heard from her in chat yet. Because yeah, never. I'm just wondering. Oh, CSD Dog's mom. CSD Dog's mom. Guilty 4 to 6. Got it. Wow, that is awesome. It is, isn't it? It's always doubtful, and it's always, yeah. And that is always like, well, she can't fix all the problems. She, for sure. Yeah. Oh, why? Well, yeah, you can. You can change after closing. Absolutely, indeed. Well, our expert says not guilty. She has influenced case 1. Joking. I don't know. I'm like, like it's a bit, yeah. I don't know. Even though I'm still on the fence, right? I I don't know. I don't know. It's indeed, she is the boss. Indeed, she is. Oh, I don't know. Even though I think yes, she is guilty. I understand Denise and Case One's point of view, and Bilney, I think it is the name. Sorry, but the jury's always impredicative, and everything. Um, it's just so hard. I still need to do Lori's music, AI music. Oh, by the way, quick question. Lori's trial starts in how long until Lori trial? Starts at 2 p.m. So 12 p.m. they come back. So we have 2 hours until Lori starts. What do you guys want to do? I can do a poll to see that. Do you guys want to do closings here and then catch up on Lori? When they come back and we do everything in one stream, instead of jumping like we've been, I can just like merge both streams, which is absolutely fine. Or do you guys want to catch up on Lori live, and then on break of Lori we finish the closings and then do the verdict watch from there? Because I don't think they're gonna be that fast. It's gonna take them an hour and a half to do the deliberations or the closings. So Lori life for you, okay. Oh, that's all right. Oh, guilty. Dear, I'm off the fence. You are off the fence. Yes. William is guilty. And how long do you think it's gonna be, William, that they are gonna be deliberating? It's absolute. So Lori life. Okay. Yeah. Well, I think yeah, they could take a long time indeed, and we are live. I don't know. I don't know what to do. Why do I have to make the decisions? Yeah. True. Oh, sorry. Being to think Todd started the fire because he didn't want her to get to the house. True. And then, but in the process, get rid of them. Okay, Lori life, definitely. Through the weekend, because so much go through Yeah. Okay. So it's gonna. You think it's gonna go to? Oh, you really want me to stream tomorrow, don't you, William? You don't want rest for the wicked, huh? Thank you very much. No, I'm joking. Of course, if they deliberate for tomorrow, we will be live. Absolutely. We can watch some parole hearings. We can do some stuff. Absolutely. Absolutely. We're gonna be doing that. Um. All right. She was deceiving him about a lot, money, affair, houses, horses. Exactly, a lot indeed, Zizzy. That is definitely a good thing. Um. Hmm. Okay. So, what about this? If you guys agree, because we have basically 2 hours until Lori starts, because it's 11 o'clock right now, isn't it? In Michigan, right? Is it Michigan? Because also it depends when they exactly start the closings. 11:17. So they still gonna do the jury instructions. And then are they still gonna go in to lunch break? Or they are on lunch break now? Because if they're gonna still go on lunch break, we'll do. Yes, Ohio is the same time zone, right? Yes, right. They still hammering instructions, exactly. And they still gonna go on lunch break after. No, take maybe 30 minutes. Oh yeah, it's been a long week, I understand, but my perfectionist thing, Denise, is not gonna allow me to take a day off knowing there's a verdict watch. All we could do is, because I'm gonna be at home, because I think Gardenbot is gonna be working, what we could do is, if there is a verdict, I can go live just for the verdict. So we could do that as well. I'll see. I'll have to. If the verdict watch will go for tomorrow, we'll definitely have a stream, one way or another, either to watch some parole hearings, etc., or we will be yeah, we'll be coming live for the verdict only. We'll see. Me chilling. Yeah, no. Ask Jason if I know how to chill. He knows me that well that I don't chill. It's hard for me chilling when I know. Right, okay. Okay, Mom. No, I'm joking. Sorry, Denise. Love you, girl. Okay, alright, I'll listen for once. I'll think about it, but I might do that. Oh yeah, no worries. Absolutely fine. I can entertain you, Susie. Definitely. And enjoy packing. I never do. I don't enjoy packing. um so we might do this then. Yeah, okay. Oh, this music the Core TV is playing, it's really annoying me. But I need to keep an eye on it because they can come back at any time. So right. I was gonna say something else that I don't know. Oh, right. Okay, so they're still gonna go on break. They're gonna come back at 12. I don't think they're gonna start the instructions there, right? What we're gonna do at 10 minutes to 2 p.m., because Lori starts at 2 p.m. Eastern. So at 10 minutes to 2, I will send us to the new stream if they still live. So, oh, I need a nice coffee. See? There we go. Jason has spoken. I do not chill. I don't know how to chill. I'm always doing something. Absolutely. I'm always on a go. So for me, having time off and like slow down. Yeah, right. You guys are funny. But Paula, I need a nice coffee. It's actually very nice weather today here in UK. For once, it's like sun, almost no wind, just a nice breeze. It's perfect day for a nice coffee. I think I might have one later because I'm gonna have to be up until 1 o'clock in the morning or around that time if the court decides to finish early. Well, yeah. Raspberry truffle macchiato. Oh, that is nice, Paula. I am not envy at all. Ooh, I forgot to do this. Why am I doing this? If anyone wants to come up and chat, you can. Um, yes, Jed is chill enough for both of us. Definitely, Jason. Garden bot cutie pie. Is very chill for both of us. Uh-huh. Yeah. So if you like to jump on stream just to talk like a phone call or anything, just do it. It's free. You don't have to have your camera on. I don't know when court. Oh yeah, court will resume in about half an hour, so we have plenty of time to chat. Ooh, we already have our first guest. Hello, hello. The person that is off from work. Yay. Uh, how is your day off going?
I forgot.
You forgot how your day is going? Your day off is going?
No, I have you on my big screen.
Oh.
So I had to mute the TV so that there wasn't any feedback.
Yeah, no, I don't want to hear my own voice. Thank you very much.
But yeah, this is what I'm doing. I am laying on the sofa doing nothing. Hi, Lois.
How do you do that? I don't know how to do nothing. I always have to be doing something. I don't know how to do nothing. It's
In all fairness, I do have a load of laundry that I need to at least get out of the dryer and get it folded. And then in a little while, I am going to go outside and do some yard work.
Ooh, yard work.
Oh, what does my hoodie say?
Oh, it's the recovery addict one, isn't it?
It is.
And I recognize the color.
Can you read it?
I cannot read it from here. I think I should know what it says, but I cannot read it from here. But maybe other people can.
This is my prison escape hoodie.
Yes, that's it. It is a really good hood. It's been on my basket on the shop for ages. I need to actually buy it.
Yeah.
Oh, Jason, yes, you need to do it, and I need to be there for you when you call Jed a garden bot cutie pie. That's what Denise calls him. So.
Oh yes, cutie pie.
Cutie pie. Definitely, I need to be there for that. Absolutely, yes.
Do it, Jason. Do it.
No, like the thing is, we are gonna probably be together very, very soon because I think you know Jason is my brother-in-law's brother, so we are related. Is in the family, so yeah, we are gonna be very soon together when the baby comes. Hopefully before, yeah. So we are on baby watch. Oh, yeah, Paula, please be careful. Yes, you drive. Good that you are technically at a light now, but yes, we prefer you being safe first. So, yeah. But yeah, so we're gonna be together hopefully soon for a good reason, because I think the last time we were together was not for the greatest reasons. So, yeah, we are on baby watch. I'm so excited. I'm trying not to be, but yeah. But yeah, how like teach me. You need to teach me then, Denise, how to do nothing. Like when you're laid down there, are you just looking at the TV, at the phone, chatting, or like are you doing a research for cases or?
The TV is right in front of me across the room. Let's see.
So while Denise is trying to figure out, William, very quickly, the link that I posted earlier, I'm gonna try to see if I can still find the link. Where's the link? Oh no, I'm gonna pin the link, and if you just pressed on that, it should take you to the website. That is the StreamYard. It's free. You don't have to have your camera on, and it's through the internet, so internet connection is required, but you are on here, so, and then I can add you to the stage. Yeah, basically that. So feel free at any time, my friend, of course.
Yeah, I can't figure out. I was gonna turn my camera around and show you, but I can't. Well, here, let's do it like this. So there's my TV.
Oh wow, there's the TV. Hello. If I wave, will I see it? No.
So
That's just the thing that I struggle, William. Just chilling and not doing anything. I don't know how to do that. So,
come on, Gilligan.
like, can you guys see me? Like, by a show of hands, can anyone see me just chilling on a sofa watching TV? Can, oh, look, it's a doggy. Doggy, right?
It's a
Not the cat.
cat
Or is, oh, it's the cat. It's the cat. Oh my days. I'm sorry.
with his tail in my face. Move.
Well, yeah, we saw. See, case one doesn't see that me's just on the sofa watching TV. See, like, yeah, no, definitely not.
So, okay, this is my reward. Gilligan. This is my reward for raising 4 kids and having 9 grandkids.
9. Wow.
Like my housework is mostly done, mostly. But Gilligan, swear that cat. I feel like Kathy yelling at the dogs. This cat.
She does that a lot, yeah.
But look. Can you see him?
Yes. Oh yeah. There he is. Come on. Hello. Oh.
He's trying to pull my blanket.
Yeah, I was gonna say he's trying to pull something. We can watch that all day. That would
He's
be
trying to
entertaining.
pull my blanket off the back of the recliner.
Maybe he's cold.
He's about a year old. He's a Norwegian forest cat, and he weighs 10 pounds already.
Ooh, wow.
Yeah. But anyway, laying on the sofa, this is my reward for being an empty nester.
Well, that is definitely a great reward indeed, and some like peace and quiet, and not just a great all the time noise and everything for sure.
Yeah. Other than the cat running back and forth, there's no noise in the house. So it's amazing.
That's good. I like, but the thing is, I don't know how to do nothing. It's not in my nature. It's of just lay down on a sofa. I think I did that too much when I was a kid, so I can't do that anymore. So I think I've rested and chilled enough.
And I didn't.
So there you go. You can do now.
So I was like, go, 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 go as a kid. We were involved in sports and, other activities, and, the same thing with raising kids. We were go, 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 go all the time. I mean, I was even for 7 or 8 years, I was a Girl Scout leader.
Oh, wow. So that involves a lot of work then.
Yeah. So now my favorite, if I'm not laying on the sofa, like as soon as the weather starts getting really nice, I will, when I get off work, I will grab my hammock and go set it up and I will go lay in my hammock and listen to whatever court case we're watching or whatever, and I will lay in my hammock for like an hour, hour and a half. I might even take a nap.
Oh yeah, naps are definitely great. I definitely take naps. Absolutely, yes. But I don't know, just laying there and not doing anything apart. Like, yes, listening to a podcast or court or anything. Yes, that is doing something in effect. But even when, like, for example, Paula was just saying, because I asked her, like, could you imagine me doing nothing? She said nope, or well, only if you
No.
are watching Dateline. Even I'm watching Dateline, I'm on a PC and I have it in the background like a podcast, and I'm doing like researches or doing housework. I always have something on, so I'm still paying attention. But I don't know. I just
Yeah.
yeah,
Also on my
I struggle.
agenda for today is to get my bolos caught up on
On the Discord.
Discord.
Yeah. Yeah, so if you haven't checked it out, check the Discord as the gavel drops. That's a great segue, to be fair. For that. Oh, Cutie Pie just came home.
Cutie
Hello.
pie!
Come here. Denise is on screen. Denise wants.
Yeah, Denise.
He can hear you through my headphones, Denise. Just like you know. There you go. There you goes.
Hey, cutie
Hey.
pie!
Don't hold my head down.
Yes. So yeah, it's on. Actually, that is another great idea. I've just put a poll up, because me and Garden bought Cutie Pie, aka Jed, as we had an idea to maybe start a podcast in the channel. What do you guys think? What do you think, Denise?
That would
Do
be
you,
fun.
that would be way too much fun. Can you imagine me and him on a podcast? My days.
That would be
So
fun.
we're talking about it, we are thinking about it, but it's still probably gonna be maybe after Lori Vallow's trial, because due to the time difference would be absolutely crazy, and we still need to
Yeah.
think of what we're gonna talk, because he's not really into true crime and I'm not into gardening, so we are on opposite interests there. So we need to come up with ideas and actually see what it's gonna be about, or it's just gonna be, yeah, absolutely crazy talk. Whatever. What else talk comes out of me? Nothing. So yeah. So what else, Denise? What else is going on that you want to share with us?
Not much. I was just gonna say I'm gonna jump off and let William or somebody else jump in.
Well, yeah. Anyone, the link is pinned, so anybody that wants to join can just join. Yeah, because we only have like I think 25 minutes until court starts again, because I think it's at 12 noon that they start. We might have a look. Well, we can watch 25 minutes of parole hearings because they're actually live at the moment, I think, or they were live. So probably could watch that. I don't know. I need ideas. I need help.
Well, I'm
let's
gonna jump off and go find something to eat because all I've had is coffee this morning.
Oh, yes,
So
definitely. Well, you can have coffee, cupcakes. That's food.
yeah, I don't have any cupcakes.
Oh, no. I need to send you some. But they will be there like 7 days in 7 days because post office is still over
Right.
here. And probably they would be all smush. But never mind. I'll let you go because I can keep you entertained for a long time. You better go because otherwise I'll talk your ears off.
Okay. I will see y'all in chat.
See you
Bye.
soon. Thank you. Bye. Oh, my days. Thank you, Denise. You okay? You still there? There you go. Oh, no, I'm joking. Thank you very much, Denise, for coming up. I really, really appreciate that. Hey, Iowa. I don't know. I mean, I can definitely carry on talking about absolutely nothing, or I think we're gonna jump on to the parole hearings. It's actually parole hearings verification. So it's like 20 minutes. So we're gonna just watch a little bit on that. I need to open the feed on my phone to see when they come up. Let me just do that. Give me a second. There you go. It's live on my phone, and I'm gonna share, and we're gonna watch some things. Hang on. Let me just set up this. Hang on. I need to add this to the stage. That's it. And oh, I'm in front of somebody. Hang on. Let me move. There we go. Right. So we just carry on waiting. For them to come back. So I was gonna say, because we are gonna be doing then Lori Vallow live, right? Well, I've decided, and you guys have convinced me. Oh, they might start soon. I can always pause.
Okay, we're reconvening at Avoyles Correction. Right this time. Raymond LaBoy Correctional. I'm old school. It's killing me today. And now we'll be hearing Mr. Dolph Finley. Mr. Finley, state your name and DLC number for the record, please.
My name is Dolph Finley. My number is 075033.
So it's a low number. Okay, Mr. Ziegler, I'm gonna put some preliminary information into the record. You're a second class, well, your rap sheet says you're a second class, your pre-parole says you're a fourth. But the rap sheet says you're a second class offender with a parole date. Looks like it was in 10/15/2014. And you have a full term date of 1/28/2039. You have no good time. You are serving a 29-year, 6-month sentence for a first-degree robbery. Does that sound correct?
Well, sir, that's not correct.
Okay, correct me.
I'm serving a 50-year sentence.
You're old 29 when you went back. Okay. All right. So the rest of it's correct?
Yes, sir, it's correct.
Okay, Mr. Finley. You have no speakers today, nobody here on your behalf or opposed. So tell us, what did you do to get yourself in there? And why do you think you should be let out today?
Robbed the lady. It was wrong what I did. I accept responsibility for that. I simply go out to the lady and her family as well as mine.
And so what did you do? You robbed a bank?
Yes, I did.
Okay. All right. What did you rob the bank for? I've been assigned the case, so I'm asking the question, so I'm going to start now. So why'd you rob the bank?
My addiction.
Okay. What have you done about your addiction?
Well, I've been to NE. I learned a lot. Since 40 years, I learned a lot.
That's what I was about to ask you. How long have you actually served in prison?
About 35 years.
About 35 years. Okay. All right. And so you haven't really taken any classes, just AA and NA?
Pre-release.
Pre-release. Okay. That's all you need. Okay, and you do need something. Says in it. But you were on drugs at the time all of this happened, correct?
Yes, sir.
What kind of drugs were you using, Mr. Finley?
Everything I can get my hand on.
Where do you live if you get out, Mr. Finley? We don't have any resident address for you.
Yeah, I send the plan up to my sister. She's supposed to send all that to the board. I have the same address I used before.
Okay. Okay, well, we hadn't heard anything from your sister and we hadn't received anything from her. So, well, that kind of makes it bad, but anyway, we'll move on from that. Did you have a gun when you robbed that bank?
No, sir. No, sir, just a word of mouth.
And you had a rolled up newspaper, huh?
That's why I called it re-robbery, because it wasn't a gun involved, it's just word of mouth.
Mhm. Tell me about that escape you had at Oakdale, the escape abscond. What happened there?
Never had an escape.
Okay, did you leave the state without permission before?
I was working offshore. And my job sent me everywhere. And the parole board knew this. They knew this already. As long as I was working, I had permission to go anywhere my job sent me.
Okay, so you ended up in Texas. Did you receive a drug charge in Texas?
Yes, I did.
Okay, did you serve federal time there or not?
Yes, I did.
How much federal time did you serve?
3 years.
Okay, and you know, you have a real poor supervision history. What makes me feel that you go listen to the probation officers this time? What has changed in your life that you think that you can abide by the rules?
I've grown and I learned a lot since then. I think my record reflects that also.
I see you have no write-up since 2004. Warden, do you have anything to add on him, on Mr. Finley?
Like you said, he's been with us since 2016 and he hasn't had any write-ups since 2004. He only has 5 write-ups in his entire record, so I commend him for his good conduct record. He got his GED while he was incarcerated, and he just mentioned that he graduates pre-release today. He's enrolled in NA, but other than that, he doesn't have any other programming. And we kind of talked about that when I met with him yesterday on how that's very important, that he really needs some programming. He is a Strive member and he works for us on the regular work squad. He has some good comments from his supervisor. Other than that, other than the programming, that's the only thing that I would recommend that he do.
Okay. You do have some law enforcement opposition. You have a chief that is very opposed to you getting out. I have no further questions. Does any of my colleagues have any questions?
I do.
Okay, Ms. Renatza?
Mr. Finley, tell us, why haven't you done programming? I know you're in pre-release and I'm glad you're finishing that today, but why haven't you sought out any other type of programs?
Well, I took the classes that was available to me at the time. What this institution provided.
All right, and before you got there, what about that?
Excuse me?
Before you got there, before you got to Raymond LaFord, you didn't do any programs anywhere else?
Same thing. You couldn't take certain classes.
Because of your sentence?
You have to have a certain amount of time to enroll in those classes.
I see. I understand. And tell us, you mentioned, I think, a sister. Where's your family today?
Ma'am,
Where's your family today?
they're not here today. They stay in New Rose, they have family in New York, in South Carolina. They're not here today.
And did they know you were coming to the board today?
Yes, ma'am.
They didn't want to do Zoom with you, huh?
Well, I don't think they knew about that. I didn't get a chance to tell them about that because I've been trying to call them and haven't been able to get in touch with them.
I see. And so your sister, you said your sister was going to send in a packet for us?
Yeah, same thing.
Where does she live?
In Lexworth.
Lettsworth?
Yes, ma'am.
And so that's where you were thinking of going?
Yes, ma'am.
Okay. All right. Well, I don't have any other questions.
I'd like to move for the executive session.
I'll second.
Okay, would you call the roll, please?
Ms. Renata?
Yes.
Freeman?
Yes.
Yes.
Okay, we're going to go into executive session to discuss some confidential matters. It'll be very briefly, Mr. Finley. We'll be right back with your decision.
Yes, sir.
All right, sorry. I can see that they went into executive meeting with what happened. I don't. Stephanie says I don't think that the telling the parole board what the parole board knew while you were going on a parole hearing probably is smart idea. Probably not. No, that doesn't sound very for. What does accept cookies mean? Oh, for the Discord, right. It just means that it's... I don't know what cookies exactly are. It's not cookies to eat, that is for sure. I've learned that in a hard way. But it's just... I think it's... oh, let me Google what exactly cookies are. Hang on. Cookies, internet. I don't know what cookies are. So it's small text files stored on a user's device by websites that you visit or applications, helping the websites remember information and personalize the user experience. So it's an optional thing. That's basically what cookies are, William. So yeah, I think that's another way to follow, or easily the case one has said. Another way to follow you. That is true as well.
Look, can I get a motion
yeah,
to come out of an executive session?
moved.
Ms. Calvin?
I second.
Okay, we've had a motion and a second to come out of executive session. Okay, Mr. Finley, this is what we're gonna do. We're concerned about the residence plan. And also, it already says you need some substance abuse training, which is required by law now before we can let you out.
Yes, sir.
So what I'm gonna do is, I'm gonna recommend that you go to Steve Hall for your substance abuse. And I would take a victim class while I was there and an anger management class.
Yes,
That
sir.
can all be offered to you at that place.
Yes, sir.
You pass that and you get out of that, and upon an approved residence plan, you will be cut loose. That'll give you 6 to 9 months to try to find yourself an approved residence plan while you're in that program.
Yes, sir.
But we gotta have a place for you to go before we can let you out, okay?
Yes, sir.
So, if not, work with, them and try to find another place to live if you can't live there. But, that's my vote today. So my vote is to grant, contingent on you completing a DOC substance abuse program and an approved residence plan. Mr. Knopfler?
Mr. Finley, I agree. The warden has recommended you need some more programs. I agree with her as well. So my vote is the same as Mr. Freeman's. Good luck to you.
Yes, ma'am.
And I concur with Mr. Freeman and Mrs. Renalson.
Okay, good luck to you,
Good
Mr. Finley. You've been granted. It's all up to you now. And thank you, Warren, for having us today. We'll close out at 10:48.
Thank y'all.
Thank you.
Sorry, Garden is on the phone. All right, sorry about that. I was just the garden bot was just making some phone calls for work, for his job and everything, but I thought of just coming back to to the scene because we have about 10 minutes for the Linda Stermer case restarted, parole hearings finished, I think for the day, I think, or for now, or they're gonna take a long break, I don't know, but we only have 10 minutes, so we can chit chat a little bit about. So what we're gonna do is, I tried to explain through message, but probably did not work that out. What we're gonna do is, we're gonna be here with Linda, if they are on stream, until 10 to 2 p.m. Eastern. All the times that I'm gonna say it's Eastern times. So until 10 to 2 p.m. we are going to be here with Linda Stermer to do like jury instructions or whatever they are doing for the case, because I don't think they are going to start closing straight away. I think they are going to take a break, the lunch break, and then do that. So we're gonna see what happens. If they stay on during lunch break, we're gonna be here until 10 to 2. At 10 to 2 we're gonna go to the new stream of the Lori Vallow case. We're gonna be watching that live, and when they start deliberations, if we are still while Lori Vallow case, I'm gonna put the clock on, the timer on, and count that. And then during on the lunch break for Lori, we're gonna be doing closings for Linda and try to catch up, because then we can speed up, and hopefully that will work out. But if a verdict comes throughout Lori Vallow case, obviously, as always, we're gonna be pausing Lori for a minute or two while we hear the verdict for Linda, and then resume Lori. Just for the fact that if there's a verdict, I can have the data off tomorrow, and just for that. So honestly, so yeah, what do you guys think? Yes, no, maybe you don't like it? Because I'm really thinking about having the day off to tomorrow, and having that, it just like making like, I love doing this, don't get me wrong, but it's making me happy. I will find something to do. I might even do a video or two, because there's a case that I want to do a video on, and I can probably do that. I know it's still work, but you know, I still keep you guys entertained somehow. No, but that's just like my plan to do, and I hope you guys understand that and agree with that, I guess, in a way. So yeah. Aw, thank you, do no harm. I appreciate that. I really appreciate that. I do really do. And I'm excited. Like because the weather's still gonna be nice, I think. I'm planning to go outside, catch some sun, walk in the park, do maybe like a video for you guys for Sunday, for the members video. So yeah. So yes, chat agree. I know, chat agree on the chilling thing. I might play video games actually as well, because I and chill and watching something at the same time that I'm playing video games, because otherwise I would be too bored. So I am setting up the extra camera for the trial, for Lori Vallow's trials. I am doing that too, because we're gonna have the on, but I don't know if because of the counter. I know lately I haven't been on with the counters, and I apologize, but it's just because I've been using garden bots. Sounds delicious. Uh, I've been using garden bots computer for the counters and everything, and sometimes he does use it. I am in the process of getting my new computer, but it's gonna take a minute or two. So 1, 2, 3. Sorry, I'm just counting something of how many sidebars and legal advices Lori has had since we've been counting manually. So 1, 2, 3, 4, 5, 6, 7, 8, 9. So 9. So 1, 2, 3, 4, 5, 6, 7, 8, 9. Okay, that is updated. I need to see something behind my monitor. Hang on 1 second. Okay. Sorry, I'm just setting up things so the things are ready for the Lori Vallow case. Sorry. And then Garden bought the phone. So yeah, so we have about 5 minutes for the case to start. I don't think they are gonna start closings or jury instructions right now. I think they are gonna come back, send the jury on lunch or whatever is happening, because they did not say anything about lunch. They said they were gonna order something, and then order and not order, it takes time. So I think they are gonna take a break now, another break, and then start during closings and everything at after lunch their time. And if they do, we are gonna be I'll be finishing this stream there, redirect everyone to the Lori one, and start Lori when Lori starts. So that's the plan for at the moment. I don't know what's gonna happen. I wish I could now. But whoa, hang on. Are we live? Yes, we are live, but we don't have sound because they play music. I do have a Michigan shirt on. You someone realized. Yeah, I do. Grand Rapids. Yeah, because it's oh, actually no. It does say Minnesota on it at the in the bottom part. It says Minnesota. So is there two Grand Rapids? But we can pretend it's Michigan. This is actually Garden Pot's t-shirt, not mine. I just stole it. But Zizzy, are you zooming in on me? I don't like. No, I'm joking. So yeah, is there a Grand Rapids in Minnesota? Does anyone know? Because it does say on the bottom of the shirt, says Minnesota in it. Says something there, but I can't read it upside down. So zooming, no. No, Minnesota, the best state for children. Well, I don't know if there was the best. Oh well, I did not. I don't know either. I'm just looking of what it says on the shirt. I don't have absolutely a clue. I walked by the front of the dryer and looked at the TV. Ooh, see, hello. Yeah, it does say it's Minnesota. Maybe there is. Oh, I overslept the bus, so my grandson is all the oh nice, yay! That is awesome. We get to spend the day. Oh, okay, that is good. That is good. Good education and medical care. Well, that's good. Well, it could be a good thing. It is a good thing oversleeping. So, you know, it happens. Now you get suspended with you. It's a longer weekend. Well, it still does. They still have Friday tomorrow. Sorry, just getting ready because court is resuming in about 2 minutes. But there's still nothing. There's still Linda. Oh, I need to move myself back to my other corner. I need to go to my own little corner. Back again. There we go. I'm back. So yeah. Oh my days. Oh yeah, Lois actually reminded me. I went and rewatched the Nancy Joe testimony of the Lori Vallow case because I did miss some part of that testimony, and oh my days, Lori was so annoying. I'm sorry, but she was annoying. On that cross of that witness, my husband. Like the thing that annoyed me the most, I think it was she's saying my husband all the time. It was not your husband anymore. You were with Chad. You were more interested in Chad than Charles. Because if you were interested in Charles, you wouldn't be with Chad. So it was very annoying, but she's trying to create, I think she's trying to create an empathy thing with the jury by saying my husband, but she doesn't believe that. That is my theory and my opinion. Because she doesn't care about Charles, about him being her husband at the time, because she was more interested in Chad than in anything else. So that is just a jury tactic that she learned from her legal advisors, not that she came up with that on her own. And some of her questions were absolutely oh yeah, she's failing. Oh yeah. Like absolutely everything. Like there is no question about it that she's failing, that it's absolutely a show. So she is very annoying. Case one in it for saying that. I don't. I cringe every time she says that. "Oh, my husband," and then the voice that she uses is just. Yes, definitely gonna have a grammar day. GSD God's mom, that's awesome. That is great that you get to spend time with your little one. So that is awesome. That's fantastic. He's precious. Oh, that is so cute. Cute. I'm sure he's the cutest little thing ever. Not that he's little, because I know he's 15. You did tell, but yeah. Oh, you can question the witness. I know, Susie. She said I can question the witness if you are, manners, Lori. But she doesn't have those. I think she missed that class. Uh, I think the judge goes home and he has a private laugh about it because only because he can't take her serious. Oh yeah, I'm sure she will. Is Charles' sister gonna testify? Because she's been in court though. So I thought they were under that witness suppression thingy that you can't be in court before you testify. Only you are released. So, yeah. Don't flatter yourself. Thanks, William. um, yeah, in the voice from absolutely. Absolutely, indeed. Oh, yes, she's testifying. Wow. Oh, sorry. No, hang on. That one. Oh, my days. That is hilarious. Oh, Court should be coming back soon. I don't. Oh, the music that Core TV has is making me want to sleep and go to the facilities again. I don't know which one is like. I'll show you guys. Can you guys hear that song? The music. That music. It's absolute. It's like putting me to sleep. Oh, hang on. So I was wrong yesterday. JJ was Kay's sister's child, Charles' great nephew. I am confused by that. Oh, yeah. I like my music better. Not saying anything, but not to flatter myself, William. But I like my music better. Oh, Stephanie, that's hilarious. Church music. I was like, and I don't like that at all. The more Lori talks, the deeper. Oh yeah, definitely. She's opening doors that she got told not to open. That could be bad for her if she would open, and she's just opening all the doors. Like, I love Garden Bot. Right, don't get me wrong, but every time that he goes to the wardrobe, he opens all the doors and lifts all the door opens. That's what Lori's doing. Opening all the doors and lift them open. Like, literally, there's no way other. She's opening, why? Case one, I don't think we'll ever know. That's sadly why they, yeah, I think that's sadly, the response. They were in way of what you wanted to do with Chad, and that is very, very sad. So yeah. The Susie says, case one, the theory is that Tylee knew about Charles and was starting to ask questions, and I think she might right. I think you are right. Tylee knew, and then JJ was in a way, so as well. So I absolutely agree. I can't understand either, but sadly, some people's minds are so ingrained in certain things that there's nothing you can say to change them, and not even the more logical thing. They change, and then they do things that are horrible, aka that's what they did. So yeah. Oh yeah. It's it's complicated. Yeah, probably. Yeah, indeed, agree. They did not have to want the responsibility. They wanted to do their whatever cult thingy they were into, and they did not want any responsibilities, and that JJ and Tylee were in the way of their of their happiness. So yeah, it's just complicated, you know. Some it's just, yeah, that is just complicated when you involve crazy non-logical beliefs that don't have any whatsoever foundation in things. um oh yeah, definitely. Oh, definitely. And the thing is, she thinks, right, even if she gets not guilty for this case, which she's not gonna, just say in the eventuality of it, if she takes that, there is no saying, there is no way that she's gonna go free. She thinks that she's gonna go free. No, darling, you're gonna go back to Idaho and continue to serve your life sentences, darling. You're not gonna go anywhere. It's just the fact that what it is one more conviction for you. That doesn't mean anything if she gets found not guilty. She's gonna still serve her life sentence back in Idaho and suffer her consequences. So she just wants, definitely indeed, attention. That was exactly what I was gonna say. She just wants the attention and put on in the show and make. I think she's using this to still kind of put her message out there in a way, but probably, yeah, revenge tour, definitely, yeah. No, case one, she still has another trial after this one for Brandon Burdo, so she still has another last grand trial thing and one more to go. She still has another trial to go through. So it's just wild. But I get it that Charles and Brandon, they do need their justice individually, because I think Lori, yes, is the woman version of Charles Mason in it. Yeah. So she still has one more to go. She's not done yet. After this trial, there's a trial straight after, like a month after or something. So absolutely crazy. Yeah, exactly. Justin needs to be served for Charles and for Brandon, and I absolutely agree for that. It is a cost, yes, it's a massive cost. But even with me being in UK, I would pay taxes in America to keep these kind of people behind bars for a very long time and not have it ever have the possibility of getting out. So those I definitely agree. So um I have a fear, guys. I have a big fear. I have a fear that they are not coming back. I have a fear that they not gonna come back. Oh my days, there's so many live people. That I don't even know where I am. No, not this one. I have a fear that they are not coming back. No. I don't know. It's just a fear that I have. Um, that they are not coming back until, yeah. I don't know what to do. I absolutely don't know what to do. Absolutely no. Um, yeah, yeah, indeed, yeah. So it's, oh my days. It's she's been, oh yeah, she has definitely been busy for sure. Indeed. You're not afraid of what she found not guilty, or um yeah, I think Chad was the one that influenced Lori, because I think he was already cuckoo land in the cuckoo land, and I think them two feeding out of each other, feeding off from each other, made things completely hard and everything. Because I think something she started to change according to several things that I've listened, exclusive from Colby. I think it's Colby, her son, the one that has a YouTube channel. He's been saying she started to change massively, even more when Chad started to be in the picture, and she started to listen to Chad's lectures or whatever he did. So I absolutely agree. Um, so yeah, that is absolutely agreed. None of it. um, hmm. So, what are we gonna do? Are we gonna carry on? I don't know what to do. Um, do you guys want to finish? I don't know. They are just like, well, yeah, okay, all right. Zizzy made the decision for me. We'll wait for what is gonna happen, and we can carry on talking about Lori and talk about crazy Lori, and give her a little bit more of time shares, because that's what she needs. But the thing is, guys, I'm gonna be very honest, and I'm gonna be very upfront with you guys and everything. I'm having lots of fun covering the trial for Lori Vallow, this trial, and covering this one. It's been good, even though it's been hard because of the candy. Yeah, definitely. I'm having a lot of fun covering it. I don't mind the time difference and at all and everything. It's absolutely great. But the Brandon Burdo case trial that Laurie's gonna go through after this one, I think it's in May or June or whatever, I am not gonna do it. The time difference, it's absolutely killer for me, and for the fact that we've already seen the show once, we don't want to see the show again. It's gonna be exactly probably the same thing. I know Brandon needs justice, and I hope that the creators do follow that case and cover it, because it definitely deserves the same type coverage that Charles is having, and he deserves justice indeed, and I'm there for it. But the time difference is a lot, and at that time my shop is not going to be letting me to work through the night, because they are only doing night shifts now, because the shop is having some work done, which very good coincides to the time that Lori has a trial, which is amazing. That's why I've been doing nights. But on that case, it's gonna be absolutely a killer, and I do apologize, but the Brandon Burdo case, we might do some recaps or anything, or here and there we might talk about it. We can talk about it in chat, in like when we are like chilling and everything, but sadly, I am sorry, we are not going to cover it live. I do apologize, but yeah, that is just a decision that I had to make. But yeah, I thank you for guys for understanding. I really appreciate that, and I really appreciate you guys understanding that. But that means we are definitely gonna cover is the Donna Adelson case. That trial, it is on my list. We are going to be covering that trial for sure. I need to start doing some research on her, compile some information, what I can get it and what I cannot get it and everything. So I definitely I know, but it's my completion of perfection thing that I have, that I have to cover everything and do everything, but I need to realize that I can't, and I have to mind. So yes, Wendy next. I think Wendy is gonna be next. I'm sorry, but Wendy's gonna go down. But for sure, we are going to be doing Donna Adelson. That is absolutely for sure. We're going to, because Perfect is from Florida. Florida is perfect time for us to cover. I know we spend a lot of time in Florida, but hey, Florida does provide a lot of entertainment. But for sure, we are going to be doing... we're gonna be there with you, Zizzy. We're gonna be in the pool with Zizzy. No, I'm joking. But yeah, the whole family. That's wild. I don't know how the dad hasn't been charged yet. I mean, he's just maybe just he's still probably at airport, like Kathy says, lost, not knowing how to return. What? Oh yes, Donna is a whole vibe. Credit LTWM. Was that? Now I'm interested. Lawyer? No, it's not Lawyer that you know. It's not Kathy. It's I'm interested. But yeah. So we're gonna be definitely doing Donna Adelson. Oh, and then in September, that's another trial that we are gonna do for sure. Is the Steven Stearns trial, not the CSAM, but the Unaliving, the Red Rum trial that we are gonna do for Steven Stearns. So, oh yeah, he was clueless about it all then. Okay, yeah, he was like, huh, what happened, Keith? Yeah. I forget his name. I even forget his name, bless him. I know Florida gives us a lot of entertainment and court cases to watch. That is indeed for sure. Not a bad place. He has his good things, I'm sure. He has the weather, has Disney World, has Lois at the moment. Uh, Florida has great people there. Oh, Lot Talk with Mike. Yes. Oh, him from Chicago. I love that intro. I love his intro. I love it. I miss it. I need to catch up on some videos from him, actually, but I really like his intro. It's so cool. His intro that oh yeah, they are gonna have definitely a lot of fun. He has his CSAM trial coming up, but we are not gonna be covering that for sure. The material is absolutely crazy. But the Red Rum trial that is gonna be in September. Oh yes, we are gonna be definitely for that. Me. Definitely. So that's another trial, and there's the little trials that also I really want to watch. Is hilarious. Is, have you seen him, the videos that he actually is in court as well? Sometimes he does stream those like cases that he is so I really like that. I there by my days, my content, I have a lot of people that I watch. I do need to catch up on some videos. That's probably what I'm gonna do tomorrow. It's just catch up on videos. That's I have my my watch later playlist. It is crazy. It's absolutely insane, that list. Because it's very long at the moment, because I see like they recommend a video and I will like, ooh, let's watch later, watch later, watch later, watch later. So it's very long at the moment, but definitely I need to catch up on some of those videos. Court is still not back. We're still waiting for court to come back. There's still nothing. It's been about 20 minutes. I don't know if they're gonna come back. This is weird. So if you want to actually, by the way, if you guys want to suggest any trial, please do so either on here, on chat, or on Discord, or on Facebook if you're on there, or you can just email me. I do have an email. You can reach me out. I think that is the command for it. You can reach out to me, and or even if you want to talk about something, you can reach out to that email address. I'm always available to try to talk to you guys, so you can just reach out, or if you have a suggestion of a trial, yeah, just tell me. As long as, well, the time zones that we normally cover is Eastern and Central. That is normally the time zones that we normally cover. It branches quite a lot of states, but because of work and everything else, that those are the two main time zones we cover, Eastern and Central. That is because like Central is 6 hours. We are back. Are we? Where? Port? Huh? Okay. Why is my mouse being dumb? Ah, my mouse is being dumb. Hang on. Oh, yeah, we are. Thank you, Lois.
3.2, presumption of innocence, burden of proof, and reasonable doubt. 3.3, defendant not testifying. 3.5, evidence. 3.6, I'm sorry. 3.4, what's, I don't have that in mind.
3.4.
I don't have one. Okay. I don't have that in the list. I don't know offhand what that one is, but. Are you just mentioning that because I skipped a number? Or,
Yeah, that's we just got to do.
okay. Did,
3.4 is impeachment by prior conviction. We had none of that.
oh, so 3.4 doesn't apply? Okay. 3.5, evidence. 3.6, witnesses' credibility. 4.1, defendant's statement against the defendant. 4.3, circumstantial evidence. 4.5, prior inconsistent statement used to impeach a witness. 4.7, stipulation. 4.9, motive. 4.10, transcript of prior testimony. 416, intent. 5.2, weighing conflicting evidence, number of witnesses. 5.3, witness who has been interviewed by a lawyer. 5.10, expert witnesses, and that single instruction applies to all those who testified as experts in this case. Demonstrative exhibits. 5.11, police witness. Then we move on, counsel, to the elements of the offenses. Initially, I'll note that after discussion with counsel, it's my understanding that counsel are in agreement that as to counts 1 and 2, the jury will be provided with the option of the lesser offense of second-degree murder. Is that correct, counsel?
That is correct, Your Honor.
Yes, Your Honor.
Okay. And no one has requested manslaughter instruction of any sort. Is that correct?
I am not, Your Honor.
Am I correct, Mr. Kelly, that there's no request for a manslaughter instruction here? Is that correct?
Yes.
Okay. Okay, so elements of the charges, count 1, and then we're including the lesser of second degree. Count 2 elements will be provided. Felony murder, again, on that count. After discussion, we will be providing the lesser of count 2 on that one. Time and place venue. 16.21, inferring state of mind. 311, deliberations and verdict. 313, penalty. 314, communications with the court. 315, exhibits, and we're still awaiting some of the defense. And exhibits, counsel will need to get defense. I think we have all the prosecutors, but you will need you to gather up the exhibits that have been admitted.
Your Honor, we do have a tote sitting behind me then of all the physical evidence.
Okay.
So if the jury, or we'll turn it over to the custody of the court.
Yeah, we'll get it in the jury room. So as soon as possible, once we're done with closing arguments and we get the case, get the jury in the jury room, if you could help us figure out where your exhibits are so we can get those to the jury. Written instructions, 316. Single defendant, multiple counts, more than one wrongful act, 320. Verdict form, 323. Counsel have been provided with the verdict form we intend to provide to the jury. The record sure reflects too, we did have significant discussion about the unanimity instruction, and I think everybody came to the conclusion that the way the charges are presented, that it was maybe more confusing than anything for the jury, so we're not providing that instruction. Is that a fair summary?
Just that we're providing the standard instruction. I think what we talked about is that we took away the unanimity instruction that we thought pertained to open murder, but we kept the standard unanimity instruction for both counts.
Correct. Is that your understanding, Mr. Kelly?
That's correct, Your Honor.
Okay. So counsel, and you both have I know we talked about a couple different verdict forms. You both have the final one we intend to use for approval?
I have the one that we've discussed. I don't see one attached in here. If it's the same one that was discussed prior to our break, or at our break, then I do have it.
Okay, it is that same one.
Okay.
Just have a copy here.
Let's see. should be back at his desk. One moment, we're going to gather that form just so we're all looking at the same item. While I'm waiting for that verdict form, to the media who's here, there's going to be a point where we release jurors. So I would prefer if you could not film that part when we're releasing the alternate jurors in the case, okay? And then if you want to, I think after that, we'd just be doing, and then after that, we're pretty much sending the jury off, so. But there's your heads up. I don't know if it's just a click or what, but. While we wait for the verdict form, Mr. Mueller or Mr. Kelly, did you have objections to the ones I intend to provide, or did you have special instructions or other instructions you're requesting?
Yes, Your Honor. As we noted, we requested a spoliation instruction, adverse inference instruction with respect to the in-car video from Deputy Russ, which was shown, we showed in plaintiff's exhibits, 10 pictures taken over 9 seconds. Deputy Russ said it was from his in-car video. He didn't know where it went. The prosecutor apparently doesn't know where it is. It's never been turned over to us. Our argument is that clearly a video is way better than 10 pictures over 9 seconds in terms of showing in real time the progression of the fire. As the court knows, one of the big issues in this case is the speed of the fire, where the fire was located initially. So we think because it's the obligation of the prosecution and the sheriffs through the prosecution to turn that over in discovery, we've been hamstrung by that, we've been prejudiced by that, and we would request an adverse inference instruction that had it been produced, it would be disfavorable to the prosecution.
Thank you. Prosecution response?
Your Honor, what I can say is this, because this is kind of encompassing a discovery issue as well that I think we've actually talked about before. This video back in 2007, and if we have any question about that, actually Detective Romeo here can speak to that as well. They use VHS tapes in the patrol cars. I understand Mr. Gruss maybe not have been very clear on that, but they use VHS tapes that were reused and recorded. I can speak to that. Even in 2009 when I started here, VHS tapes were used because I used to get them in cases. And unfortunately, those tapes were reused and were sometimes corrupted and didn't work properly or whatever. My understanding is these stills were taken from the videotape because the videotape itself was not in good working order. And that's why we have where we're at this point in time. They are a representation of what was on that videotape. It is all we've ever had in our possession since we took over, Ms. Zyderby and I took over this case, and even prior to that, the original case file that we had in our office never had that videotape. I've been through all the evidence of the Sheriff's Department. There are other VHS tapes present there of different interviews and things, but this videotape has never, ever been located. All we've ever had is still photographs, which have been turned over as part of evidence. In the case from the onset, there is, I don't think there's any justification for a spoliation or an adverse instruction against the people. There's no legal justification, no case law in support of this, and I don't think it's appropriate for the court to give such. Thank you.
Thank you. And I think you were indicating those were, instead what you have are these 10 photos that were taken
Yes.
over how many seconds?
9 seconds.
9 seconds. Okay, the defense is requesting a special instruction as it relates to this video. The court finds that, that I'm not going to provide the instruction. The defense has not demonstrated to this court that the government acted in bad faith in any way in failing to preserve the evidence, or that the nature of the evidence was such that the defendant would be unable to obtain comparable evidence by other reasonably available means. The court is citing People v. Kress reversed on other grounds. If the court uses the missing witness instruction, then the issue is whether the prosecution exercised due diligence. But in any way, in any event, under either standard, I find that the defense has not met its burden to get the instruction.
May I give a 30-second response, Your Honor?
No, thank you. And counsel, in the meantime, did you get the?
I've not seen an
Okay.
email.
Oh, it should be on the verdict form?
We have a written one, but I don't.
Oh,
have
you
one.
want an email?
Yes, and
Okay.
he said he emailed it, but there's nothing coming up.
Can-
You want me to forward that email to you, Wolf, that I got?
Please.
Oh, wait, Jay might be on the case here.
Yeah, it was sent to all of us.
It's not on your emails?
I have it.
We just,
Okay.
he just.
I just forwarded it to Mr. Mueller, hope maybe it was a.
And this is the one do you have it yet, Wolf? On your email?
I don't have
Oh,
it. I think
you
Joe
just
was
need it on
email
your-
it. Said he emailed it, but I haven't seen it.
Okay. So I think Jay just sent it to you, because you need it for your closing, right?
I'd like to have
Yeah.
it loaded up. No, I'm going back to before noon, Your Honor.
No. I think Jay's gonna try to get
I
it.
did, I just emailed it,
Here we go, I got it.
Okay.
Defense, are you good with the form of the verdict form, providing the option on each count of not guilty, guilty of first degree, or guilty of the lesser offense of second degree?
Yes, Your Honor.
Okay. And I know, Wolf, you're waiting to get yours.
Just 5 minutes real quick.
Okay.
I got the email, I'm just trying to,
You put it into your
please.
PowerPoint or whatever, okay. The jury has pizza, so they won't mind.
Thank you, Your Honor.
You good?
I'm good. What's that?
Do you have what you need, Mr. Mueller? Are you good?
I'm good, thank you.
Okay. Anything else, counsel, before we bring in the jury for closing arguments and final instructions?
I have nothing, Your Honor.
Anything else, defense?
No, Your Honor.
No? Okay, we'll bring in the jury.
All right, so we're gonna have closings now, and we're gonna have instructions now. So we're gonna stay on, and we'll do probably Lori Vallow on this stream. So I'm gonna have to delete the other stream. We're gonna do here until about 5 to 2 p.m. Eastern. For the next 1 hour and 10 minutes. Yeah, 10-ish minutes. And then as soon as Lori starts, we'll move to Lori, and then go from there. So, and then depending on what you guys want from the verdict, we'll do what we do. Okay? We'll do that. I am trying. Oh, thank you. I am
Welcome
trying
back,
my
jury.
best.
As I indicated, we are now at closing arguments. Inside of you.
Good afternoon. First of all, I want to take this opportunity to thank you for your time and your attention over this very long 3 weeks. It's obvious you've been paying attention, and the questions were very thoughtful questions, and we appreciate that. So, what is the closing argument? Closing argument is an opportunity for us to rehash what you've heard, kind of condense it down. It's been a lot of information, a lot of witnesses, just a chance for us to summarize. And it's also a chance for us to give you our theory, what we think happened. So let's jump in. We talked in the beginning, I think in our opening conversation, about the two charges. We have a first-degree murder and we have a felony murder. 2 counts. That's what you're going to be deciding and looking at. So again, going back to the boxes that I have to check. That's what we talked about in voir dire, right? Those boxes, those elements. So you can see on the screen what the elements are. Defendant caused the death of Todd Stermer. Defendant intended to kill Todd Stermer. That the intent to kill was premeditated or thought out beforehand. And that the killing was deliberate. There's some definitions there, which you will have. The judge will give you all of this in writing, but that's really breaking it down to the simple form. Let's take a look at count 2. That's your first-degree felony murder. 3 boxes I need to check. First, that the defendant caused the death of Todd Stermer. Second, that the defendant had one of 3 states of mind. She intended to kill, or she intended to do great bodily harm to Todd Stermer, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would likely be the cause of her actions. And third, that when she did this, when she caused the death of Todd Stermer, that she was committing or attempting to commit the crime of arson. So those are your 2 counts. But within that, we need to take a look at arson, because that's part of that last element. So what are the boxes for arson? That the defendant burned a building, that at the time of the burning, that the building was a dwelling house, was a residence. Third, that when the defendant burned the dwelling, she intended to burn the dwelling. And again, there's a little bit more description there, which you will have a copy back in the jury room. But that's broken down simply. Those are the boxes. So, let's talk about the evidence that you've heard now for 3 weeks. Because every witness is only one piece of this trial. You are the fact finders on whether these crimes were committed. And it's taking all of the evidence into account. So let's take a minute to look at the evidence. First of all, you heard from Sandy Stermer. She's the mother of Todd Stermer, victim who died in this case. Todd and Linda were not in good financial standing. You heard lots of testimony about that. The loans, being behind on bills, never able to pay the bills. Sandy talked about how Todd was in good shape. He was an athlete. There was discussion about how he was a coach. Todd built that house that burned on January 7th of 2007, and Sandy described her son as a perfectionist. Linda relayed little detail or facts about that fire to her in the stories that she ever gave Sandy. Twice, Linda said she went out the basement door, and once she said she exited out the front door. You next heard from Tony Evans. Tony, Deputy Evans, was the first deputy to arrive on scene at that residence on County Road 215. He observed the Stermer residence to be on fire. Flames were coming out the second floor and the smoke was going up. It was an overcast day. No issues traveling down that driveway. Hadn't started raining by the time he got there. Found Todd Stermer laying on the north side of the house. So as you're looking into the house, to the right-hand side. He was badly burned. His skin was slipping off his hands. Defendant was laying on top of him. He described it as face-to-face. And he had to physically remove the defendant from Todd Stermer's badly burned body. Todd had lacerations to his head and to his back, which you have then the autopsy, a copy of that, as well as pictures. His pants and his underwear were down to his ankles. Had his socks on. Deputy Evans used a plastic, he described it as a plastic molded sled to move his body to a safer location because of that fire, that fuel tank by the house. That was the fuel tank for the furnace. And when he was on the property, that's when he noted a van still running, smoke coming out of the tailpipe, parked in the rear of the residence. And that's when he saw the blood that you have the picture of, and he put a flag on. Tony took several photographs, of which we put several up for you, and they are admitted into evidence. He was able to follow a set of tracks. And he marked them. You can see you've got the left tire here, and you've got the right tire here. Same here, you've got the right tire and the left tire. He's able to follow that set of tracks through the area, right through where Todd was originally located. Those tracks led directly to the van that was running. You heard from Deputy Gruss. He was the second deputy to arrive at that Stermer residence. He arrived to the residence fully on fire. You can see by the picture what he saw. He attempted to render aid to Todd. He also observed Linda laying on Todd. He also stated he saw Linda's hands on Todd's face. He assisted in moving Todd and performing that aid on his badly burned body. He had an opportunity to speak to Linda Stermer, the defendant. Her statements at that time, where she was downstairs doing the laundry, heard Todd yelling and screaming, ran upstairs to the main level, and it was full of smoke. She was yelling for Todd. She tried to go up the stairway, but could not get through the fire. So she ran out the front door. Later, she saw Todd in the yard. She got in the van and she drove around to try to get Todd help. You then heard from Dr. Musali. He testified that he was one of the neighbor to the Stermer residence. He saw the fire and he drove to the residence. I believe he said him and his sons were outside doing some chores. They got in a car, drove down to County Road 215 and drove up the driveway. He also discovered Todd in a badly burned state. Todd was laying near the house. He also said Linda was laying on Todd. And he helped move Todd in what he described as a small plastic John boat. And he also attempted to perform aid on Todd. You heard from Annette Crandall, a friend of the Stermers who responded to the scene as soon as she saw the fire. She sat with Linda at that scene, and she then said that she talked to Linda days after the fire, and Linda had told her that she picked Todd up and leaned him against the front bumper, and that's why there was blood on the van. You heard from Steve Leach, also a neighbor of the Stermers. Saw the fire, drove to the residence, lives right by it. He also described how badly burned Todd was. He also talked about how Linda had to forcibly be removed from Todd. Not once, but on 2 separate occasions. He talked about how he attempted to render aid to Todd's badly burned body. He talked about how he helped move Todd away. And he stated, actually he was the Lawrence fire chief at the time, that he smelled fuel about Todd's person. You then heard from Mike Matheny, the direct neighbor to the Stermers. He testified that he was leaving his residence around 3:30. He went bowling at 4 o'clock on Sundays. He drove to the Stermer residence, and this is key. When he drove into the residence, he saw Linda in the van in the driveway. So we've put up a drawing here. You're coming in this way towards the house. He's coming towards the house and he sees Linda in this area. And he says, as he's driving down the driveway, what does he see? He sees her back up the van and immediately drive to the north side and around to the back of the house. He stated he parked his own vehicle, went down behind where he saw the van going, and shortly after, as he's approaching, he sees Linda out of the van walking away from the van. He kept asking for Todd's location. Where's Todd? Where's he at? And Linda finally said, there he is. Todd was unclothed when he saw him. He ran to his vehicle to gather some clothing to cover Todd. He talked about just grabbing some of his items that he had, some hoodies, some coats, of which then you'll also see physically. You have the physical evidence of it, and it's talked about in lab reports. He helped move Todd away as well from that location by the fuel tank. You heard from Connie Calhoun in her emotional state. She also testified, she was living with Mike Matheny at the time, that they had bowling on Sunday at 4, and she left about 3:30 out of their residence. And when they were leaving, they saw the smoke when they left their house. She testified that she drove up that same driveway as a passenger in that vehicle with Mike Matheny, and she saw Linda in the van. She stated Linda's van was facing out towards the road. As they're driving down, Linda's driving out, they're facing each other. She then stated Linda's van then turned around and went to the back of the house. She got out of the vehicle, and the next time she went up, she saw Linda laying on Todd. You heard from Kim Thompson. Kim arrived at the scene of the fire. She's a friend and a neighbor to the Stermer family. She was just trying to go and help. She saw Linda for the first time that day on the hill on the north side of the house. Both the family dogs were outside. I think she told you about how they had to try to help catch the dogs a couple different times, or at least one of the dogs. Linda told her that she heard Todd yell, "The house is on fire." Then Linda opened the door, opened that basement door at the top of the stairs, and went outside, and she didn't know where Todd was. Another story that Linda told Kim was that there was a kerosene heater located near where Todd's chair was. in the living room. In a third story, Linda claimed that Todd may have fallen asleep and dropped his roach. She told you that she took possession of both of those dogs and cared for them after the fire. You then heard from Ken Thompson, her husband. He remembers it being an unusually nice day for that time frame in January. He'd been out cutting wood across the street, spent most of the day there. He had gone past the Stermer residence 15 or 20 minutes before on his way home after cutting wood. Said he didn't notice anything out of the ordinary. Got home, heard about the fire on the scanner, and immediately got in his car and went back to the Stermer residence. Todd was on the north side of the house when he arrived, and he again described the injuries that he saw. Linda told him that she was downstairs doing laundry, looked up the stairwell and saw fire, too much fire to go upstairs, and she ran out the basement door. You heard Dr. Michael Markey, the forensic pathologist. He talked about how when he received the body, that Todd's body had the socks, the two socks, the underwear, and a shirt across the groin, and that's in the report and detailed in the report. He preserved those items and turned them over to law enforcement. He, as a doctor who does autopsies, had no opinion as to how the blunt force injuries occurred, other than Todd received blunt force trauma. And he described what he looked for and why he made that determination, and how he looked for particular patterns and didn't see them. And so all he could say was a blunt force trauma where the skin splits. Didn't know if the injuries happened before the fire, after the fire, or what caused them. He also couldn't tell the order of the injuries, just based on the body and looking at the body and examining the body. Couldn't tell what injury occurred first. He said that the burns to Todd would have caused severe pain. And that's common sense. When your skin is slipping off your body, that it would be painful. He also talked about the toxicology, which is on this bottom area here. Oops, sorry about that. He talked about the toxicology and about how in the blood they found caffeine, and it was negative for other substances that they screened for. And then in the urine, he found the hydrocodone, hydromorphone, and it was negative for anything else they screened for. And what's important to remember is he couldn't quantify the amounts. He could only tell you that they were above the amount that they screened for. We don't know how much of that drug was in the body. He also talked about 4 distinct lacerations in the head. He talked about 1 on each side, 1 on the top, and 1 in the back. And that's also in his report. He did say, upon questioning, and agreed that it would be consistent with injuries from being hit by a van. And he also said that the lacerations would be consistent with being hit by a blunt force object like a frying pan. You heard from Mr. Jim Shinsky. He gave the first detailed interview, or conducted the first detailed interview with Ms. Stermer about the fire. We talked a lot in voir dire about what do you do when you have inconsistencies? How do you get to the truth? What do? You start asking more questions. We talked about it in voir dire. Those were the answers you gave me. I ask more questions. It helps me get to the truth. One juror in voir dire, I asked a specific question about, well, what do you find when you start asking more questions? Their answer was, well, sometimes you get blame shifting. Sometimes you get blame shifting. Mr. Shinsky conducted detailed questions, started to dig into the inconsistencies. Linda discusses the morning of the fire, and she gives details about seeing that fire and events that lead up to that fire. And there is a transcript of the interview that you have, the entire transcript to review while you're deliberating. This is where she begins to point blame at Todd. I'm not going to bore you with the entire transcript, but I am going to give you a 2-minute recitation of the high points. Filled up the blazer, came home, he got up. She gave him receipts. He got angry and was screaming at her. Went downstairs and woke up boys, told them to go to the mall because her and Todd needed to talk. Went upstairs and made Todd breakfast. He ate and took meds, and they didn't discuss much more. He sat down and started watching hunting program in living room. She did some laundry and some dishes, came upstairs and read an acne instruction booklet. Must have fallen asleep. When she got up, Todd asked for juice. She took him more medication. I told him I was going downstairs to do laundry. Todd was yelling at me. And then all of a sudden she heard him scream. She went running upstairs. There was fire from our bedroom to his recliner. He was on fire, his whole upper body, and there was fire and smoke. I just turned and ran out the door. She jumped in the van to go to Mike and Connie's. She backed up and saw Todd in the yard. She got out to try to help and get fire off of him. Later in the interview, he was screaming. We had been arguing quite a bit. We were arguing over me leaving to go to my sister's. Told the boys we were going to be talking about a lot of things. She didn't know how much arguing or yelling Todd was going to want to do. Just asked them if they would just go, and I would let Dad know that they were going. They didn't come up and talk to Todd because he was all angry. Todd was taking prescription meds, her sleeping pills, muscle relaxants, pain pills, a lot of things lately, and smoking pot too. Further, Todd took meds, began watching hunting. She went down and did laundry, folded laundry, and was putting Christmas ornaments in boxes, was puttering, went back up, read acne med pamphlet, dozed off, heard Todd in the basement. When she got up, he was back in the recliner, asked her for something to drink. Got him something to drink, did dishes. When she came up, made him a fire. Todd yelled at me once during the day and told me nobody else would ever have me. Now, when you came upstairs, you said you could hear him yelling, this is Shinsky, and then it turned to screaming. What was the yelling? She says, that's when he was yelling at me that nobody else would ever have me. When she came upstairs, around the corner from the stairway to the living room, there was a lot of fire between our bedroom door and his recliner. Todd was closer to the bedroom. There was just fire and a lot of smoke. There was no fire on the kitchen and dining room side. She could see Todd's legs. The chair was on fire. There was a little fire on the floor. A lot of fire over by the bedroom. She ran out the front door. She doesn't know where he came out. When he came out, he was completely covered in fire. When she came out, it was just black. She ran towards the side of the house. She saw a bunch of smoke. She ran to the van. She backed up and saw Todd, so she pulled forward real quick and jumped out to see if she could help him. He wouldn't lay down. He was trying to pull his pants and his socks off. She screamed at him to lay down. She got back in the van. She couldn't get the van back up because it's so muddy. Pulled over to try to help him. Realized she couldn't and she had to get some help. Jumped back in the van, but couldn't get back up. Usually we go down to the driveway because it's real sandy right in front of the house, and then get going real fast and get back up. But then she saw Todd laying, so she jumped out of the vehicle and she ran to him. He wasn't on fire anymore. She saw the neighbors come up. Then when I was laying on him, I was trying to keep his mouth open and keep him breathing. They pulled me away from Todd. Later, recliner was all on fire. Big bunch of fire by bedroom door in between bedroom and fireplace. Bunch of fire by the recliner. Not much fire in between. Ran up to van, parked in front. Keys were always in the vehicles. Todd does. She always brings hers in and puts in the kitchen. Todd was in the side yard. She pulled the van up real quick and jumped out. She was screaming at him to lay down. He was trying to get his pants off. She kept trying to get up and reach and grab him, his pants. He wouldn't stay still. Then he laid down. She jumped back in the van and tried to back up. She couldn't back up because it was too muddy. Couldn't see Todd when she backed up. Pulled down here because I was going to try and back up to get a running start, and she couldn't. Jumped out, ran to Todd. He was laying. She just laid on him, laid on Todd, trying to keep his airway open. She could tell he was breathing. She ran up almost to the fireplace, and fire came from our bedroom direction towards me, towards the fireplace. So it wasn't the fireplace. Her words. So it wasn't the fireplace. He could not have had fuel on him. I took him juice. I would have smelled it. Oh, since last winter was the last time we used kerosene. You think smoking's the cause of the fire? No, definitely not. We don't even own ashtrays. The kids were everything to him. This is where she begins to blame Todd. This interview greatly differs from the one that she gives Steve Willison 1 month later. Mr. Willison was the attorney hired by Farm Bureau Insurance. He conducted what's called an examination under oath of Linda Stermer. The interviews were conducted in February of 2007, 1 month after the fire, and then again in October. Many statements blame Todd for the trouble, more blame shifting. Stories are more elaborate and more dramatic. These statements also greatly differ. Let's look at the February interview. Finances were the wedge. Todd not running his business as well as he could. And she felt he should work more. He was not putting in enough effort, in debt continuously. What other issues were in the marriage, he asked. Horses. Had 49 at one time during the marriage. Said he was addicted to sleeping pills. Saw him take one the night before the fire. What was it? Ambien CR. Night before the fire, he came in the bedroom and tried to pry her legs apart and take off her pants, but she wouldn't let him. Said if he tried to make her, she'd call the police. Got home that day and began cooking and put on coffee for Todd. Told him that she used his debit card. Todd was mad, and she told him, "You knew I didn't have any money to get any of this stuff," when she got back from the gas station. "You wanted me to take care of these things, but I didn't have any money. So I used your debit card again." I spent a total of about $50 to $60 that weekend. That night, she went downstairs to the basement the night before the fire. The boys were watching TV. She laid on the couch with Trenton and fell asleep. They snuggled, because they're a snuggly family. She said she spent the night in the basement the night before the fire. That's when Willison asks, well, what about him forcing himself on you the night before? And she says, that was later, after the kids had gone to bed, and then I went up to brush my teeth. He wanted to talk some more then. I told him no, and I went back down to the basement, and I slept on the couch. She tells Willison she told the boys to call before they came home because she needed to get the blazer for them, and she didn't know where she would be. She told the boys to call her before she came home. She had to pack. She went back upstairs and gave Todd breakfast. She made plenty of food, but didn't want the boys to eat there because of the way Todd was yelling at her. Told them to leave through the basement sliding doors. Willison says, so he tries to force himself on you and then you get up and get groceries for him and make him breakfast? She says, I thought I was making for everybody. Then she goes down to the basement, she packs up Christmas ornaments, she does the dishes. She says now for the first time she begins to pack a suitcase. She went upstairs to get things out of the bedroom, and that's when she sees Corey's booklet about acne medication. She reads the booklet and falls asleep. She gets up, comes out, Todd asks for juice. She gets some juice, goes back downstairs. When I went back down, he was screaming at me again. He screamed that no one else would ever have me. And so what did she do? She slammed the door in the laundry room. She's taking the laundry out, and that's when she hears a scream, and she runs upstairs and sees the fire. She says, I saw Todd take 2 Ambien last night. After she gets juice, Todd's ranting upstairs, and then it turned into a scream of pain. She looked in the living room, she sees Todd on fire. Fire was on both sides of him, was on the floor over here to his chair. To make sure. His chair and the half wall were on fire, but not the whole half wall. His upper body was on fire. He was wearing sweatpants. I know he had socks on. I remember seeing his gray sweatpants. I just screamed and ran. I've got to get out of here. She jumped in the van to drive to the neighbors. What did you do when you got in the van and backed up? She said, I backed up straight. Where did you see Todd? And she marks the X of where she sees Todd when she first gets in the van. She's in the van and marked the X of where she sees Todd. When she sees Todd at that X, he was on fire. She was in the van facing the front door. She did not see where Todd came out. She was going to turn around, but backed up. She didn't back up very far, and that's when she saw Todd. So she pulled up and stopped the van at number 3, which I believe Mr. Willison said she originally marked this number 3, crossed it off, and then wrote the one on top. So she pulled back up after she sees Todd, stops at number 3. I drove up there real fast. I jumped out at number 3 and screamed to just lay down. He was screaming and trying to pull his clothes off. I tried to get close to him. He was jumping and moving. He wouldn't lay down. I was afraid to touch him. So she jumped back in the van, and she couldn't get it to go backwards. So I slammed it into gear, and I went forward, and I almost ran through the fence. And that's what she's marked, ladies and gentlemen, as number 4. So the fence, you recall, is on the side of the property, and I believe you have a drawing showing how many feet that fence is from the house when they did the overhead. Now she almost hits the fence. I almost ran through the fence. I thought if I could get down, because every time we've ever had a hard time anywhere in this driveway, we just come down here because it was sandy and better traction. She could floor it and get back up and get to the neighbors. She got to number 5, which was here. Number 5, so she moved to 5, so she's at the fence. moves to number 5. And that's when she decided she needed to go behind the house. Then she hurried and drove to 6, which is behind the house, and saw Todd. He was not on fire. She ran to him. He didn't have his clothes on and was badly burned. He was like pink melt. She ran to him. When she was close, she saw Mike and Connie. She was screaming, and she laid on top of him. She was laying on him because he was naked, and I didn't want him to not be able to breathe. She said, I could feel his heart beating. I could tell he was breathing, but it was hard for him. So I put my mouth on his mouth a few times, and I just tried to give him little breaths. She saw Todd's skin was melted. She threw her purse in the van while she was talking to the boys as they were leaving. She talked to them on the way out because she had turned water on in the horse tank, told them to hang on a minute, not to take off without her purse, went out the basement door with them, put purse in the van because she thought she'd be leaving in the van. The fire was not connected to the fireplace. That's February. October is a small pack. October had already received $93,000 or $96,000. What was the issue you needed to get away from? His lack of working as much as I thought he should be working, getting behind in the bills. You described pretty heavy fighting Saturday night. She says, I don't recall that it was heavy fighting. I know we argued some. Willison says, didn't he try to rape you? She says, no, he didn't rape me. He wanted to have sex. She says she was in the laundry room. Todd was screaming, no one else would ever have me. Then he let out a terrible scream. She ran around the corner of the living room. Todd was on fire. Fire went from Todd to the bedroom. Got in the car, thought she was going to the neighbors to get help. She went through the yard by the barbed wire fence. She couldn't get going and get out of that spot, so she needed to pull down the hill to where there was better traction. She saw Todd before she got to the barbed wire, pulled away from the fence a little and got stuck. When she puts Bannon forward, she knows Todd's outside. She pulled forward down to the bottom by the house, by the slider. She was going to turn around and come back up the hill, going to try to barrel back up the hill, but sees Todd. First time she saw anyone other than Todd was at the bottom of the hill, either running to Todd or still in the van. She saw Mike and Connie at the top of the hill. She remembers backing up and seeing Todd outside. Got out of the van, screaming at him to lay down. He wouldn't lay down. He was trying to take his clothes off. He wouldn't listen. So then she gets back in the van, floored it too hard. She went too far off the driveway, stopped at the bottom and didn't turn around and came back up because she saw him laying on the ground. She ran to him. She saw the neighbors there. He didn't talk, but he was moving his mouth. He was still alive. He was having a hard time breathing. She remembered breathing into him a few times. They lifted her away. That was October. There's multiple inconsistencies, some consistencies. There's many different statements that blame Todd and point to this blame shifting. The stories are more elaborate, and the statements differ from the ones given to Shinsky. You then heard from David Hayhurst. He's from the Michigan State Police Crime Lab, and he conducted the examination of the van belonging to Todd Stermer. He noted that there were several red-brown stains on the front bumper and the underside of the van. He actually took samples, L1 through L6, of 6 different locations on that van. Said started from the front and went towards the back. All of the locations were then on the driver's side, and they were all on the front-facing parts of the vehicle as he went back. He took samples from all those stains, and he determined them after testing to be human blood. You then heard from Ann Hunt, who took those samples and tested a few of them. They're in the report of which one she tested, the locations that they came from, and they matched the DNA from the DNA card taken at the autopsy of Todd Stermer. You then heard from Troy Ernst. He tested the socks, the underwear, the sweatpants, the shirt across Todd's groin area that went into the body bag. And what did he find? Those tested positive for gasoline. He also tested all of the other clothing that you heard from testimony that was placed on Todd. That was Mr. McTheney's. That was put into a separate bag. I believe Detective Maziowski talked about a clean garbage bag. He tested those items, and those are in his report, and those tested negative for the presence of gasoline. And when I asked him about would it be more likely from one of those to then transfer to the other, he said that due to the nature of the particles on the sweatpants, the socks, the sweatpants, the socks, and the underwear, and the difference in the testing that he had done, I believe he described it as lighter and heavier particles, that it would be more likely the transference would have happened in the body bag from the sweatpants, socks, and underwear to the shirt, based on his testing of those particles. He was not able to quantify how much gas was on any of these items. He could only tell us that there was gas, the presence of gas. And he also told us that there was the presence of gas in that gas can, which he also tested. You heard testimony from Detective Rout. She was the detective called to the Stermer residence that evening of the fire. And she also took statements from Linda the night of the fire. Linda talked of an argument that occurred that morning of the fire. She detailed that the argument was over finances and her using a debit card. She had the boys leave to go to the mall so they wouldn't hear arguing, and said no further arguing occurred after the boys left the house. After the boys left, she went outside to turn on water for the horses. She went into the bedroom while Todd was watching TV to read acne pamphlet. Todd was watching TV and she was going to read the acne pamphlet and fall asleep. Woke up, Todd asked her for juice, of which she brought him. She then stated that Linda went downstairs to do the laundry, let out both the dogs and the cat. Not sure where the cat was or why she remembered a cat. Straightened up a bathroom, was in a laundry room and heard Todd scream that there was a fire, ran upstairs, saw a fire in the living room and a lot of smoke, but could not see Todd. And she left the residence, got in the van, heard a boom, and saw Todd on fire on the north side of the residence. Todd was on fire trying to shed his clothes. Then she stated she lost sight of Todd and drove around the north side of the residence to the west side near the basement to either get help or get Todd into the van. Todd was on fire. He wouldn't stop moving. She denied that she ever grabbed Todd. He was burned and gasping, and she was trying to keep his mouth open. Eventually, Connie, Mike, and Dr. Musali arrived, and she stated that there was a fire going in the fireplace. Detective Tom Maziowski testified. He was also another detective called on the scene the night of the fire. He arrived at scene, he contacted other officers to get details. He observed the person of Todd Stermer. He noticed the significant burns and the lacerations to his head. He also noted that Todd's person smelled of fuel. He collected the clothing taken off of Todd, and he attended the autopsy and also collected those items. Remember, the item that Sergeant Leroy collected are the sweatpants. Detective Detective Maziowski was also present at the execution of the search warrant of the van. This was January 9th, 2 days later. He observed several possible blood stains on the driver's side of the van, consistently on the driver's side as you're going from front to back of the van. Saw no signs on the van, and you'll have the pictures of the van as well, that the van was ever stuck in the yard or that the van had become stuck. And when he looked at the tire ruts, the tire tracks, also didn't see any evidence of that. He did take a picture and saw the purse in the van that had Linda Stermer's wallet in it, her identification. He determined it to be her purse, and he found $202 in cash. Scott Leroy was the expert witness in the fire investigation. He was called in to determine the cause and the origin of fire at the Stermer residence. He collected these sweatpants that you see at Todd's ankles, as well as the socks and the underwear. He took photographs of some photographs of the Stermer residence that night, more later. And there was no examination of the house because it was still smoldering. It was the night of the fire. So he didn't go into the house due to safety concerns on January 7th. As he's removing the sweatpants, he's smelling accelerants. He went on January 8th to the Stermer residence, and that's when he took several photographs of the Stermer residence. I believe he went around the house, and you have those photos. He examined each room of the house to determine the area of origin for the fire. At the same time, he's also collected any available evidence that's relevant to determining cause or evidence of the crime as he's going around the home. And you can see the gas can that was found the next day. And it was also shown in pictures the night before. With all the data that Sergeant Leroy has, he uses it to determine the area of origin. Data of what he's found, data of what he sees, the pictures, the data of the statements made by Ms. Stermer. He uses a systematic approach to examine for evidence and determine the area of origin. He explained to you what he did, what his system was. He talked to you about burn patterns and mass loss and about how that was used in the determination. And what he determined that the area of origin was the living room. And later, this was confirmed with the additional statements of Ms. Stermer. This is where he marked the area of origin. He talked about mass loss. He talked about the roof that you still have in place. He talked about the walls still in place. And then he matched them with Ms. Stermer and what she saw. This is where Ms. Stermer saw the fire. You've got the recliner here and where she described seeing Todd Stermer when she came up the stairs. Matches his origin. He told you how he examined several different possibilities. Any causes that he felt were relevant. He used his common sense, formed his hypotheses at that Stermer residence. He considered the furnace. He ruled it out based on the mass loss, based on the burn patterns that did not support the fire starting in the furnace area in the basement. Also, that furnace is not in the area of origin. It's not in that area. Ms. Stermer didn't describe it in the basement, said she was in the basement, said she came up, and it was in the living room. considered a possible electric fire in the area of origin. He said there was no evidence that supported an electrical fire. Electrical fires typically start in the walls. The wall studs would have been completely burned away. And also, electrical fires take time to burn, time to develop. He also considered the fireplace as a cause of the fire. He looked at the burn pattern evidence, and it didn't support a chimney or a fireplace fire. He talked about how those timbers right above the fireplace and the header of raw wood above the fireplace. Those timbers around the fireplace would have completely burned if the fireplace or the chimney were the cause. When questioned and talked about the chimney chase and about how the materials would fall on top of the box, he talked about how all of that would burn. And he talked about how fire consumes everything in that little area of origin that it's working on. And then as it exhausts its fuel, it burns out and up. It would have burned everything around it before it moved. He also stated that there would have been a lot of smoke expected in a chimney fire, and that would have been probably noticed by able-bodied adults. Other possible causes were also considered and eliminated. He looked at the fuel oil lamps. They were small. They would have been a very small fire. They weren't consistent with gasoline or a description of the fire from Linda. And per Linda, the fire was not in the dining room or the kitchen, which is where those oil lamps were. He also considered a log rolling out. Talked about how there'd be a slow, smoldering fire, would not have spread quickly, and would have probably been noticed by Todd. He looked at if this was an intentionally set fire. He considered the fact that there's gasoline present in the area of origin with no explanation of why gasoline would be present there. Todd is found with gas on his sweatpants, socks, and underwear. He's on fire in the living room. Why is there gasoline there? It's a sudden fire, described as Linda. She talks about how he was yelling at her and then it immediately turned to screams. Not the description of a small, smoldering fire. She talks about the fire in between, extending from one side of the living room to the other. She talks about how it goes from the bedroom to the recliner, almost as if it's a trail of fire between the two. All of these, ladies and gentlemen, are consistent with an intentionally set fire. Common sense. Now let's look at what Cynthia DeLoach said. Cynthia DeLoach remembers January 7 of 2007 because it's a small town. She worked that day. She thought her mom's house might be on fire. They drove out there. It was a big deal in their small community. She remembers distinctly Ms. Stermer came to the Marathon gas station approximately 9 a.m. that day. She explained on the receipt the time was off by an hour. Her boss had never adjusted for the time change. She stated Linda purchased gasoline with Todd Stermer's credit card at pump 3. You can see she described the account numbers match on the receipts, which would be here and here. This is the outdoor pump and indoor pumps. And you can see then the name Todd Stermer on pump 3. She specifically remembers the fuel hose going into the back hatch of Linda's Blazer. And I think she actually described it. She said, you know, when you have the glass half and you turn the latch and you lift it up. And she specifically remembers the hose going into the back, underneath that glass hatch. Like if she was filling up a gas can. She did say, I stopped watching after that. After I saw that, I just figured she was filling up a gas can, went about her business. Didn't see then what happened. Didn't see if maybe then she did put it in her gas can or in her car. She didn't know. But she does remember clearly the hose going into the back of the vehicle. You heard from Brad Stermer, Todd's brother. He helped Todd build on several pieces of the residence. He described Todd as a physically fit and a very capable person, very capable man. Todd loved his house. In the driveway of the house, he said it was a path when they were using it, in the beginning of it, when they started it, they used it as a path for construction. But after that, Todd graded it into a yard. So after construction was done, they stopped using it, and that's when he graded it and did the final grade. Todd and Linda, he also testified, were in poor financial condition at the time, and he stated that the horses were a financial strain on the marriage. Linda told him, I'm sorry, I can't read the small print, that on January 9th, Linda told him on January 9th, 2007, Linda described to him that she was downstairs doing laundry and heard Todd yell, Linda. She ran upstairs, she did not see Todd, and she ran out of the house. When he found inconsistencies and questioned her further, that's when she said, he said, well, what about the smoke detectors? Didn't they go off? He knew that he had helped do all the hard wiring for those smoke detectors. And that's when she said, oh, we were having issues with them. Todd disconnected them. And then she didn't want to talk anymore. You heard from Mr. Chris Williams. You heard that he started an extramarital affair with Linda before the fire. About 6 months before the fire, they met at work. He talked about how she pursued him. Showed up at a parking lot one time when he was there shopping. He said he had sex with Linda about twice a week for 6 to 8 months, right in that time frame. Most encounters occurred at his house in Kalamazoo. He talked about how once they did go to see some museums or something in Grand Rapids, and they did some joyriding together, riding around in the car, but mostly it was just meeting up at his house. He said they did try to keep it quiet at work, and he knew she was married. That's why they tried to keep it quiet. He said that he saw a different side of Linda that Friday before the fire when Todd had sold a truck to purchase a van. That's when he saw a different side of her. He also testified from a question that Linda took him to the fire scene months and months later after all the debris had been removed. We don't know why, but he testified she took him there. You heard from Kathy Ill. Met Linda in 2006. After the fire, she was at the Stermer residence. She noted several school pictures of the boys stacked in frames out in the shed. Linda also told her she needed to look for a cup in the dishwasher, and she wanted to look for some rings in the house. Ms. Ill got into Linda's vehicle later, and she noted a lot of jewelry in the center console area of the vehicle. You also heard from Kate Fox. They both had kids in Lawrence schools. They started work together at ChemLink. They became best friends. They actually carpooled to work together almost every day. Linda, in those car rides, began to confide to her with problems in her marriage. She started claiming abuse. Kate testified she never saw any signs of abuse. She did tell Kate about her affair with Chris Williams and that she wanted to be with Mr. Williams. The defendant wanted to be with Mr. Williams. She said he was the best lover she had ever had. And Linda told her about wanting a divorce from Todd. Kate drove Linda to Chris Williams' house on several occasions and actually told the police where he lived. Gave them the information of how to contact him. She testified that she knew Linda had 2 phones. One was kept at her house so Todd could not find it. Sometimes it was kept under the dash of the Blazer. She also talked a lot about how the defendant would talk to Chris Williams on the car rides home. She told Kate she thought of several ways to get rid of her husband. She told Kate that she considered shooting him, and she told Kate that she considered running him over with a car. She also testified that she called the police on Thanksgiving, just 6-8 weeks before the fire, because Linda had a gun and said, "Give me one good reason why I should not shoot Todd." She called the police because she feared for Todd. She said Todd was suspicious of Linda 2 to 3 weeks before the fire because he discovered a secret post office box. She asked Kate to go and clean it out. Clean out that post office box, get everything out of it. She also told Kate that Kate said Linda told her that she ran over Todd. She said, one story, it was because it was smoky and she couldn't see Todd and she accidentally hit him. And then she said the second version is that Todd ran out in front of him and then she struck him. She also said Linda called her a few days after the fire requesting a flashlight to locate a cup in the dishwasher of the burned home that contained tranquilizers that she was planning to give to Todd. This is when she decided to have Kathy Ilg reach out to the police, and she wanted it to appear that the police were coming to her, not that she was going to them. She didn't want to walk into the police station. She didn't want to make a call. She didn't want any report saying Kate Fox called the police. She wanted it to look like the police came to her. You then heard the testimony of Dardita Gordon. Dardita is the unavailable witness. She has since passed away, since her sworn testimony. Her testimony stated that she was housed in a jail cell with Linda and that she befriended her. And Linda stated Todd was on medication. She testified to that. And she stated Linda told her she hit Todd with an object during an argument and started the fire. She didn't say what the object was. Even when pressed, she didn't say what the object was. She said it was just an object. And she stated that she started the fire with gasoline. You heard from Corey Pierce, the nephew raised as a son by Todd and Linda. You heard what happened the night before the fire. He was sleeping downstairs. He heard parents arguing about Linda cheating. He said Linda did not come downstairs that night. He did not hear his father working on the furnace, and his bedroom shared a wall with the furnace room. He says the day of the fire, he woke up to an argument between Todd and Linda about cheating. Linda came down and sat on the bed and said the boys needed to leave so that her and Todd could split up property for a divorce. Told him to take his brothers to Kalamazoo. And she told him she wanted Todd to think the boys were still home so that they would argue less. The day of the fire, Corey testified that he went upstairs, he saw Todd sitting in the living room, saw his arm, but he didn't see his face. He testified that Linda blocked one of his brothers from going to see Todd. He testified it was always common practice to give a hug and a kiss and say, "I love you," before leaving the house anytime. He specifically remembered seeing Linda's purse on the kitchen counter when he walked straight up the stairs. He said Linda told him that there were some statements about what had occurred in the fire, and those conversations usually happened in the vehicle with his brothers after the fire. He said one version, there was too much smoke when she tried to get up the stairs, and that she ran out the basement. Another version was that she ran upstairs and saw Todd on fire and ran to get help. When the brothers would question her differing events, like we talked about in voir dire, confronting with conflicting statements, that's when she would yell and become physically violent. He stated Linda coached him and his brothers on what to say prior to any interview or testimony, and said if they didn't listen, they didn't listen to her instructions, that they wouldn't receive any insurance payout to replace their things that they had lost in the fire. You heard from Trenton, the youngest, who's 12 at the time of the fire. He remembers an argument the night before. He stated Linda did not come down in the basement the night before the fire to watch TV or to cuddle with him. He said Linda did not sleep downstairs, and he did not hear Todd in the furnace room. The morning of the fire, he stated Corey woke him up, they got ready, they went up the stairs. He stated Linda blocked him from seeing Todd. It seemed like Todd was sleeping, but she shooed them out of the house. They left the residence in the black Blazer. He said that when Linda talked to them about what happened, there were differing stories. One version was she couldn't get upstairs and that she exited out the basement. One version was that if she could get upstairs and then she exited out the front door. He said Linda would attack him if he confronted her with her changing stories. He stated Linda gave him a bloody nose on one occasion when instructed his brother Trevor, the older brother, to silence him when he started questioning and pushing. Linda told him to say, "I don't remember," to certain questions during the insurance investigation. Lastly, you heard from Trevor. He said that the Stermer home was about 95% complete. They were missing some floor coverings, but he said about 95%. He said there were working smoke detectors, and he actually talked to you about how they would beep and he'd have to replace the batteries. He said Todd was meticulous about safety. He said the night before the fire, there was a very heated argument. It was the worst one he'd ever heard. He was asked to leave his brand new bedroom in that loft and go stay downstairs with his brothers because of the severity of the argument. Also had an open loft area, so probably was for the noise as well. She told him it started he's talked about why they were arguing. He said it started with finances related to Linda's horses, and then it transitioned into Linda's infidelities. He also said Linda did not stay in the basement on the couch or cuddle with any of them that night. And Todd did not come downstairs that night. He said on January 7th of 2007, he woke up at 8 a.m. He tried to go upstairs, but Linda stopped him. Remember, he was the first one to wake up. He woke up early, and he wanted to get some breakfast. And she stopped him twice from going upstairs. Said another argument broke out that morning. And I think he actually said Linda brought him down a Pop-Tart at one time. Linda asked the boys to leave the house to go to Kalamazoo to a mall and movie. He didn't want to go. He wanted to wake up his dad and make an argument of why he wanted to stay. Tried to speak with Todd twice, just hoping maybe he could just stay home. And both times, he was blocked by Linda from going to talk to his father. He said after the fire, Linda's stories changed each time. What door she exited would change. She'd get angry and attack his brothers, or direct him to attack Trenton to stop the questioning of her stories. He said Linda sheltered them from any outside information. He only knew the facts as provided by Linda. He also coached them on what to say when questioned by the insurance or police. He also remembered a duck boat. He remembers Todd having a small plastic duck boat. He said it never had a gasoline engine. It had oars that they would use. And they would take it out in the back pond to go duck hunting on the property. Told a story about how Todd let him spray paint it camouflage with the green and black paint. He also said Linda's horses were an obsession. So let's break it down by the elements. Remember, you, as the jurors, have the opportunity to look at all the evidence. All the evidence surrounding this fire and making your determination on whether this was an arson fire set by Linda Stermer. No one witness is the entire case. You get to judge all of the evidence, and it's your decision. Start out with the second element of arson. We know at the time of the building, they were living there. It was a dwelling. So I've checked the box. Let's look at the evidence that would support the other two. What's the evidence that supports arson? The defendant bought gasoline. Actually, I'm going to stop there for a moment. I'm going to read to you the definition of circumstantial evidence, not in entirety. You'll have the entirety when you go back. Circumstantial evidence is evidence that normally or reasonably leads to other facts. Common sense. The defendant buys gasoline the morning of the fire. She's observed by Cynthia Deloach to have the hose in the rear of her hatch. The only reason would be to be filling a gas can. She's certainly not pumping it into the interior of the car. There's a small 1-gallon gas can found in front of the Stermer residence at the fire. There's no explicable reason for this can to be in this location. You saw a picture of all the gas cans neatly stacked in the shed. All of them, except for this 1 gallon. You heard the testimony about the huge tractor and how they wouldn't use a 1 gallon to fill up the tractor in the backyard. Gasoline is found on Todd's sweatpants, his underwear, and his socks. What leads to a logical progression? Then you can look at Linda's misdirection as evidence of an arson. In any detailed statement, she attempts to redirect towards the fuel oil furnace. She consistently mentions Todd bleeding the furnace the night before the fire. There's no evidence that supports this. As if she's redirecting you to think that that's why he would have fuel oil, which we know now is inconsistent. Fuel oil tests differently from gasoline. Fuel oil is chemically distinct from gasoline, and that's what you heard from the chemist. She tried to claim Todd accidentally started it with a dropped roach. There's no THC found in his system on that autopsy. It's not in his system, it's not in his blood, it's not in his urine. She describes it what we call a fire trail in the living room. She stated that it wasn't the fireplace. She detailed and described the path going from the recliner to the bedroom where Todd was. She described an excellent trail across her living room. It's like, what else? The suddenness of the fire. Todd went from yelling at her to immediately screaming in pain. You also heard witnesses talking about how within minutes of getting there, it just started to it was consumed. They were watching how it just started breaking through. I think Musali's, Matheny's, Thompson's, everybody was talking about how quickly it just was being consumed. This implies that it happened quickly from her statements. 1 minute it's not there, the next minute he's yelling in pain. Now that also we can look at the fact that she ran Todd over as evidence of an arson. He's the only witness to the crime other than her. And after Linda, sorry, your type is very small. After Linda realized he escapes, his survival would have left Todd as a possible witness. And she needed to silence that witness. You can also look at supporting arson, that she's laying on Todd, because that supports her intent to silence him. She laid on a man whose skin is sloughing off. They tried to carry him away and they couldn't because his skin was coming off and they had to put him in the boat to move him. She laid on a badly burned man who she described as pink melt and talked about how he was struggling to breathe. Why would you lay on a person with that severe injury and who's struggling to breathe? She had to forcibly be removed from him as they're trying to render aid 2 times. This can all be considered as part of the arson. You can also consider that she let the dogs out moments before the fire erupted. She didn't want her dogs to be killed in the fire. You can also consider that there were framed pictures of her children that were moved to a shed on the property. Precious keepsakes were spared, things that can't be replaced. The boys, pictures, the dogs. She didn't have to worry about the horses, they were outside. You as jurors can take the totality of all the evidence presented, all of the evidence presented, supporting that Linda intentionally set that fire. The element, the defendant burned the building. We believe we've given you the evidence. We believe that we've given you everything you need to make that common sense approach. What makes sense and leads to the conclusion? The conclusion is that the defendant burned that building, it was a dwelling, and that she intended to burn it. So
All right. So, oh, hello, Susie. You summon Rubber and she's here. See, she's very good trained. So I am gonna stop the closings right there. I am sorry that probably is a cliffhanger, probably not. She's been going on for a very long time, but it's almost Lori safe. Lori safe. Lori time. Because feeds are starting to kick in. There's no trial going on. I am just waiting on one feed that I really want to use it, but it's not live yet, so we are just waiting on which one is I'm gonna use. So do not worry, we are not gonna lose a second of it, of the Lori Vallow. So right away, breaking news: KR trial, Karen Ridge trial has a jury selected. Trial is gonna start Thursday for her. So that is the latest news on her. So we'll see. Case one, I think we'll see. So definitely is Lori time. There's already a lot going on already at the moment. Oh, no worries, big news. I know there are some KR people out here that want to see the trial and everything, so I definitely want to keep everyone updated. So I am so sorry. I am not feeling the greatest right now. The onion is definitely not agreeing with me. It's having a big massive fight within myself. Rules going forward today. Do not worry. Do not push. Yeah, definitely. We're not gonna be pushing buttons. We are not gonna be doing nothing. So what else? Yeah. No gas holes in washers. Yes, definitely not. So if it has not started, I am. Oh my days! I just hope I feel better soon. The thing is, I'm sorry, TMI, too much information coming. I just need to let go of my dinner and then I'll be fine. But it's just up until that point. So, we don't have thumbs, but we have something similar. Probably I'm gonna have to. And no all caps. Yes, indeed. So this is now an educational channel, and I have to change my voice for that. Sorry, just saw a notification that's actually interested me, but I need to check that out. I've got towels. Yes, I've got plenty of towels and a bowl. So feed is still not kicking in. I am checking. We still have 2 minutes anyway, so we all are all good. That one is live. That one has the seal, but it has. The thing is, I don't like some one of the feeds, but they are a bit ahead, so I want that one. Yeah, it's like, everyone please wait. Okay, we're gonna have to use this one. We're gonna have to, because they're starting. Oh, court hasn't started, guys, so let me just do one thing very, 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 very quick. I promise to be very quick. There we go. There we go. It's done. I'm done. I'm done. I'm done. I'm done. Don't kill me. There we go. Oh yeah, I forgot. It did start with the sidebars, so I need to already put one on a counter. We have our counter back today. Yay! So anyone? No, there is. Is there a verdict, Nancy? Or was there a verdict? Did he come back with it? Oh no, not back yet. I was gonna say because I have that one on my phone and I haven't seen anything. But now I have to put Miss Stermer on my phone, so I know when they start deliberations eventually. So okay, all right, not the problem.
All right, we're on the record. State of Arizona versus Lori Daybell, CR 2021-001704. For planning purposes, Judge Kemp, who does his morning calendar in this courtroom, is dark on Monday and Tuesday. Do the parties, council, advisory council, does anyone have an issue starting at 10 a.m. on Monday and Tuesday?
No, Your Honor.
Advisory council?
Monday and Tuesday at just 10?
Yeah.
Yeah, no problem.
Okay, so for advising your witnesses, we'll plan on starting at 10 a.m. on Monday and Tuesday. Is there anything we need to discuss before the jury comes in?
Not that I'm aware of, Your Honor.
All right. Do you want to? All right, we're ready for the jury. Okay. While we're waiting for those jurors, can I have everyone come up to the bench? And I just want to discuss off the record potential scheduling for the second trial.
And that's another sidebar already for today. So don't forget, so Monday, Tuesday, that's what he was saying. Court will start at 1:30 p.m. Eastern, 2 p.m. Hang on. Yes, so they're going to start at 10 a.m. with a half an hour, which is 1 p.m. for Eastern. No, hang on, I don't know. Help. I don't know. I'm confusing myself. So if they start at 10 a.m., that's one. Huh? I don't know. Help.
6 p.m.
12:30 Eastern. So it's 10 a.m. Arizona time. I need Google. Google, friend, come back. I thought that was, my brain is all smushed right now. So 10 a.m. Arizona to EST. 1. Yes. Thank you very much. 1 p.m. Eastern, and that's what Google said. Thank you very much, Nancy. Thank you, Zizzy, as well. I appreciate you, girl. You are amazing. Thank you. So, court on Monday and Tuesday is going to start at 1:30 p.m. Oh, no, you good. You good. You're amazing anyway, so it's fine. Thank you very much. Court Monday and Tuesday is going to start at 1:30 p.m. Eastern, so half an hour earlier than we have been. Yeah, I'll figure out at what time we'll go live, but I've already written on my book, so when I'm setting up the streams for Monday, I know what I'm doing. No, you were amazing, period. Don't even say anything else. Yeah, low as me either. I was fine earlier, but I'm still feeling a little bit sicky. I think I'm improving, but I think I still want to, you know, on so do I. A lot of the time, so do I. But no, Arizona is um PSD or something. So it is something. Oh, nice. Oh, Nancy, that is so nice. They live in Arizona. Hey, guess who's in the house? Hello, Garden Bot. Hi, love. Hello. Hello. He's just over there, so yeah. No, Zizi, you are amazing. Hey, Garden Bot is here. Who is ready for the craziness of trial? Who is ready? Oh, did I retract my message? Oh, weird. Oh well, I guess I'm gonna pin my own message and I retract. I don't know. Yeah, for sure, Lois, definitely. Oh, sorry about that. That's just like emojis, Zizzy. Like it's a heart one. So William, I like that. It's a robot and a wave thing. So
Jury.
oh, here we go. Oh, that's so nice. Yeah, Nancy, definitely. You chilling with a blanket. Nice one, Garden, but you definitely need a blanket. You've been working hard today. And taking care of the cousins too. Guys, you know the prosecutor in Linda, she's still going. So oh, I need to make sure it's Denise here. Denise, make yourself present. Uh joking. Are you okay? Are you here? We're
The
about to
jury is
start.
present. The state can call its next witness.
Thank you, if I may go get it.
Well, apparently this next witness has a long to walk. Oh, it's way better, Nancy. Thank
Sir,
you.
come on up.
I'll reply in chat.
You're gonna stand right here and be sworn in.
Please spell your name for the record. Please raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, you're gonna walk around the court reporter here. Have a seat to my left.
Sir, would you please introduce yourself to the jury?
My name is Adam Cox.
How old are you, Adam?
I just turned 56.
And what do you currently do for a living or for life?
I'm a pro pickleball player and instructor.
Where are you living now? Just what state?
I live in Arizona.
Back in July of 2019, where were you living?
Wichita, Kansas.
Prior to your pickleball career, did you have a different career?
I did.
What was that?
I was a radio morning show host.
Is that why you were in Wichita?
Yes.
Did that make you travel a lot?
Yes.
So I want to talk to you about your family first, okay?
Okay.
Where did you grow up?
Grew up in Southern California.
Okay. Do you have any siblings?
Yes.
How many?
5. Or
And-
4 siblings.
Can you tell us the names of the 5 siblings you had growing up?
Stacy, Alex, Lori, and Summer.
For Alex, did people refer to him as Al sometimes? Were your sisters Lori and Summer close?
Yes.
I want to ask you about another family member. Back in 2019, Melanie Boudreau. How is she related to your family?
Melanie is my oldest sister, Stacy's daughter, so she's my niece.
And was your sister Lori close with Melanie?
Yes.
Do you see your sister Lori in the courtroom today?
Yes.
Can you point her out and tell us what she's wearing?
She's sitting there wearing black blazer.
And may the record reflect the witnesses identified the defendant.
Good job.
In July of 2019, was your sister married?
Yes.
Who was she married to?
Charles Vallow.
And so in July of 2019, was your sister known as Lori Vallow?
Yes.
Do you know approximately how long Lori and Charles were married?
I think over 10 years.
Okay. Do you know if your sister, since the passing of Charles, married Chad Daybell?
Yes.
Did Lori, your sister Lori, have any children from prior marriages before she and Charles got together?
Yes.
And who were those?
Colby and Tylee.
Okay. And were they from the same marriage?
No.
By July of 2019, was Colby an adult?
Yes.
Do you have a son? Zach?
Yes.
Did your son Zach ever live with Lori and Charles for a bit?
Yes.
Did he move in there after Colby moved out?
Yes.
In July of 2019, was Lori's other daughter, Tylee, still under the age of 18?
Yes.
Do you know whether or not Charles helped raise Colby and Tylee?
Yes.
Did you know if Charles had any children from prior marriage?
Yes.
Do you know if do you know how many children he had from a prior marriage?
I think 2.
Okay. And do you know if either of those 2 children lived with Lori or Charles?
Visited. I don't know if they ever lived there.
Okay. Did Lori and Charles have any kids together?
JJ?
Was JJ adopted? Okay. So did they adopt him together?
Yes.
Okay. So in 2019, did Lori and Charles have just JJ and Tylee as their kids living with them?
Yes.
Did Lori and Charles always live in Arizona?
No.
Where else did you know them to live?
Texas and Hawaii.
Okay. We had talked about your brother Alex, or Al. Were you close with your brother Alex?
Somewhat.
Do you know where Alex was living in July of 2019? What state?
Arizona.
And can you describe your brother Alex's relationship with your sister Lori? Were they close?
I mean, I don't know if close is the word I would use growing up, but
Describe
just
for us.
normal brother-sister relationship, I guess.
As they became adults, did they continue to be close, or what do you recall of their relationship?
Yeah, over the last, I guess 4 or 5 years.
The last 4 or 5 years between them was what?
They were closer, they were close for like a year and a half, is what I remember.
Before this happened?
Yeah, they became oddly close for a while.
How about the relationship between Charles and Alex? Do you recall what that was like?
Just a normal brother-in-law relationship, I guess.
Did you ever know them to do things just the 2 of them?
No, I don't have any knowledge of that.
Did your family sort of do a lot of big family events where everyone might be together?
Yes, yeah,
Birthday meals, holidays.
yes.
Adam, did you grow up a member of the Church of Jesus Christ of Latter-day Saints?
Yes,
And are you still a member of that?
yes.
At some point, was your brother Alex excommunicated?
Yes.
Do you recall when that was?
I think he was excommunicated twice. So I'm not sure the dates or when that happened, but when he was an adult.
In 2019, was he still excommunicated to your knowledge?
Yes.
What does that mean to be excommunicated?
It means that you do certain things to where the church, it takes away your membership from the church.
Are you able to go to temple if you're excommunicated?
No.
Is that important?
Going to the church in our faith is important, yes.
Let's talk about your relationship with Charles Vallow. Did you and Charles ever text?
Yes,
Did you and Charles ever talk on the phone?
yes.
When Lori and Charles were married, were you aware that Charles would pay for things for the family, like cell phones?
Yeah, I heard that there's people in our family that they're on his business cell plan.
Or car insurance?
Don't know about car insurance, but
You knew about the cell phones.
yeah.
Did you know what Charles did for a living?
Yes.
What was it?
He sold insurance.
Okay. Did you know what kind of insurance?
No, he explained it one time, but he was doing something with school teachers or helping them with their situation.
Okay. Did you know whether or not Charles traveled a lot for work?
Yes.
Was he traveling to other states?
Yes.
And was that sort of throughout his marriage with Lori?
Yes.
Okay. Were you aware of whether or not your sister Lori worked prior to marrying Charles?
Yes.
Do you know what kind of work she did?
She was a hairstylist.
Okay. After she married Charles, did she continue to work outside the home?
At a hair salon?
Yeah.
No, not that I know of.
Was it your understanding Charles worked so she could take care of the children?
Yeah, for the most part, yeah.
So you were unaware of her doing any sort of outside work like she had done prior to being married to him?
Yeah, I don't know any of that.
At some point, did you learn or become aware of the fact that Lori and Charles were having some marital problems?
Yes.
Just yes or no, did you ever talk to Charles about why he and Lori were having marital problems?
Yes.
You yourself personally, were you aware of Lori having any beliefs that were outside of what is accepted by the LDS religion?
Yes.
Can you tell us what you were aware of that you knew to be outside the LDS religion?
Lori told me that she was in the process of translating from a mortal human being to an immortal human being, a celestial state.
That's something that the LDS religion supports?
I haven't heard of it that it's happened here on Earth yet.
Did you ever hear her talking about being married to someone that is relevant in your religion?
Yes, I have heard that.
Did she tell that to you?
I don't know. I can't recall her telling me that, but I remember other people telling me that.
Okay. Was there anything else that you recall her telling you that she believed that seemed outside the LDS religion?
Yes. There was a time where she told me that she had more priesthood authority than the priesthood.
And why Can you explain for us what that means, why that was significant to you?
In our religion, the men hold the priesthood, and she said that she's in a state where she's above that.
Okay.
I didn't quite understand it, but very strange.
Did you confront her about these beliefs?
Confront her? No.
Did you discuss with her about these beliefs?
I just let her say what she wanted to say.
Was there ever a conversation where, when she was telling you these things, where she asked if you thought she was crazy?
Yes.
And how did you respond to that?
I said, I don't know if you're crazy, but what you're telling me is not true. It's not real.
After you said that, what happened to your relationship with Lori?
She stopped talking to me.
Were you ever aware of Lori believing that people could be dark or possessed by evil spirits?
I later have learned that, yes.
Did you ever try to tell your family about the beliefs that Lori had expressed to you?
Yes.
What was your family's reaction?
One of the reaction was, she's in a delusion, let her do whatever she's doing and she'll come out of it at some point.
How did this impact your relationship with your family when you're bringing up these concerns about Lori?
They basically cut me off.
So you bringing up your concerns about Lori's beliefs being at odds with the LDS religion sort of terminated your good relationship with your family?
Yes.
At the end of June of 2019, do you recall Charles sending you some emails that were purportedly written by him asking Chad Daybell to come out to Arizona and write a book for him?
Yes.
And did you, without going into it, did you review that email?
Yes.
Did you know Charles, what he had done in his life prior to selling insurance?
Yeah, I know that he played minor league baseball.
And in this email was the person pretending to be Charles asking about writing a book about his career?
Yes.
Was that something you knew Charles was not interested in?
No, he's not, or wasn't.
After you saw those emails that Charles had forwarded to you, where someone was reaching out to Chad, were they inviting Chad out to Arizona?
Yes.
After reading that and getting that forward and talking with Charles, did you believe that Lori was having an affair with Chad Daybell?
Yes.
Did you and Charles spend time talking about that?
Yes.
Was he kind of, I guess, in a tailspin? I'm not sure the best words to say from learning that.
Yeah, he seemed a little desperate.
Did Charles have some idea on how he thought he might be able to get Lori back into the LDS faith?
Yes.
What did you understand that to be?
Charles just thought that Lori was going overboard and that she was going to the temple like 5 times a week, and that's not normal in our religion, and that she was going a little off the wall. So he figured that if she got her temple recommend taken away from her, that she would come back to normal, who she was before she started in all this things that she was believing.
Now, you told us that you had heard yourself some ideas by Lori that were outside the LDS religion. Did Charles also tell you about other things that she had told him?
Yes.
Okay. And so Did you talk with Charles about something that we'll term an intervention?
Yes.
What did you mean by an intervention?
Intervention means Charles he's kind of desperate because nobody in our family would talk to him. I'm sure that, Lori had told people in our family not to talk to him. So he thought that, having an intervention would be getting in front of her, recording her, giving it to the stake president, or having the stake president hear what she was talking about and hear the crazy things that she was saying.
So the intervention was part of the way to try to get her to come back to the mainstream LDS beliefs.
Yes.
Did Charles ask you to help him with this intervention?
Yes, he did.
Did you guys have a specific plan, like on X date at X time, we're going to do this?
No.
Had you talked to Charles about potentially going to Lori's and recording her on your phone?
Yes.
Did you talk to Charles and text him about another idea of having a family dinner and again, recording her so that you could play that for the stake president?
Yes.
We're using a term there, stake president. Who is that? What is that in your religion?
Well, in our religion, we have our churches organized to where we have wards, and then a bigger, like 4 or 5 wards that are in a stake, and then there's a president of the stake, and so it's somebody who's in charge of everybody in the stake.
Okay. So someone that's pretty high up in the church.
Yes, yeah.
And so the idea was to bring any of these recordings to show she's saying these things to his attention.
Yes.
And again, the point of that whole was to just try to take away her temple recommend.
Yes.
So on July 9th of 2019, did Charles talk to you about him flying you out so that you can help him with this intervention?
Yes, he did.
And did he offer to purchase your flight
Yes.
to bring you to Arizona?
Yes.
At that time, did your parents live here in Arizona?
Yes, they did.
At that time, was Lori here in Arizona?
Yes, she was.
And you told us your brother Alex was living here as well at that time?
Yes.
Was your sister Summer also living here at that time?
Yes.
And after Charles purchased your tickets, did you reach out to anyone in your family to ask if you could stay with them?
Yes.
Who did you reach out to?
Alex, my brother.
And did he offer to let you stay with him?
Yes, he did.
Were you supposed to fly in on the next day, July 10th?
Yes.
So your understanding was when you flew in on the 10th, you'd reach out to Alex and you'd spend the night there?
Yes.
Did you end up staying with him?
No, I did not.
So when you landed in Phoenix on July 10th of 2019, do you recall what time of the day it was approximately?
Sometime around lunch.
Okay. And did you reach out to Alex?
Yes, I texted him as soon as I landed.
Did you get a text response back?
No, I did not.
Was that unusual?
Yes.
So he's expecting you, right?
Yes.
Did you try calling him?
Yes, I did.
Did he answer your phone?
No, he did not.
Again, was that unusual to you?
Yes.
Did you think anything was odd at that time?
Yeah, at first I was like, he can't be that busy. He knows I'm coming.
Did Alex ever respond to you on the 10th?
No.
So he ghosted you.
Yes.
What did you think when you didn't hear back from Alex?
I just thought it was very strange and bizarre.
Okay. So you were supposed to be staying at Alex's. When you talked to him on the 9th, did Alex ever text you between when you guys talked and when you landed saying, oh, I'm going to go stay at Lori's?
No.
Did Alex ever call or text you and tell you You know, I can't have you stay with me. I know I initially said okay, but not anymore.
No.
So we just ignored you.
Yes.
Where'd you end up staying?
My mom and dad's house.
Okay. On July 10th, did you understand Charles was also flying into Phoenix?
Yes.
Did you see Charles on the 10th?
No, I did not.
Did you see your sister Lori on the 10th?
No, I did not.
So you told us you stayed with your parents. What did you do on the 10th?
They picked me up and we went to lunch. And then we just, I think, hung out at the house.
And you said your son Zach lived here at the time?
Yes.
Who was he living with at that time?
I think he was living with my mom and dad.
Okay. So although you didn't talk with Charles on the 10th, did you have an understanding of what he was going to do the morning of the 11th?
Yes.
What was that?
He was going to go pick up JJ, his son. It was his turn to, I guess, have him for a few days or whatever.
Were Charles and JJ really close?
Yes.
So the morning of July 11th, you were not expecting to get together with Charles at 7 in the morning, right?
No.
Did you get a text message from Charles?
Yes, I did.
And did you learn where Alex was?
Yes, I did.
Where did you learn Alex was?
Alex was at Lori's house.
When you learned this, was Charles texting you sort of in real time as he is coming to the house,
Yes.
explaining to you what he's seeing and what's going on?
Yes.
And are you responding back to him?
Yes.
So you're at your mom and dad's house when you start getting these text messages from Charles?
Yes.
When you learned that Alex was at your sister's, what were you thinking?
I just thought something weird is happening because he never answered my text the whole day I was there, never returned a call. And then all of a sudden he said he's at Lori's house. And I didn't even know what to think at that point. I thought something was off.
So immediately you knew something was off.
Yeah.
From the prior day where Alex ghosted you to now he's at your sister's that morning when Charles was going over to pick up JJ.
Yes.
Were you concerned that Alex was at your sister's house?
A little concerning, yes.
Have you seen text messages that you and your brother-in-law Charles had sort of making the flight reservations and leading up to the morning of the 11th?
Yes.
And were those all messages that you two had as you're trying to figure out how to have this intervention?
Yes.
And then ultimately, what you are seeing and saying that morning at 7:30 in the morning?
Yes.
And I've shown defendant exhibit 210, if I can have a paralegal approach with that. Adam, if you can take a look at those and let me know if you recognize those as text messages that you had with Charles, sort of the 9th, 10th, and 11th, as you are interacting leading up to that morning and including the morning of the 11th.
Yes.
Your Honor, the state will move to admit Exhibit 210 pursuant to 8031 as present
objection?
sense impressions.
Yes, Your Honor, we object in lieu of that is a report and not the full extraction.
All right, well, may I see that particular objection wouldn't prohibit admission, it would go toward weight, but give me a second here. All right. I'll admit 210.
And if I may publish it then, Your Honor. And if I could have the elbow, thank you. Adam, I'm going to start sort of going back to, in Exhibit 210, the conversations that you and Charles were having as you're trying to come up with a way to have this intervention, all right? So you learned that Charles was reaching out. Well, let me ask you this. You had learned from Charles about this fictitious email, correct?
Yes.
Did you learn that Charles had reached out to Lori about it?
One more time?
Did you learn that Charles had reached out to Lori about this email?
Yes.
Did you learn that he had reached out to Chad Daybell's wife about it?
I think I remember that.
These are text messages. Were you also receiving emails from Charles?
Yes.
Does this sort of array of messages start to involve where you and Charles are talking about having you come out to Arizona to help with this intervention?
Yes.
And so do we see on the 9th, you letting him know that you could fly out tomorrow and come home Saturday or Sunday?
Yes.
Do we see, as you continued on, he tells you that he could fly you in on Southwest, and he's telling you he's just right now landing in LA, right?
Yes.
And you knew he traveled a lot for work.
Yes.
When we get to the 9th at 9:11 a.m., did you get a message from Charles about how you were going to get everyone together without Lori knowing that you're going to have this intervention?
Yes.
And is that one of the ideas where you indicated that I'll go see Lori at her house and have a talk with her and keep your phone on record?
Yes.
So that was sort of one idea of a potential way to show the stake president that she was having these ideas outside the LDS faith?
Yes.
Does Charles kind of tell you he's not sure that that's really going to work?
Yeah.
He says, I think she'll leave, but it's worth a try.
Yeah.
Did you then suggest also have a family dinner with everyone? And then say, always leave my phone on to record what I say and what everyone else says?
Yes.
And then you go on to say that's to have proof for Holmes. Who's Holmes?
President Holmes, he was our stake president, or their stake president.
You were in Wichita, but he was the stake president here.
I lived here before and he was in my ward, so I know him.
So when you're talking about the stake president, Holmes is who it actually is?
Yes.
Okay. On the 9th, Does Charles tell you that, got it, but honestly, if you, Zach, Brandon, and me go to him, that should be enough? She will feel like we ambushed her, but something has to be done. She'll be real careful what she says. Had you brought Brandon into this yet? Like, did you have a plan to have him come with you?
No, but Brandon played basketball with us on that night. So me and Zach and Brandon played basketball where President Holmes played basketball at a church. So that was that reference.
Okay. So you thought if we go to the church, Brandon will be there and he can help you
Yeah,
talk about
say
this.
that, yeah.
Okay. But Brandon's not part of this conversation right here, right?
No,
Then does it kind of go back to Charles asking for your information so he can make your flight reservations?
yes.
Okay. Then at 1:13 PM, does Charles let you know that your flights are booked and that he emailed that to you?
Mm-hmm.
And then does he go on to say, I'm really uneasy about how she will respond, not only to you, but to me and Zach and Brandon? Right?
Yes.
In talking with Charles and this intervention, was there a constant concern of how she would respond to trying to take away her temple recommend?
Yes.
Was some of that based upon your understanding of the things she had said to Charles in the past?
That and others. Apparently Lori was flighty. When Charles tried to serve her divorce papers, she disappeared and nobody knew where she was. So in Charles's mind that she could be flighty and just take off again where nobody would know where she is. So there was some definite reference to that as well.
Okay. Then it goes on to say, I'll pick up JJ and take him to school. So you knew what he was doing that next morning, right?
Yes.
And you said she'll be there, right?
Yes.
Friday the same. So you knew his idea was he was going to be with his son in the mornings, Thursday and Friday?
Yes.
And then you said she'll be highly suspicious about recording. If you can bring a second device and put your phone on the counter or turn it off, it might help. Is that sort of the same idea that he was unsure that she would trust you showing up there and trying to ask her about those things?
Yes, this was all just it seemed like Charles was just desperate and he wanted to do anything he could this last ditch effort to try to shake Lori loose of whatever she was under, some spell that he said. So, that's basically what happened.
And then does he go on again to talk about that he really thinks the only thing that's going to break her out of this is going to Holmes?
Yeah. Yes.
And that she's hurting too many families and that he's upset his is gone.
Yes.
Does he say that he still loves her?
Yes.
And does he think that she's basically potentially gone forever?
Yes.
And then we see that he corrected slots to Lori, right?
Yes.
Typo?
Yes. Lots of typos.
On July 10th at 3:34, do you get a text from Charles asking if you're in Phoenix?
Yes.
And do you respond, yes, you're going to Summers, and that you'll call him?
Yes.
And then does Charles let you know he's got a meeting, but he'll try to call you before he goes to see Lo? Who is Lo?
Lo is Lori.
So people would call her Lo or Lolo?
Mm-hmm. Yes.
Do you remember if you talked to Charles on the 10th?
On the 10th? What day was that?
The day before. So when you flew in, did you ever talk to Charles?
No, I don't remember talking to him then.
So even though you guys had attempted to call, you don't recall if you ever spoke with him that evening or afternoon.
Right.
So at this point, you'd said you went to Summers in the text messages, and then later you stayed at your parents' for the night.
Yes.
And then you knew that Charles would be going to pick up his son the next morning. Did you assume that you and Charles would meet up or talk sometimes later that day?
I figured so.
Okay, but you had no scheduled timeline for
Nothing
that?
planned.
Okay. So next, in Exhibit 210, we see text messages from July 11th of 2019 at 7:35 a.m., where Charles texted you, "Al is here." And then just a couple seconds later, he said, "At Lori's." Was this shocking to you?
Yes.
And what did you respond back? Did you say, "Really, I wonder why he never called me back"?
Yes.
And then we see that you wrote at 7:36 and 28 seconds, "They are planning something." Why did you write that?
Because Alex not answering his phone the whole day and me calling him and texting him, not knowing where he's at. Nobody in my family said they heard from him or knew where he was. All that is very suspicious to me. And then Alex being at Lori's house that morning felt like something was really off.
So when you told Charles they're planning something, Charles responded back, "Absolutely." Did you then let him know that you were supposed to spend the night at Alex's house? She probably blocked that.
Yes.
Did Charles respond to you, "What you do is up to you"?
Yes.
So were you kind of upset at your brother for telling you you could stay with him and then ghosting you, ignoring you?
Yes.
Were you upset at him for being at Lori's house when Charles was going there just to pick up JJ?
Yes.
Did you then text him, "I'm going to put the pressure on to have him come get me right now, see what he says"?
Yes.
Did you in fact text your brother?
Yes.
Did he respond back?
No.
As we're going along here, we see that each of these are being read sort of in this short period of time, these couple minutes that Charles is here as he's driving in. After you texted Charles about putting the pressure on to have him come get me right now, did you then say okay to Charles?
Yes.
And then we see again that at 7:49:34 a.m., you texted Charles, "Me and Zach are going to the Stake Center tonight at 8 to play basketball. Holmes is always there, either playing ball or interviewing people. I will try to catch him and have a conversation with my old friend."
Yes.
What was that about?
That was just part of the plan that Charles initially came up with to somehow get in front of the stake president. That night, he's the stake president. He interviews people for Temple Recommends and also plays basketball afterwards. So that was just a thought of maybe this could be something that we could do to help with that situation.
Okay. Now, up until 7:37 you had been interacting with Charles, right? You would respond and you were getting some text messages back from him.
Yes.
We see after 7:37 where he texts you, "What you do is up to you," that he didn't respond back to any of your other comments, right?
Right.
So when you sent him at 7:37 and 29 seconds that you're going to put the pressure on him, you meant Al?
Yes, Alex.
to come get you, Charles didn't respond to that?
No.
And in fact, it shows that that message was read at 12:13 PM versus the earlier messages that were read sort of right in time.
Mm-hmm.
Is that yes?
Yes.
And when you told Charles that you and Zach were going to go to the stake center to play basketball and see if you could find homes, did you get a response from Charles?
No.
And again, we see that that was read at 12:13, correct?
Yes.
Did you go talk with Holmes that night?
I went to go play basketball, but he wasn't there.
Was it just you and Zach?
Yes.
During the day of July 11th, at any time, did you learn that Charles Vallow had been shot?
No.
So Lori did not call you and tell you that Charles had been shot?
No.
Alex didn't call you to tell you that he'd shot your brother-in-law?
No.
Anyone in your family talked to you about it?
Nope.
How about the next day, Friday, July 11th? Did Lori tell you Charles had been shot?
No.
Alex contact you to tell you that he'd shot Charles?
No.
Anyone in your family talk to you about that?
No.
Did you decide to go visit a friend in Tucson on Saturday, the 13th now?
Yes.
What were you going down there for?
Going to see my friend Eric.
And did anyone come with you?
Yes, Zach did, my son.
Okay. When you went down there, did you talk with Eric about what's going on?
Yeah, I just thought it was really fishy that I had heard from Charles. And I didn't know if he took JJ and just was having one-on-one time with JJ. I didn't know if Lori and him were getting back together and Lori told him not to talk to me. Or my mind was spinning. Like I had no clue what was going on.
Had you talked to any of your family about it? Were you still keeping that intervention thing secret from them at that point?
No, at that point, but I think nobody had heard from, I asked if anybody had heard from Alex, and nobody said that they heard from Alex in my family. But at that point, I was there spending time with my son, Zach, also to help Charles with what he wanted to try to get an intervention with Lori, and also to see my friend Eric, because I live in Wichita, so I was trying to do 3 things at one time on my short visit.
So on the 11th or 12th, though, were you still keeping that sort of secret that you and Charles had been wanting to do an intervention on Lori?
Yes.
You weren't telling your family, like, I don't know why we're not doing this?
Charles asked me not to tell anybody.
And was that actually sort of a message you guys had talked about of who in your family might prevent any type of intervention?
Yes.
And who in your family were you guys concerned with if they learned about the intervention might try to stop it?
Mom and Dad, Summer.
Alex, too?
Alex, yes.
So even though you're here and you're seeing your family and you're seeing your son, you don't want to tell them a lot about Charles because you're trying to still keep that quiet in case he does want to go forward with it.
Exactly, yes.
So you're in Tucson and you start talking to your friend about Charles.
Yes.
Do you learn at some point that Charles has been killed?
Yes. I was talking with Eric saying something doesn't feel right. I haven't heard from Charles, and usually he would text me or send me a message or something. And then Eric asked me, he goes, well, what's his last name? And I said, Vallow. And he was on his computer and he just Googled Charles Vallow. And he said, it popped up that he's been killed by his brother-in-law.
So you learn this. What is going through your mind now?
Just everything, chaos. I had a knot in my stomach, just probably one of the worst feelings I've ever felt in my life.
Obviously, you had been concerned that something was being planned when you told Charles that on the morning of the 11th, right? But
Well,
not that.
not that, but yeah, it felt like something was off that why that Alex would be at Lori's house that morning.
Did you know your brother Alex to carry guns with him?
Yes,
Did he regularly go shooting with guns?
yes.
Prior to Charles being shot and killed, did you ever tell Lori that you were going to be trying to do this intervention with her?
No,
Prior to Charles being shot, did you ever tell Alex, hey, I'm going to stay with you, but we're trying to do an intervention with Lori?
no,
What about your parents? Did you ever tell them you were going to try to do an intervention?
no,
Your sister Summer?
no,
So if your sister told detectives a couple hours after Charles was shot that she was confronting Charles about you and Charles talking and texting, it wasn't something that you told her about.
no,
You told us that you are LDS. Have you ever taught Sunday school?
yes.
Can you tell us about the story of Nephi?
Nephi? Well, Nephi was a prophet in the Book of Mormon. It's the first chapter. He was a prophet, very humble and faithful servant of the Lord. Ironically enough, his brothers tried to kill him at one point. But he actually ended up going to Jerusalem to get these plates back, and he was run off, came back, and then went back again because the Lord asked him to. And when he did, the King Laban, who was actually a wicked king, was laying on the ground drunk in front of him, and Nephi was told to kill Laban.
Who was he told by?
The spirit, or God.
So God was using a Holy Spirit to tell him to kill Laban? And
Yes.
did he?
Yes, he did.
Was that something he anguished over?
Yes,
But ultimately, it was a justified killing.
yes,
So was the concept that it was better for Nephi to kill this one evil man and sort of benefit the nation and his descendants?
yes.
Were you aware that that your sister had told people that Charles was possessed by evil spirits?
Yes,
Were you aware that your sister had told people that your brother-in-law Charles was dark?
Objection. Calls for hearsay.
It's whether or not he was aware of it.
Whether or not
Yes or
he's
no?
aware, he can answer yes or no.
yes,
When you and Charles were talking about this intervention, were you trying to help your sister come back to mainstream LDS beliefs?
yes,
So it wasn't just Charles, but also her.
yes,
You told us that your friend had Googled and learned that Charles was killed. Did you know at that time it was by your brother Alex?
that's what the article said. So yes, he told me that.
What did you do after you learned that?
Freaked out for a little bit, cried, didn't know what to do. Thought my world was coming apart. Then I got angry a little bit and then called I think first thing I did, I called Kay, who's Charles's sister, and asked her, because she's the only one that I felt safe calling after knowing my family was involved in this or thinking of this, that I asked her if she knew that Charles was dead, and she said she just learned of it too.
Did you learn from your friend when, because it's now the 13th when you learned this, right?
Yes.
Did you learn when that happened?
Yes, I did.
So you knew on that Saturday, the 13th, that Charles had been killed that morning
Yes.
of July 11th?
Yes.
Did you ever come back to Phoenix and confront anyone in your family about this or talk to them about it?
Yes. After I talked to Kay, then I called my mom and asked her if she knew that Charles was dead. And she said yes. And I said, what's going on? And she said, you tell me what's going on. And at that point, I thought that was bizarre that she would say that. So I said, well, we need to sit down and talk. And she said, yes, we do. And so me and Zach got in the car and drove back to Phoenix.
Did you go to your mom's house?
Yes, I did.
Did that conversation go well?
No.
Did this create a break in your relationship with your mom?
Yes.
Did you stick up for Charles?
Yes.
Did sticking up for Charles create issues between you and most of your family?
Yes.
Did you continue to stick up for Charles even with that happening?
Yes.
After you had that argument with your mom, what did you do?
Me and Zach left her house and we were staying at Summer's house, my sister, who was away on vacation. And we were staying at her house and we went back to her house. We were watching her dog.
You were supposed to leave the next morning, Sunday, to go back to Wichita. Did you return back home?
Yes, we did.
Did your son go with you this time?
Yes, he did.
After this whole incident happened, did you not talk with your family for a long time?
Yes.
Did it cause a lot of friction in your family?
Yes.
Have you started to try to talk with your family some?
Yes.
I have no other questions, Your Honor.
Cross?
Mr. Cox, how long has it been since we've seen each other in person?
Don't know.
When was the last time you saw me?
I don't recall.
So, has it been a year, 2 years, 3 years, 5 years, 6
Something like
years,
that.
7 years, 8 years?
Something?
Okay, so you have no idea.
Nope.
You have no idea when the last time you saw me in person.
I don't know the year or how many years it's been.
Okay, so did you see me at Colby's wedding in January 2018?
No, I was not there.
You didn't come to Colby's wedding.
No, I did not.
So did you see me sometime that year at my house
Possibly.
where Colby got married? That house,
I did see you at that house, yes.
at least one time.
Yes.
So possibly in 2018.
Yes.
And when was the last time we had any communications?
The last time I remember our communications was you and I were speaking in the kitchen when the family was over.
Okay, so you think that was that time in 2018?
I think so.
Okay. And were we eating my green chili chicken enchiladas?
Do not remember that.
You do not remember that?
Nope.
Is that what I made every time we had a family get together, which was like 10 times a year?
I don't remember that.
Okay. And when was the last time that we had a phone call or text message
I have no idea.
Could it possibly be around that exact same time?
Possibly.
Okay. So that was possibly in early 2018?
Yes.
Okay. Who do you think initiated the final communication in our relationship?
Who concluded it?
Yeah.
I don't know.
So right now it's 2025, is that correct?
Yes.
And so we haven't spoken in about 8 years? Would that be correct?
Probably 7 or 8 years.
Okay. So would you say up until that point that how often would we communicate before that?
Before what?
Before 2018?
Probably on a regular basis. Once a month, twice a month, 3 times a month.
Like a call or a text message?
Yes.
Just keeping in touch?
Yes.
You know of us living in Hawaii and you were living in Kansas at the time?
Yes.
And in your career, you lived in lots of different places, is that correct?
Yes.
Austin,
Yes.
Dallas,
Yes.
New York,
Yes.
Wichita,
Yes.
Sacramento.
Yes.
Did I miss anything?
Others.
And I was in Texas,
Yes.
Arizona,
Yes.
Hawaii.
Yes.
So would you say that we were not physically close during the past 20 years?
Yes, I would say that.
So our communication would be solely family get-togethers, occasional text messages. Is that correct?
And phone calls, yes.
Okay. So, Mr. Cox, did you see or hear or personally witness me conspire with my brother Alex Cox to murder my husband Charles Vallow?
Repeat that again?
Okay. Did you see with your eyes or hear with your ears or personally witness me conspire with my brother Alex Cox to murder my husband Charles Vallow?
No.
Thank you. No more questions.
Redirect?
Have you talked to your sister since Charles was shot and killed?
No.
So, since that happened, you cut off all communications with her?
Yes.
Prior to that, you were being asked about 2018 being at Lori and Charles's house. Was that the time where Lori told you she was becoming a celestial being?
Yes.
And the time where she was telling you other ideas that were not in line with the LDS faith?
Yes.
After you had heard those statements by your sister, you told us that she had asked you if you thought she was crazy, right?
Yes.
And you had responded back how?
I don't know if you're crazy, but what you're telling me is not true.
After you told her that her beliefs were not true, did that sort of end your talking with her?
Yes.
You were asked if you personally saw, heard your sister Lori conspire to kill Charles. Were you there that morning?
No.
Were you the person who was supposed to, though, be with Alex on the 10th into the morning of the 11th? You spent the night with him?
If I would have spent the night with him, yes.
So that stood out to you because you had made plans with your brother, right?
Yes.
And instead, you learned he was at Lori's house.
Yes.
You told us that you thought it was odd that your brother would be over at your sister's house at 7:30 in the morning.
Yes.
And you were aware that your brother had guns.
Yes.
Charles was going there to pick up JJ, right?
Yes.
And so did it seem odd to you that your brother would bring a gun that was loaded with extra magazines that was not safe to your sister's house where JJ was?
Objection, out of scope. This is not just
Goes to the
a
conspiracy.
redirect. This is not just a redirect.
Hey, I didn't ask for argument. Okay. The objection's overruled.
What's the question?
Sure. Did it stand out to you that your brother, who knew JJ, would bring a loaded gun and extra ammunition to the house where JJ was running around?
Well,
It
I
wasn't-
didn't know at the time.
Yeah.
You're saying afterwards?
Yeah, you learned afterwards your brother killed him, right?
Yes.
So when we're talking about this conspiracy and things that are going on, did that seem odd to you that your brother would bring a loaded gun and extra ammunition in this unsafe way to a house where your, sister's son, JJ, lived?
Yeah, it seems extreme.
When you were talking to your family after this happened, did you actually tell them that you believed that Lori and Alex had conspired to kill Charles?
Yes.
Why was that?
Because Lori had told people that Charles was no longer living, that some guy named Ned was inside of his body, that there was a zombie living inside of him. And Alex didn't respond to any of my text messages when I was supposed to be with him. And he was at that house that morning. Lori talking crazy about how she's a translated being. All these things all added up into that moment and that morning. Once I found out on Saturday that Charles was shot and killed, no doubt in my mind that they killed him. That's a feeling that I got.
And you told your family that?
Yes.
No other questions?
The last line of questioning from the possession of the gun on, I think the defendant's right, was technically beyond the scope of her cross. So based on that, I'll allow the defendant, if she wants to recross on those issues, if she elects to, may do so now.
No questions, Your Honor.
All right, are there any questions from any member of the jury? Not seeing any, sir, you can step down. You can step down. Thanks. State can call its next witness.
Thank you. If I may go get her.
Go ahead. All right, you're going to come right up here. My clerk will swear you in. You're going to stand right here.
Will be the truth, the whole truth, and nothing but the truth, so help you God.
You're going to walk around the court reporter here and have a seat just to my left.
Thank you. Would you please introduce yourself to the jury?
My name is Serena Sharp.
I'm going to have you pull in a little or move the mic down a little closer to you so we can hear you. Thank you. How old are you, Serena?
How old am I? 51.
And where are you living currently? What state, what city?
Arizona, Queen Creek.
And where did you live back in 2019, 2018?
Connecticut.
Okay. When did you move to Arizona?
It was right before COVID, so 2019.
Do you recall, I know we don't have a lot of weather here, but summer, winter, fall?
Definitely summer. It was hot. I think it was end of July, August, but we closed on our house September.
Are you a member of the Church of Jesus Christ of Latter-day Saints?
Yes.
Were you raised in this church?
Yes.
Do you consider yourself a spiritual person?
Yes.
I want to talk to you about a group, Preparing the People. Have you ever attended any of their events?
Yes, two.
Can you tell us what those are?
They were conferences that helped people prepare physically and spiritually for emergency preparedness and the second coming of the Lord.
And you said you attended a couple of those conferences?
Yes.
Are they located sort of around the country?
Yes.
Did you ever attend one of those conferences here in Arizona?
I did.
Do you recall when that was?
It was November of 2018.
When you decided to come to this conference in November of 2018, did you know anyone here?
Two people, one just from over the phone conversations, Melanie Gibb and Jason Mao.
So did you have any place to stay when you came here? What was your thoughts as you're coming in for this conference?
Both of them invited me to stay at their homes.
And what was your plan? Who did you think you were going to stay with?
I thought I was going to stay with Melanie Gibb because she offered to pick me up at the airport as well, so that I didn't need to rent a car.
Did you know Arizona well?
Not at all, no.
So were you picked up by Melanie Gibb?
Yes,
And did you stay at her house?
no.
Where did you stay?
After she picked me up, she said that instead of her house, because her whole family was home and it was busy and chaotic, we were going to stay at her friend's house, whose family was gone for the weekend and had a bunch of people for the conference staying there.
Who was that?
That was Lori.
Did you know her last name, or did you learn it?
I learned it when I got there. I had never heard or had met her before.
What was her last name?
Vallow?
Okay. So you told us you didn't know Lori Vallow prior to just coming to stay at her house.
No.
Do you see her in the courtroom today?
Yes.
Can you point her out and tell us what she's wearing?
She's right there with glasses on and blonde hair and a black jacket.
Your Honor, may the record reflect the witnesses identified the defendant.
It shall.
Do you recall who else was staying at Lori's house that weekend?
There was a lot of people, and I was meeting everybody for the first time, so I don't recall everybody, but I do know Lori was there and Melanie was there.
Did you ever meet Chad Daybell?
Yes, he was there as well.
Was that the first time you met him?
Yes.
So during this event, are you going between Lori's home and to a location where the conference is at?
Correct.
Okay. And did you ever talk with Chad Daybell outside of, well, did you ever talk with him that weekend?
Yes.
Okay. Did you ever talk with him after that November 2018 conference here in Arizona?
Yes.
When else did you see or talk with him?
I saw him at another Preparing a People conference in February.
So that's 2019 now,
Yes,
after the November one.
correct.
Where was that one?
That was in Idaho.
And did you ever contemplate moving to Idaho?
Yes.
Did you ever meet with him in Idaho well, did you learn he lived there?
Yeah. When did I learn?
Did you learn that he lived in Idaho?
Yes.
And did you ever, in fact, meet with him in Idaho to kind of talk about possibly moving there?
Yes, I was actually house hunting with a realtor and in the city that he lived, so we connected for a few minutes.
What city was that?
Rexburg?
Did you know if Chad was married at that time?
Yes.
When you were staying at Lori's house in Phoenix in November of 2018, did you understand her to be married?
Yes.
At that time, did you have any idea that Lori and Chad were having an affair?
No idea.
After you met Lori at this and stayed at her house, did you have any more conversations with her, texts or phone calls?
Yes.
Were you ever invited back out to Arizona?
Yes.
When was that?
That was in March of 2019 for Girls Weekend.
What was the girls' weekend going to be?
It was a few girls coming together for a Girls Weekend, so
Whose house, where was it going to be?
that was at Zulema's house, and I think from my memory, she's the one who invited me and started that Girls Weekend idea.
Had you met Zulema before?
Yes.
Where had you met her?
I met, it's vague, but I think I met her at the first Preparing a People conference I came to, which was the November 2018 here in Arizona.
Okay. And had you talked with her as well between that November time and when you came out in March?
Yes.
Who else was part of this Girls Weekend that you recall?
It was Lori and Melanie Gibb, Zulema, Christina, Nicole, and myself. I think that's it.
Now, were all of you women members of the LDS Church?
Yes.
During this time, did Lori ever tell you things about her beliefs that seemed to go against what you understood or what you were taught through the LDS Church?
Yes.
Did Lori ever tell you that she did not need to repent?
Yes, she did.
What does repenting mean?
Repenting means turning to God and confessing our sins and repairing our relationship with him so that he can take on our sins for us and we can become better people through him and seek his forgiveness.
Do you recall what Lori told you about not needing to repent anymore?
What I remember is she's had a couple of verses in the Bible that she pulled out and read and then said, I believe something to the effect of, I believe we don't need to repent anymore.
Did that stand out to you?
Oh, yes. Yeah.
Was that
That was
concerning
shocking.
to you?
Pardon?
Was that concerning to you?
Very.
I think you just said you were shocked by it.
Yes.
It was that against your religion.
Correct.
Did she ever express to you and this group that all of you might not need to repent?
I don't remember the specifics of it. If she was trying to apply that to us or just to her, I don't remember. I just remember she said we, or generally, I don't remember the specific words she used, but that there was not a need for repentance anymore.
Do you recall, have you been interviewed by the police a couple different times?
Yes.
Do you recall being interviewed in April of 2021?
Was that was the Chandler Police
At the
Department?
police department instead of at your home? Do you recall saying to the detectives then that she said, we don't need to repent anymore. We've come to that stage. And then you were asked when she said we, was she talking about like her and Chad or all you guys? And you said she was trying to get all of us to believe that.
Mm.
You recall saying that?
I don't recall saying that, but if that's in the transcripts, that was much closer to the time when it was said. It's been a few years. I don't remember exactly what was said anymore.
So your memory back then would have been better than now?
For sure.
So if you had told the police back then that she was trying to, in fact, tell everyone that you could follow along with this belief of not repenting, you would have been truthful to the police back then?
Of course, yes.
Do you recall Lori ever talking to you about people having dark and light levels assigned to them?
Yes, I do.
And do you recall Lori ever talking about not needing to repent because she was translated?
I don't remember her using that specific word, but
What do you recall her saying with regards to that?
I remember her talking about changing physically and spiritually. Those are the two I remember.
And by changing physically, what do you recall of that?
Just being filled with more light and knowledge so that we could become closer to God.
So is that sort of the same as when we're talking about being translated?
Yes. I just don't remember her saying that specific word.
Okay, so the concept was the same,
Mhm.
whether or not she said that word, you don't recall now.
Correct.
Did Lori ever talk to you, either that weekend or prior to that, about casting?
Yes.
Do you recall if Lori was the person who brought up casting?
I believe she was, from my memory.
Do you recall if she talked to you about casting on more than one occasion?
Yes.
Now, how many times do you recall that she had brought this up?
I don't know how many times.
It was more than once?
Yes, it was more than once.
Did she ever bring it up while you were talking or Zoom talking like we used to do in the pandemic?
I never Zoom called with her. I
Did you
don't,
phone call?
phone calls. Yes.
So at least one phone call you recall
Mhm.
that she brought up casting?
But I remember one phone call. There might have been others. I just don't remember.
What, so was that phone call, to the best of your memory, before this girls' weekend in March of 2019?
From my memory, I think it was after, but
So then let's talk about the weekend of March, the girls' weekend in March of 2019.
okay.
Did Lori bring up casting there?
Yes, she did.
And the other time when Lori had talked about casting, whether it was before or after, was this to sort of cleanse society, sort of a generic, I don't want to say generic, but to try to cleanse evil from an area or a population, not a specific person?
Yes, it was like generally a cleanse or casting out evil.
Have you on your own sort of prayed to get rid of evil?
Yes, I have.
Is that sort of a personal casting that you've done, if we want to term it that way?
Yeah, I wouldn't term it that way, but yes.
Okay. Would you just term it as you're praying for the better of the world?
Praying and or casting out evil. Yes, in the name of Jesus Christ.
But you said you had never used casting as a term before.
No.
So Lori was the one using this word casting.
I don't recall her using that word. I think she was also saying casting out from my memory.
So casting out.
Mhm.
When you met up on this girls'
I'm
weekend.
sorry, was the last answer a yes?
This was the first, I guess, Lori was the one using the term casting out.
Yes.
On this March girls' weekend trip, do you recall having Lori ask everyone to help cast out as to a specific person?
Yes.
Can you tell us who that was?
It was her husband, Charles.
Had you ever met Charles before?
Vague memory, but it was a quick, I think, meet as I was leaving Arizona for the Preparing a People conference in November. I was going to the airport and I think he was coming in at the same time. Again, it was pretty chaotic.
Yeah.
But I think that's when we met very briefly.
So he was kind of coming home and you were leaving.
Yes.
Okay. Did this seem unusual to you to do this, to be asked to cast out as to a specific person?
Yes. But not. Did you say unusual?
Yeah, did it stand out to you, her asking you to cast out as to her husband?
Yes, it stood out to me.
During this weekend, did Lori talk to you about her husband, Charles Vallow, being possessed?
Yes, she did.
What do you recall about her talking about her husband being possessed?
I recall that she spoke about her husband being possessed by an evil spirit, and she named the evil spirit.
Do you recall what the name was?
Yes.
What was it?
It was Ned.
N-E-D? Ned?
N-E-D.
When you heard this, did that stand out to you as well?
Very much, yes. Very unusual.
Are you someone who questions things? Or
Yeah.
do you just go with the flow?
I question things.
So you're hearing these things from Lori that are standing out to you, some of them very against your religious beliefs. Are you starting to ask about some of these things?
Yes. I remember I was asking a lot of questions about the repentance thing she brought up. And I remember asking and talking to some of the other ladies about the casting out in a group setting before, or stuff like that.
Do you recall Lori Vallow telling you that her husband Charles was no longer Charles, that he was now this possessed person?
Yes.
When Lori was talking to you about Ned, was she explaining that this evil spirit was now in the body of her husband?
I don't know if she used those exact terms, but that was the impression I got, yes.
So the word she used expressed to you that idea that this evil spirit Ned was now in her husband's body.
Yes.
So did you ever hear Lori use the term zombie?
I did.
Is that another thing that kind of stuck out to you?
Very much.
In listening to Lori, did zombie sort of did you understand that to mean someone whose body was possessed by an evil spirit?
Well, prior to this, I had thought zombie was like a Hollywood thing, but she tried to relate the zombie and correlate that to the evil spirit that was inside of somebody.
Like her husband?
Like her husband, yes.
Did you ever start to question Lori about zombies and these evil spirits inhabiting her husband's body? Did you try to question her about that?
I don't recall specifically.
Okay. When you started questioning her, at least about repenting that you recall, did you see a difference in how you were treated?
Soon after that girls' weekend, yes.
So let's talk about the group casting. What happened? What did you guys do for this group casting for her husband, Charles?
All the ladies came together and we were all in the same room just talking. And I remember coming together. I don't remember if we were standing or sitting, but I remember Lori started and asked for this help for her husband because she needed to cast out this evil spirit. And she asked to just go around the room and each of us take turns casting out to see if we could get rid of this evil spirit within him.
Ned.
Ned.
And this was the first time you'd ever had anyone ask you to be part of some group to cast out?
Yes.
And a group to cast out a evil spirit as to a specific person?
I've never done that in a group setting before. Never even heard of that before.
After this weekend, let me ask you, how many days do you recall that you were here?
For which?
That March?
That March?
Yeah.
Just a couple days. I don't recall how many. Just a couple days, though.
Okay. So
Like a weekend, maybe?
just the weekend type of thing.
Approximately.
During that time, do you recall just the one evening where Lori had asked you and the other women to cast out this evil spirit and her husband? Was there just one incident that weekend that you recall?
One incident. I'm sorry, I don't understand the question.
Over the March Girls Weekend, was there just the one time where Lori asked the group to cast out Ned from her husband?
From my memory, yes, I think so.
Had you heard on, though, more than one occasion, Lori saying that her husband was possessed?
More than one occasion on that weekend, or like,
Or either that weekend, or had you previously heard that?
I don't recall previously hearing that. And I don't remember hearing it after how many times she said that.
Was it discussed throughout the weekend?
I believe so.
Let's go ahead and recess for lunch. We'll resume at 1:30 p.m. I'll tell the jurors to remember the admonition.
All rise for the jury. That will be 5 p.m. Eastern, so that's in about, yeah. We've got problem Batman and Batgirls. First of all, wow. Oh, yeah, JJ was live, but we still an half an hour delay. Yeah, it amazes that people can be so passive. Oh, yeah, I know. Some people are, yeah, but this imposes a problem. Court, the break is an hour and a half. Wolfgang person has been talking for more than an hour. We can zoom through it. But yep, okay, no worries. Oh, your message does not show up there, but no worries, Lois. Okay, no worries. I like that girls' weekends, Iowa. Definitely better than those weekends there. Absolutely. I agree. Okay, so do you guys want to zoom through Mr. Wolfgang's closings, because it's still going? We can zoom through that and see if we can, well, we might catch up of where it is, but we might not finish his closing, because to be fair, we even finished the prosecution closing. So any evils? I don't think so, Zizzy. I don't think there's anything. Okay, so crash. Yes, zoom. Okay. But I do need to start a new stream though, which I have one already ready. So what we're gonna do, we can do 2-speed for sure, yes. Being fast and furious for it. So what we can do is I am gonna redirect us to the new stream, which will start as soon as I am there. And then just because I need to restart a new stream because of the thing, it's as soon as this one finishes, everyone's gonna get the redirect, go to the new stream. I'll see you guys in 2 seconds over there.
And I'm a real-time crime professional.